The chair lays out SB 30 as a matter of postponed business on second reading. The clerk will read the bill.
SB 30 by Shortner relating to recovery of damages in civil actions.
The chair recognizes Dr. Bonin to explain the bill.
Thank you, Mr. Speaker. The purpose of Senate Bill 30 is to prevent Texas trial courts from refusing to admit relevant evidence about the value of healthcare services provided to injured individuals, which is a common problem today in many courtrooms. The mechanisms to achieve the bill's goals are as follows. There are two main ones. First, require trial courts to admit through an expert witness or cross-examination of a witness evidence that tends to show the value of healthcare services rendered based on amounts regularly paid for healthcare services in the marketplace by payers who do not have a stake in the lawsuit. Specifically, the following would be admissible: the Medicare allowable for each service, supply, or device, the maximum allowable reimbursement amounts from Texas workers' compensation schedules for each service, supply, or device, the 50th percentile of allowed amounts by commercial insurers in the same GeoZip as where the service, supply, or device was provided, the specific healthcare provider's billed charges related to the injured person involved in the lawsuit, and if the plaintiff elects the following indices of value by telling the other parties early in the case that they intend to rely on the following information: the specific healthcare provider's average amounts collected for each service provided to the injured person, and or the specific healthcare provider's range of contracted rates with commercial insurers. The second element is to require the plaintiff and healthcare providers to disclose relationships that bear on whether the healthcare services were billed at a legitimate rate, and require trial courts to admit some of the revealed evidence. Specifically, the things that must be revealed are: first, any letter of protection, which is defined to mean a document by which a lawyer or plaintiff promises to pay healthcare expenses in the future from a settlement or judgment. Second, any agreement by a provider to refund or rebate monies paid to the provider in relation, or paid to him in relation to services provided to the plaintiff, that is to say, a kickback agreement. Third, the identity of any healthcare provider who treated the injured person and an authorization to obtain medical records from that provider. Fourth, the name of persons who gave the plaintiff or injured person the name or contact information for a provider who treated the injured person. Fifth, the number of patients the plaintiff's lawyers referred to a provider involved in the case in the prior 2 years, and the amount of money the lawyer paid that provider. The items that are mandatorily admissible into evidence are the injured person's medical records for services, supplies, and devices that were provided to the injured person to deal with the injury caused by the event that is the subject of the lawsuit, letters of protection for any healthcare provider who will be a witness at trial or whose records will be used at trial, and the evidence about the number of referrals and amounts paid in the preceding 2 years by the lawyer to the provider. I would like to make a few comments or observations about this legislation and specifically what's not in the bill. This has been heavily discussed and worked on by many stakeholders and many members of this body. In the original version or iteration of this, there were thresholds, if you will, that would have required something called remittiture. That has been completely removed. There were specific changes to the charges or instructions given to a jury. That also has been removed. There were statutory definitions for mental pain and suffering and anguish and physical pain and suffering. Those also have been removed. Additionally, an agreement has been made that the evidence with respect to medical expenses or cost will apply to those services that have already been provided and not to future services. I also have a perfecting amendment that I would like to lay out and explain, because it will enter in many of the negotiated changes that will then become a part of this substitute.
I'll let the gentleman.
The following amendment, the clerk will read the amendment.
Amendment by Bonin.
Dr. Bonin to explain the amendment.
Thank you, Mr. Speaker. This amendment has a lot of important information, and so I'm going to take a few minutes to explain the substantive changes that are in this amendment. In this amendment, the committee substitute applied to past and future healthcare costs. The amendment changes this legislation to apply only to past healthcare costs. The committee substitute required provider invoices and statements to include industry-recognized codes for all services, supplies, and devices. There were concerns and questions about the coding of healthcare costs and whether all services a plaintiff might need to recover from an injury would have a code. This amendment limits the coding requirement to only when the healthcare service, supply, or device has a recognized code, such as a current procedural terminology code, healthcare common procedure coding system code, or evaluation and management code. There were questions about how the automatically admissible evidence about the value of the healthcare services provided to a plaintiff would be introduced into evidence. This amendment makes such evidence admissible in only two ways, either via an expert witness or through cross-examination of an adverse party's witness, but only with at least 45 days pretrial notice to the other parties in the case. In the committee substitute, the plaintiff was required to provide information about referrals to a healthcare provider, including if the plaintiff's attorney made the referral. To make sure no attorney-client privileged information is revealed, this requirement was reworked. Now the plaintiff is only required to identify the name and the contact information of the person who referred the individual to a provider, whomever that may be. In the committee substitute, the healthcare provider was required to provide an anonymized list of each patient referred by the plaintiff's attorney in the preceding 2 years, the date and the amount of each payment made to the provider in the preceding 2 years by, through, or at the direction of the attorney, and other aspects of any financial relationship between the provider and the attorney. This amendment changes this requirement and instead requires the provider to simply provide the number of patients referred from the plaintiff's attorney in the previous 2 years and the total amount paid by or on behalf of patients referred from the plaintiff's attorney in the previous 2 years. There were concerns about the language making healthcare records of the injured individual automatically admissible. Those concerns centered on the language being too broad and including unrelated matters. That language is updated to include just information about the injured individual's healthcare records to narrowly tailor the information to just medical records related to records to diagnose, alleviate, cure, treat, or heal the injured individual from the injury caused by the event. In the committee substitute, workers' compensation treatment guidelines and drug formularies were admissible as evidence related to the necessity of healthcare services. The floor amendment strikes this provision. In the committee substitute, the new law applied to any new cause of action in any case pending trial or retrial as of the effective date of the legislation. The amendment changes this so that the legislation applies only to causes of action commenced on or after the effective date, which is September the 1st of 2025. Additional changes are conforming changes or edits for clarity, and I move adoption of the amendment.
The following amendment to the amendment, the clerk will read the amendment to the amendment.
Amendment by Little.
Mr. Little to explain the amendment to the amendment.
Thank you, Mr. Speaker. Members, this is a very narrow amendment to Dr. Bonin's extensive floor amendment, and my understanding is it will be acceptable to him as the author. If I could just take a second to walk you through it. There is a category of information toward the end of this bill. You can find it in Dr. Bonin's amendment on page 3, line 10, and the purpose of Dr. Bonin's floor amendment is to require courts to admit certain medical records that are related to any given injury. The purpose of my amendment to his amendment is to insert language in front of the admission of those medical records that says, subject to redaction of matters contained therein for lack of relevance under Rule 402, Texas Rules of Evidence. Now, if I can just take a second to explain this to you, the purpose of my including this language is to ensure that courts do not admit a medical record in its entirety, including information that might not be relevant to the claim or injury at hand. For example, medical records might include statements about the claimant having a DWI or being in a domestic violence situation, or that claimant's residence address that might be in a gated neighborhood. There could be all kinds of information contained in medical records that are not relevant to the matter at hand, and that's why I am seeking to amend his amendment to exclude information that is not relevant to the jury's analysis of that injury and any damages thereto. I believe it's acceptable to the author.
Mr. Little sends up an amendment. The amendment is acceptable to the author. However, a record vote has been requested. The clerk will ring the bell. Show Mr. Leach voting aye. Show Dr. Bonin voting aye. Show Mr. Little voting aye. Show Mr. LaHood voting aye. Show Mr. Alders voting aye. Show Mr. Lozano voting aye. Mr. Verdell voting aye. Have all voted. Mrs. Weiner voting aye. Have all voted. There being 144 ayes, 1 nay, the amendment is adopted. The following amendment to the amendment, the clerk will read the amendment to the amendment.
Amendment by Moody.
The chair recognizes Speaker Moody to explain the amendment.
Thank you, Mr. Speaker and members. This runs similarly in line with what Mr. Little just spoke about, except for the amendment in front of you now is wholly contained in Section 41.015 of the bill. And so that is related to the evidence of health care expenses. And if you read that in conjunction with Chairman Bonin's amendment, this is amending, it touches that amendment in 2 places. One, on page 1, line 17. And what that would do is that it would remain the evidence would remain admissible, and the court shall admit, and except for it would limit that in 2 ways, not in any other way. So any other objection to this evidence would be inconsequential. So on hearsay grounds or character evidence grounds or any other of the evidentiary things, for those of you who went to law school, when you took rules of evidence, the number of ways that you have to get evidence to qualify to come in front of the court or in front of a jury, all of those would still be swept aside under the terms of the bill, except in 2 instances. Relevance, and that's 402, and that's what's mentioned here in the amendment that's before you, and 403. 403, is those of you who went through law school know, is a balancing test that would say this evidence is more probative than it is prejudicial. So in those 2 gatekeeping functions that a judge has today, those would remain for the evidence that would be automatically admissible under 4.015. If there's any other evidence, because I know that there has been some discussion that somehow this takes current law backwards, and I do want to mention another section of the bill to draw your attention to. 41.017 says that everything else outside of 41.015 and 41.016 is subject to the Texas Rules of Evidence as a whole, including 402 and 403. So nothing here in this amendment is going to touch current law as it pertains to any other evidence, just the evidence that is listed in 41015. It would be cabined to that evidence which is relevant and that evidence that is not more prejudicial than it is probative. The concerns that we heard when we discussed this bill in committee and then later in multiple other discussions were that in courts around courts in the state, you have relevant evidence that is being excluded by certain judges. However, the solution that's proffered in the bill is to state that irrelevant evidence could potentially be automatically admissible. So we have gone around to try and discuss how do we address the concern, but also ensure that we're not putting evidence in front of a jury that they shouldn't see. And so this is the balance that I've gotten to discuss with some of you, and I think strikes that balance where we're going to limit the ways that this could be objected to those two very narrow exceptions. It touches, like I said, touches the amendment by Dr. Bonin in two places, but it only affects 41.015, which has to do with healthcare expenses. The other place that it would put this similar language is on page 2, line 6 of the Bonin amendment.
Mr. Speaker,
Mr. Little, for what purpose?
does the gentleman yield for questions?
Will the gentleman yield for questions?
Yes, sir.
The gentleman yields.
Speaker Moody, thank you so much for working together with me to help craft this amendment. You have filed the amendment. My signature is atop yours on that amendment, along with several other people. You know, one of the concerns that I had as you and I have worked together on this bill over the course of probably dozens of hours at this point was the automatic admissibility of evidence.
Yes, sir.
And I think you'll agree with me, it is very rare in Texas civil procedure that evidence is automatically admitted under any circumstances, right?
No, that's correct. And like I said, I don't mean to kind of take it back to law school days, but when we learn about the predicate to introduce certain evidence, and I know when I was a prosecutor, we had a predicate manual. Make sure you ask this, make sure it's proffered through this witness, make sure you do it this way. And that is how, even if you've got relevant evidence, if you don't have the proper predicate and you haven't facilitated it through the proper witness, even relevant evidence can be excluded. And so, like you said, only in very, very rare circumstances do we flip that and say something's automatically admissible. And so this amendment is attempting to narrow that in a very, very precise way without opening it up to a myriad of other objections under the Texas Rule of Evidence.
And my understanding is without this amendment going on, certain evidence, including Medicare charges for the same procedure or treatment, workers' comp charges for the same procedure or treatment, the 50th percentile of that provider in that GeoZip, that stuff is going to automatically come in any trial concerning concerning past medical damages unless this amendment comes on.
That's correct. Yes, sir.
And the remedy, or not remedy, the limitation that we have fashioned is to provide the court a mechanism to decide whether that information is relevant to that particular claim. For example, if that claimant is eligible for Medicare or eligible for workers' comp, and alternatively, allowing the court the ability to determine if the evidence itself is more probative of the case itself or more prejudicial against the claimant or the defendant.
Yes, and it's just in those two narrow circumstances. And I would also say that if there are a number of cases where even if someone may not have received care under those programs, that evidence could be relevant to essentially set a baseline. But we do want a threshold determination being made.
So I think you'll agree with me that this amendment helps strikes the right balance between admissibility and our current between the need to admit alternative evidence of medical damages and following and adhering to the Texas Rules of Civil Procedure as they've been prescribed by the Texas Supreme Court.
Yes, sir. I think that's exactly what we're trying to do. And I think also what courts are going to take notice of is that these are laid out specifically as types of evidence of healthcare expenses. This is the kind of things that can and should be entertained in a court, but that gatekeeping function in those two very limited ways will remain to make sure that we're not getting something irrelevant or something that is more prejudicial than probative.
Thank you, Speaker Moody, for working with me on this amendment. I will wholeheartedly support it.
Thank you, sir. Move adoption.
Dr. Bonin in opposition to the amendment.
Thank you, Mr. Speaker. Listen, this legislation will make automatically admissible certain objective payment metrics for healthcare services, and that includes bill charges, workers' comp and Medicare rates, the 50th percentile of amounts allowed to participating providers. What this amendment would do is it would change all of that information from automatic admissibility back to current law, which leaves it to the judge's discretion. The problem is that judges are currently excluding relevant evidence going against clear guidance from the Texas Supreme Court. In 2018, in the North Cypress Medical Center case, the Supreme Court said the amounts regularly paid to a hospital by third-party payers was relevant to prove the value of the services provided. In 2021, in K&L Auto Crushers, the Supreme Court again said, the reasonableness of the claimant's medical expenses is as germane in a personal injury case as it is in a suit to challenge the validity of a medical lien. Our relevance holdings in North Cypress thus apply equally here. While certainly not dispositive, the negotiated rates the providers charged to private insurers and public payers for the medical services and devices provided to Walker and the costs the providers incurred to provide those services and devices are at least relevant to whether the charge master rates the providers billed to Walker for the same services and devices are reasonable. Put another way, the Supreme Court has clearly already spoken that these types of payments, which are outlined in this legislation from government payers and private payers, are relevant to the value of services provided, which speaks to Rule 402. Courts in Texas are not following those guidelines. That is why we have this legislation in front of us. The point is to make this relevant information admissible in trial so the amount of damages can be determined by a jury. I respectfully oppose the amendment.
Mr. Little in favor of the amendment.
Thank you, Mr. Speaker. Members, this amendment is actually extremely important. Let me explain why. It is extremely rare. There are very few occasions in Texas civil procedure where we automatically admit evidence for anything. And the reason is we have the judge that we elect in the state, we have elected judges to make the decision as the gatekeeper concerning what evidence is admitted in a personal injury trial. Keep in mind, we as a body here are considering something very narrow, and it has to do with evidence concerning past medical damages. It's a very narrow window, but the thing that I want you to keep in mind is if we begin automatically admitting evidence and turn over the judge's responsibility to determine the relevance and the probative value of that evidence over its prejudicial value or prejudicial problems, we will be opening a big door to a major change in civil procedure. I think we will go back to our districts and our judges will look at us and say, what are you doing? There is nothing like this in civil procedure. It is very important that we have a safety mechanism in there for this evidence so that the judge can say, you know what, maybe because we have an injured child, Medicare reimbursement rates for which the child is not eligible are not relevant to that child's injury. This child is maybe 10 or 14 years old, like my son is back there. 14-year-old child is not eligible for workers' comp as it relates to a medical damage injury. So let's be very careful here in what we're doing. And if this amendment does not come on, this discussion is going to change very rapidly about what it is we're going to do with this bill. It is very, very important that this body understand the significance of what we're doing here. It's important to leave our judges as gatekeepers, because if you were on the P side, the plaintiff side, or the D side, the defendant side, I promise you, you are going to want to make sure that there is a judge there ready to make a decision based upon the law, not because of what one interest or another has to say about any given case. And I ask you to support this amendment and vote in favor of it.
Mr. Speaker,
Mr. Money, for what purpose?
will the gentleman yield for a few
Will the
questions?
gentleman yield for questions?
Always.
The gentleman yields.
The purpose of this amendment, I think, is in alignment with what the bill author said that his amendment was for, which is to make sure that relevant evidence gets into trial, correct?
That's my understanding, yes.
And under Texas law, which is the same, it goes all the way back to English common law, judges have always determined what's relevant, correct?
That's my understanding.
And the problem is that every case is different, and relevance is very fact-specific at times, correct?
That's why we hire judges to make those decisions. So as I understand, the dynamic with the bill is we are concerned that plaintiffs in personal injury cases have received too much of an advantage, and the defendant is not able to get in alternate forms or measures of economic damages as it relates to past medical injuries. And so what we don't want to do is we don't want to overcorrect and say that every piece of evidence on the defendant's side is automatically admissible. For the same reason, we need to be here to provide a balance to the equation.
So all the evidence that is in the amendment that we're discussing would get in with your amendment to the amendment as long as the judge determined that it was relevant according to the rules of evidence, which only means that it has a tendency to make a fact more or less probable than it would be without the evidence.
Yes, that's right. And if you just stop and think about this amendment in the negative, we would be requiring a court by law to admit irrelevant evidence if this amendment is not incorporated into the bill.
That's correct. And so I don't think anybody on this floor, in this chamber, in this state wants irrelevant evidence to be considered in a trial, correct?
Doesn't make much sense to me.
And I don't think that the bill author was saying that he wants irrelevant evidence admitted in the trial. I think there is a disagreement at times about which evidence is relevant or not relevant, and that we usually ask a judge to make that determination. And in those rare cases where a judge gets it wrong, you have an appeal process,
That's
correct?
Right. That's right. That's right.
And so I think it's just important for the people listening here to understand, if you vote against this amendment to the amendment, what you're actually voting for is to make sure that evidence gets in that a judge would have found irrelevant.
I think that's what we're trying to avoid.
Okay, thank you, Mr. Little.
Yes, sir. Thank you.
Mr. Speaker,
Ms. Garcia Hernandez, for what purpose?
Does the gentleman yield for questions?
Yes,
The
ma'am.
gentleman yield for questions. The gentleman yields.
Thank you, Representative. You brought up a really good example talking about a child and a judge making a determination that certain rates wouldn't apply in that particular situation. I wanted to talk to you a little bit more about that because my understanding is this particular bill pulls in different considerations of as far as what will be considered in the rates and what are the reasonable charges, the medical charges that will be put forward before a jury. As far as your understanding, because I know my understanding is that you practice a little bit in this area as well, is that correct?
I really don't. I'm not a personal injury lawyer. I'm not an insurance defense lawyer. I'm a civil litigator. I'm familiar with the rules.
Sure.
And I feel like I have a good grasp of the bill, but I'm certainly not as experienced as you are.
Sure, no problem. I wouldn't mind asking you a few questions just in regards to that, because I know that you had quite a bit of an opportunity and time to hear all of this type of testimony and talk to stakeholders. Are you aware as far as whether all medical providers here in the state of Texas are obligated to accept Medicare or Medicaid?
I'm really not, because I'm assuming that they are not.
You would be correct. So here in the state of Texas, we do not require every medical provider to accept Medicare or Medicaid. We allow our medical providers to make that determination of whether they want to accept those particular patients or not. As far as the percentage of Texans that are on Medicare. We only have 14 to 15% in the state of Texas. Were you aware of that?
No, ma'am, I'm sadly not. I don't know enough about that topic.
Now, of those 14 to 15%, only 52% actually have additional insurance coverage on top of that. For a lot of individuals who either have Medicare or Medicaid, or no individuals who have that, very often a lot of individuals have to have additional coverage on top of that because Medicare and Medicaid only cover so much of your medical expenses. Is that something that you're a little familiar with?
That makes perfect sense to me. Every person in Texas is in a different set of circumstances. One of the perks of having this job is apparently we have great health care insurance. So it certainly doesn't apply to everybody in the state of Texas. Everybody's in a different situation. Some on Medicare, some on Medicaid. Some are going to have their problems solved by workers' comp. Others are going to be paying cash. That's why I think it's important to cabin this evidentiary introduction by relevance and probativeness.
Absolutely, and I agree with you 100%. An example is taking in consideration that you have to be 65 or older in order to qualify for Medicare. That wouldn't be very relevant in that example that you gave about a child who may have been injured or potentially killed. Is that correct?
Well, if Dr. Bonin were here instead of me, what he would say is that Medicare is kind of this universal benchmark where a lot of medical providers are billing at some function of that benchmark of Medicare. I'm not a physician. I don't know whether that's true or not. I just know that not everyone is eligible for that benchmark, and everyone's circumstances are going to be different, and that's something a judge is going to have to consider in determining what evidence to admit in a trial.
Absolutely, but just so you are aware, we know in fact that the federal government agencies are the ones that dictate what those actual costs for Medicare are, and very often it's 86% less of what an actual cost to the provider himself can be. My understanding is underneath this bill, you are also potentially subjected to putting forward workers' compensation amounts as well. The rates is something that would be subjected to that. Is that correct?
Yes, ma'am, and my understanding from Dr. Bonin is that workers' comp reimbursement rates are actually higher than Medicare. It's another benchmark that one could use to present controverting medical damage evidence in a trial. It's not dispositive. It's something for the jury to consider. Absolutely,
and just so you're aware, and if you didn't know already, there's only a total of 30%.
Gentleman's time has expired.
Thank you so much, Representative. I appreciate you bringing this amendment, and I look.
Chair recognizes Mr. Moody to close on the amendment to the amendment.
Thank you, Mr. Speaker, members. Appreciate the conversation on this. As is stated, and we've talked about back and forth here, we understand the problem. There's been a myriad of conversations about how to find the right space to address the problem. I think this amendment gets us to that place in a way that doesn't do violence to the core principle of 41015. And as you notice, we've already adopted an amendment that narrowly addresses this in 41016. That was the little amendment that was adopted previously. Again, adding relevance, and you saw overwhelmingly that we stood up for that provision in the other major operative section of this bill. And so this amendment would sit over the top of these types of evidence that are laid out in the bill, and it would simply say that only in the instances of relevance or something that may be more prejudicial than probative, we're going to maintain that narrow space for the judge to still retain their gatekeeping function in these cases. And I think that strikes the right balance, and contrary to what some folks have said, does not take the law as is backwards. All of that stuff is still subject to Texas Rules of Evidence in full. We're now laying out a category of expenses where we are going to just narrowly create these objections in these particular cases.
The gentleman yield for questions.
Will the gentleman yield for questions?
Yes.
The gentleman yields.
So what this bill, this part of the bill is trying to accomplish is trying to provide evidence of what something costs, the marketplace of what a certain thing costs, a broken bone, for example, right?
Sure. So so if you go.
But hold on, let me,
But-
generally you understand that's what the bill is trying to do. You agree with me?
Don't need you to tell me to understand what the bill does. I've been looking at this for a little while. Okay, so we can have a level conversation here. Can we just keep it like
No,
that?
I'm with
Okay.
you. I'm just saying, that's what the bill is trying to do here. What
Yes,
the
sir.
language says
Yes, sir.
is it's trying to say, here are some data points to find out what the market is in certain circumstances for, let's say, for example, a broken arm,
Well,
and how to repair a broken arm.
Well,
Can we
so-
start with that basic understanding?
well, there's multiple provisions under subsection D in 41015 that list out the types of evidence that would be automatically admissible, right?
Correct.
So, yes, to your point, yes, that would be included. You're looking at what amounts paid by non-third party payers, and then you're looking at Medicare, you're looking at the 50%, right? Medicare,
Yeah.
workers' comp, 50th percentile of amounts allowed. So you're looking at data points. And these are in cases where, subsection C doesn't apply, right? So those are cases in which you had a third party payer paying for these, right? So you have the bills of the third party payer paid.
And so you'll agree with me that what this bill is trying to do is find out what the market is in certain circumstances to find out cost. The goal is, for both plaintiffs and defendants, the goal is to find out what is a cost for this certain medical service from a certain provider.
In
right.
circumstances, yes, in circumstances that are not covered under subsection C,
Right.
which is where those are being paid by a
Correct.
third-party payer. So we're talking about every other circumstance. Then we're trying to figure out what
Correct.
evidence should come in so that you have a number of things, right? So the average amounts collected by the provider during a 1-year period.
And we know that, for example,
Their contract rates.
in workman's comp, there are providers that provide services to fix the similar, in this example, a broken arm.
Sure, yes, sir.
For a certain cost. That is market evidence of cost, right?
That would be, yes, sir.
You'll agree with me that's relevant, right?
I think in certain cases it would be, in certain cases it may not be.
Okay. Well, can you give me an example where, in a certain locale, where a workman's comp provider fixed a broken arm, and it's the same broken arm type of service in the case at hand, how that would not be relevant of a market cost or value
And the
for
claimant,
that service?
I'm sorry, I'm trying to understand the example. And the claimant in that case made a claim under workers' comp?
It doesn't matter. It's a service provider providing a service for a fee, meaning that is a market. That is something that can be measured. We see that.
Yeah,
we
I do-
see that
and-
in non-insurance and in insurance providers. We can determine what that cost is. Again, the goal of this bill is to do this. It's to say, let's compensate when there's liability. Let's compensate those that are injured for their injury. And one of the items, there are a number of items, but one of them is their past medical expenses.
Well, I think the goal is to ensure that we have some tethering points so that the jury can understand whether those costs are accurate or on par. So yeah, I do agree with you there. However, and I don't want to get into the philosophical parts of this, but as Mr. Little stated, without any guardrails here, this is all evidence that we are deeming relevant and not prejudicial versus probative as a matter of legislative fiat.
And you're
and
talking
you and
about
I
that-
are not in those
Right.
courtrooms.
And you're
day
talking
to
about
day.
that in the abstract because I don't think you can conceive of a scenario, or I can conceive of a scenario, and I'm talking about this one little minor piece, where the cost in a workman's compensation scenario to repair the broken arm, that data point isn't relevant to what the cost is in the market. that doesn't mean that's what the damages are going to be. It's just a piece of evidence that's admissible, along with a number of other pieces of evidence.
Well, and I think,
and let me finish. Let me finish, and I'll give you a question.
sure.
But the point here is to give these courts, this instruction that these things are relevant, and I think most of us would agree that they are, and that they're admissible, but they're not determinative of what the damage amount is going to be. It's just evidence. And to have statutory guideline to help in that respect, we have more consistent outcomes, more consistency within our judicial system, and I think it will help the courts and the parties in determining this element of damages. So I say that to ask you, in what circumstances, let's go back to that one minor piece, the workman's comp cost to fix a broken arm, how that would not be relevant or admissible to show just what the market cost for something like that would be.
Well, I mean, I don't, look, the point of this bill is to gather up the medical costs in all these various points. And in some cases, my argument would be, like you said, they are relevant to that particular case. And in some cases, they wouldn't be relevant. And why would we not? If you're saying that in all cases that's going to be a relevant piece of evidence, then I don't think you would have objection with a judge finding them relevant or not, because you're saying it's going to be relevant in the case. If you got a workers' comp case and you have a workers' comp rate, I think that's absolutely relevant. But why would we have a legislative action to deem these things relevant when we don't know the fact pattern of every single case that's coming forward, and all of these pieces of evidence are going to be deemed admissible and relevant without any sort of input from the trier, from the judge, which divorces itself from every other way that we do this.
I think we see, Mr. Speaker, more eye to eye than you think, because I think
Well, I
that's
look
why
forward to you voting for this.
That's why this is so narrowly tailored and drafted, to make sure that what you're concerned about doesn't happen.
No, I do believe my amendment is narrowly tailored because the entirety of the rest of the Texas Rules of Evidence won't apply to this stuff. Won't apply. So any other thing that you could object to here would not apply. We're just saying that they need to be relevant to the case at hand,
And
which I think is important.
And I do appreciate the discussion. Thank you.
No, thank you very much.
Mr. Speaker,
Mr. Fassouf.
Gentleman, you have for a question?
Gentleman, you have for questions.
Yes.
Gentleman.
are you aware Rule 401 relevance is any tendency to make a fact more or less probable? It's an extremely low bar, way down there. This only applies when somebody's having a personal injury cause of action where they're seeking economic damages for the personal injury.
Gentleman's time has expired.
It is relevant as a matter of law. Thank you.
Move adoption.
Mr. Moody sends up an amendment to the amendment. The amendment to the amendment is not acceptable to the author. A record vote has been requested. The clerk will ring the bell. Strict enforcement has been requested. Members, I will give you time to vote from your desks. Have all voted. There being 65 ayes and 65 nays, the amendment to the amendment fails. Verification has been requested. Members, please take your seats. Members, please take your seats. The clerk will proceed to call the names of those members voting nay.
Alders.
Members, please take your seats. Sit down in your seats, please, members.
Ashby. Barry. Bell of Montgomery. Bell of Kaufman. Bonin. Buckley. Bumgarner. Button. Kane. Capriglione.
Members, please take a seat.
Cook.
Mr. De Ayala.
Craddock. Craddock.
Is Mr. Craddock on the floor of the House? Temporarily strike his name.
Cunningham. Curry. Dean. Deala. DeRazio. Dyson. Fairley. Frank. Gertis. Harless. Harris Davila. Harrison. Hayes. Hefner. Hicklin. Hull. Hunter. Isaac. Kerwin. Kitzman. Landgraf. Leach. Leo Wilson. Lopez of Cameron. Lozano. Lujan. McLaughlin. McQueenie. Metcalf. Meyer. Noble. Ordaz. Orr. Patterson. Paul. Perez of El Paso. Schatzline. Schofield. Shaheen. Schoolcraft. Schaffner. Slauson. Smithy. Spiller. Swanson. Tepper. Toth. Troxclair. Van Dever. Vasu. Villalobos. Wilson.
The clerk will proceed to call the names of those members voting aye.
Allen. Anshia. Bernal. Bojani. Bryant. Busey. Campos. Canales. Cole. Collier. Cortez. Darby. Y. Davis of Dallas. DeRazio. Dutton. Flores. Gomez. Garcia Bear. Garcia of Dallas. Garcia of Dallas.
Is Ms. Garcia of Dallas on the floor of the House? Temporarily strike her name.
Garcia Hernandez. Guerin. Gervin Hawkins. Gonzalez of Dallas. Gonzalez of El Paso. Goodwin. Guerra. Hernandez. Hinojosa. Holt, Hopper, Howard, Johnson, LaHood, Lilani, Little, Longoria, Lopez Abear, Louderback, Luther, Manuel, Martinez, Martinez Fisher, Meza, Money, Moody, Morales of Harris, Morales of Maverick, Munoz, Olcott, Oliverson, Phelan, Plisa, Plisa,
Is Ms. Plesa on the floor of the House? Temporarily strike her name.
Reynolds, Richardson, Rodriguez Ramos, Romero, Rose, Rosenthal, Tallarico, Thompson, Tinderholt, Turner, Vo, Wale, Zwiener.
Is Mr. Craddock on the floor of the House? Verify Mr. Craddock. Is Ms. Garcia of Dallas on the floor of the House? Strike her name. Is Ms. Plessa on the floor of the House? Strike her name. The following members have informed the chair that their machines malfunctioned. The following members were present in the chamber, but their machines failed to register. Show Representatives Verdell, Ward Johnson, A. Davis, J. Jones, M. Pettis, Pearson, V. Jones, Simmons, and Wu voting aye. Show Representatives Gates, Wharton, Lambert, Raymond, and Guillen voting nay. Members, the verification of the vote shows 72 ayes and 70 nays. The amendment to the amendment is adopted. The following amendment, the clerk will read the amendment. The following amendment to the amendment, the clerk will read the amendment to the amendment.
Amendment by Johnson.
The chair recognizes Ms. Johnson to explain the amendment.
Thank you, Mr. Speaker and members. What this amendment does is acknowledge and address the issue of whether or not a hospital provider needs to track down all the records with regard to patients who are referred by an attorney. And so if you look at the language of SB 30, it asks if there is an attorney that is referring patients to a medical provider. And I would expect that what you think here is that if you have a letter of protection or you have a chiropractic's place and the attorney is referring over to them, that's what you want to know. You want to know if the attorney is sending all of their patients to a one individual doctor. The problem is the second paragraph on page 7 says that it also obligates a provider to provide 2 years' worth of records for anybody referred by an attorney. And so let's take it the other way. For example, when anybody comes to me and says, hey, I have a lump in my breast, I'm going to say, go to MD Anderson. Don't go anywhere else. Go to MD Anderson. That's the place you need to go. The question would then be, does MD Anderson have to go back and figure out a way to track down 2 years' worth of records of anybody that was referred to them by Ann Johnson? This seems an impossible thing for a hospital provider to do. And so what we're looking at here is any orthopedic place, any hospital, anybody else. The provider is not going to have the access to go figure that out. And so if the goal is just to say, and if an attorney is running cases towards a doctor, you want that list. But the second prong of saying we're going to put on every hospital entity, every medical provider, anybody else, to go down and try to figure out if any of their patients have been referred to them by a lawyer, that now they have to give 2 years history of all of those other individuals' billing records. This seems impossible to comply with and does not seem to be appropriate based on the intent of the bill.
Dr. Alderson, for what purpose?
Mr. Speaker, Does the
what purpose?
gentlelady yield for a question?
Will the lady yield for questions?
I do yield for
The lady
questions.
yields.
Okay, so Representative, I appreciate your amendment. I am not a lawyer. I don't play one on TV. I'm just a humble doctor who is occasionally taking care of these patients. Are you telling me that the way this bill is drafted, if I take care of one of these patients, that 2 years worth of records suddenly become, I have to provide those to a court?
And not just on the patient, but let's say that I refer, I'm a lawyer, and I say, you know what, you should really go see Dr. Oliverson, right? They're going to ask me, as the lawyer, tell me which patients you've referred to Oliverson, and I can answer that question. But they're also now going to ask you, can you tell me all the patients that you've treated in the last 2 years that have been referred to you by Ann Johnson? In my view, this is putting a massive administrative burden on not only the physician, but the hospital entity to try to figure out what, if any, connection you have to a lawyer through the patients.
Let me ask, what happens if you're a hospital-based provider? I'm, as you know, an anesthesiologist. I have worked at surgery centers where doctors have brought these cases, and so I've gotten involved in their care because the doctor brings the case there and I have the contract at the place. Are you telling me that just because I'm involved in the case, now my anesthesia company has to turn over records as well?
That's the way it reads to me, that your anesthesia company would have to turn over any records for any patient within the last 2 years that has been referred by a lawyer. And I don't know how you're going to obtain or collect this information.
So normally how this works is when I'm taking care of patients, you know, a surgeon will have block time, and they'll be operating from like 8 to 12 on a Tuesday, and they may bring some cases that would be in this bucket, right? And so I don't have control over that. I don't set the surgeon's schedule. Are you telling me that they could essentially go back through other records and things like that and get access to cases maybe not even related to this particular case, but since that surgeon comes once a week and I do their cases, any case that would be, you know, referred from an attorney suddenly now, no, going back years, and 2 years, you're saying?
2 years. And these are the two key phrases, provider and attorney. And so if your anesthesia group or Memorial Hermann or any other hospital is, quote, the provider, then you would be responsible for any patients that have been within that system that is tied to, quote, an attorney. I don't know how you would figure out how to comply, but how you would keep the information. So I also think about this. When I go in for an orthopedic injury and I fill out the paperwork and the physician will ask, is this part of an injury or a wreck or a workplace incident? And what you and I know, that usually means they're going to say, no thanks. I don't actually want to treat you because this is related to a potential lawsuit, and I don't want to be deposed. I don't want to be brought into a litigation. And so my greater worry is this may create an even larger medical desert for people who are actually truly injured.
Yeah, you know, it's interesting you say that because, you know, the more I learn about what this bill does just from a provider standpoint, I mean, it seems to me that the only way that a provider could protect themselves from the requirements of this bill is to just refuse to see these patients. Is that right?
That's the worry.
So I would just have to drop my contract for that facility and not, or tell that surgeon to go find another facility to operate at and just basically not be involved in the care of that patient. That's my only defense against what you're talking about.
That's exactly right. And that's the issue, which we know the whole discussion about this is to get rid of frivolous lawsuits.
Which we agree do happen, right?
And that's the goal.
And that's
this
laudable,
doesn't
I
accomplish
think.
that goal.
I think that's laudable, right? I mean,
and
I
that may
don't.
be laudable, but this doesn't accomplish it because, as you say, this language of, quote, provider and, quote, attorney, and the obligation that it's putting on the hospital entity or the physician to now become part of a lawsuit with any potential patient that they have had, that is more hassle than treating the patient. And you're
Wow.
right, that's the worry. The unintended consequence of this paragraph is medical providers, like they already do now, will say, no thanks, I'm out, I don't want to mess with it. And that's why this amendment keeps intact the request that an attorney provide all the people they're sending to.
So
you're still
does-
getting the information from the attorney, you're just not pushing it on the provider.
Okay, so would this requirement still be subject to HIPAA requirements with regards to federal law? In other words, would there be confidential patient information that could become part of this court's record?
I mean, of course, if you're replying and you're giving discovery, then yes, you're going to have to give them the medical records, and lawyers are going to have to keep confidentiality, whatever else. And the point being that if you and I are involved, if I'm a litigant and you're my physician, why in the world should J.M. Lozano's records or Miriam Perez's records somehow now become part of my lawsuit simply because they were treated by you out of your hospital provider?
Yeah, I mean, that's really scary. And as a medical provider, you know, I can lose, that's a violation of the conditions of participation in Medicare and Medicaid if I violate HIPAA. And you're telling me there's a possibility that I may have to turn over records that aren't even related to this patient's care but involved other patients' care could be part of this as well. Is that what you're saying?
And I can't answer on HIPAA, and I don't want to speak
Well,
to
I
that.
can.
But
I can tell you
definitely
I can tell you that's a HIPAA violation. I can't disclose that kind of information.
But I can definitely say if I'm the attorney and I've referred, you now have the obligation to provide everybody else's information. And it's duplicative, which is if that's what you want, you can get it from the attorney. There's no reason to ask the healthcare provider to provide it.
Okay, and your amendment will fix that so that I don't have to worry about that in the future as a healthcare provider.
Correct. The medical providers are not having to jump into this litigation and discovery game. The attorney is obligated, so the defense is still going to get the information they want. They're just not going to have to get it through the hospitals and the providers, which may have the consequence of having them say, I'm not treating these people because I don't want to play this legal discovery game in mass.
That's probably what I'm going to do if your amendment doesn't go on. So I appreciate you
make sure it
offering it.
gets
I hope it does. Thank you.
Thanks for supporting
Thank
the
you.
amendment.
Mr. Speaker,
Mr. Dutton, for what purpose?
would the gentlelady yield?
I will.
She's got about 30 seconds. The lady yields.
Thank you. And this may not be the right question for you, but I'm a little confused in the bill by what it means for an attorney to refer.
That's right. And so same thing of a referral and an attorney. As I said, I am an attorney, and I may tell my friends where to go. Does that somehow make me subject to that? I don't think that's the intention here.
Is that a
but-
referral?
So I don't know that that's the intention, but what we do know is if the intent is to go after lawyers who are pushing people to doctors, you get that with the first prong. You don't need the second prong.
And if I gave the client 5 names,
The lady's time has expired.
thank you.
Chair recognizes Dr. Bonin in opposition.
Thank you, Mr. Speaker. Let me be clear, because I think there's some confusion here. A provider would be required to provide 2 things. And by the way, that is if they provided care to a claimant. They would have to be providing care to a claimant, not somebody who simply got, the provider's name from somebody who happened to be an attorney. This would be, they are actually involved in litigation. If that's the case, what they're being required to provide is how many patients has that attorney referred over the last 2 years, and how much money has that attorney paid the provider. That's it. There's no other information specific to any other individuals. It is the cumulative amount of money they have been paid by the attorney representing the claimant and the number of patients who have been referred by the attorney.
Mr. Speaker,
Mr. Dutton, for what purpose?
would the gentleman yield?
I'm happy to yield for
The
questions.
gentleman
Thank you.
yields.
Thank you. I want to follow up on the question I was asking Vice Chair Johnson. And based on what you just said, if a client calls me and says, Mr. Dutton, I've just been in a car wreck, what should I do? And I say, well, look, go see, here's a list of 5 doctors. You have a choice to go see it. Is that a referral under this bill?
Are you representing that individual?
Well, I'm just saying not at that point.
Well, if you're not representing that individual, there's no, that it would not fall under the bill. If you are representing that individual in a cause of action, then that would be a referral.
So if that person chooses for one of the 5 I gave them, and then I later become their representative, would that change the situation?
That would change the situation.
So
If
it
you,
doesn't-
if you filed suit on their behalf, then that would
So
That-
it doesn't matter whether it comes before or after the person goes to see the provider.
If you're involved in a suit and you referred your client to a provider, then that would be disclosed.
Well, that's what I'm saying. I'm trying to understand the term you're using, referred to. Would it be referring if I gave them names of 5 doctors and they chose one from that list?
Yes.
That would be a referral.
If, again, if there was actually a cause of action, if there's actually a suit.
So that's my point. At that point, it wouldn't be a referral, though. It would only become a referral if that person chose from one of the 5, and then I later represented that person. Is that what you're saying?
In reality, what happens most of the time is that the individual goes to the attorney makes the referral. So, I mean, you're describing something that in theory could happen, but that is not, in most instances, the way this works.
Well, that's not going to help us as a lawyer, because what I'm trying to figure out is, I do this all the time, but I'm trying to figure out, when you say referral, what specifically in the legal terms does that mean? If I give them, again, 2 doctors to select from, and they go to see him, and then later I represent them, is that a referral? I think you said yes before.
Yeah, correct.
So when I gave them the 2 names, though, that wasn't a referral.
Well, at that point, they haven't gone to see anyone.
But they ask about seeing him.
Okay.
So the referral doesn't come with asking to see somebody. The referral comes with actually seeing them, I guess, is the first.
You would have to have given them that provider's name, and they would have to have gone to see the provider. Obviously, if they didn't go see the provider, then there was not a completed referral.
Well, sometimes doctors refer patients, right?
Sure.
And so if you sent the person to a general practitioner, the lawyer did, and the general practitioner said, okay, well, I need you to go see Dr. Bonin. Would that be a referral?
That's a referral.
So if the doctor that you sent them to refers the patient to a specific doctor, that is a referral also?
That is a referral.
Okay, I think that's, I understand it a little bit better. Thank you.
Mr. Speaker,
Ms. Gervin-Hawkins, for what purpose?
will the gentleman yield for questions?
Happy to yield for questions.
Gentleman yields.
Thank you, Dr. Bonin, because as you well know, this is an important deal. People got to make a great big decision here. And so I'm trying to understand this particular amendment. How does it adversely impact what you're trying to accomplish in this bill?
So the relationship between the attorney and the providers provides important information, and that's number 1, the volume of referrals that they receive from that attorney. Is this 1 or 2 a year, or is this a very large number? And number 2, what is the book of business represented by the amount of money they have received from that same attorney, meaning they've entered into a letter of protection, a financial or contract, if you will, that provider is then paid not by a third party, but by the attorney, with the understanding that that money is going to come from a settlement or an award in litigation. That speaks, so then these same providers are going to be providing information in terms of how much they should be paid and how much their services cost. And if they have a financial relationship with that attorney and a vested interest in the litigation, it speaks to their motivation behind their charges for those medical services.
So what we're trying to do with the author of this amendment is saying what, though, in terms of how that impacts those referrals, that you have to have 5 or more referrals? Because what I'm trying to understand is, are we trying to penalize a doctor who may have a relationship with an attorney and that attorney sends all of their clients to that one doctor? Are we trying to penalize them, or are we trying to just have disclosure?
We're trying to shine the light of day on these relationships, and the data will show what it shows. That's subjective to say whether that is a positive or a negative. We're simply looking for the facts.
And so who would make that determination if it's a negative, or is that up to whoever's representing the interested party if it's a negative? Or would that be brought up in court?
Yeah, so obviously this is evidence that would be presented, and it is not, it would be up to the court or the jury to decide how to interpret that.
So in layman's terms, we can say this attorney has referred 100 clients to this doctor, and that could potentially be viewed as negative, not necessarily so, but it could be, and that would help determine potentially the results or the outcomes of that case. Is that a fact?
I think that would be relevant information.
Thank you for answering my question, sir. Thank you.
Mr. Speaker,
Ms. Gonzalez, for what purpose?
does the gentleman yield?
Gentleman, yield for
I yield
questions.
for questions.
Gentleman yields.
Dr. Bonin, so I know there are currently, certain exceptions, like, for example, when you're dealing with, a relative. So for example, let's say it's a sister is a PI lawyer, and the sister is a chiropractor, and they both, right, treat family or friends, because these, family or friends, they want to hire that PI lawyer and that chiropractor. There's exceptions to that, right, as of now, but does it, in this situation in your bill, would that have to be, would that be included as a referral under your bill? If it's if family and friends?
Are they involved in litigation?
It could be.
Yeah, if they're not involved in litigation, the bill would not apply.
Okay, what if they are in litigation?
If they're in litigation and that attorney is representing them in the litigation, then that would apply. If the attorney is not representing them, then...
But that wouldn't necessarily be a referral. So, for example, as I'm saying, if it's, let's say my dad gets in a car accident and he wants me to represent him as a PI lawyer, and my sister, he wants to get treated by my sister as a chiropractor, would this fall in your... It's not referring, it's him wanting to choose for us to represent him in this claim.
Gentleman's time has expired.
Thank you.
I motion to table.
Ms. Johnson to close on the amendment to the amendment.
Members, I would ask, please consider this amendment. And here's why. We've had these discussions in judiciary and civil jurisprudence, and we heard from the victims that have been part of a horrific car crash and everything else. We watched them come in here and talk about their family members, the loss of life, the medical, everything else. We heard about these horrific cases that need not only medical care, but they need the courthouse doors open. We've all heard about frivolous lawsuits. We've heard about the folks that are running commercials or trying to set up these deals with these doctors that this bill says they want to go after because maybe they're not really providing medical. Maybe it's just a, quote, chiropractic clinic that's claiming to do something, and the defense wants to be able to say, hey, this lawyer, Joe Schmo, always sends all of their people that had a 5-mile-an-hour rear end to ABC Chiropractic, and boy, this looks like a scam. Well, you can get that in the first prong. You can get that with the prong of, hey, attorney, tell me everybody you've sent this to. The problem is this second provision says provider, and that's going to hurt all the people we heard from. Because when you are hit by a terrible 18-wheeler and you go to the emergency room and you're in ICU at Memorial Hermann or anywhere else, or you've been life-flighted, and you happen to have a lawyer because that's a case, well, now we've pushed this burden to the hospital entity to say, go track down any and all patients who have come through your ER or ICU that may have the lawyer, John Smith. That is an incredible burden on the healthcare community. It is forcing them to become a litigant in litigation and discovery of which they don't want to be part of. And so what's the harm? The harm is not that they'll stop taking these fraudulent claims, because they're not doing it anyway. The harm is that they're going to start saying, you know what? No, motor vehicle accident? No, don't bring them up in RER. I don't really want to be tied to years of litigation and discovery because you've got a motor vehicle accident in the back of the ambulance. You can only send them over
Mr. Speaker,
to the
Ms.
other
Gervin Hawkins,
hospital
for
that
what
will set
purpose?
up this arrangement.
will the gentlelady answer questions?
Will the
Yes.
lady yield for questions? The lady yields.
I'm trying to be clear on what you're attempting to do here. What you're attempting to do is not have the provider report out. Is that what you're trying to do?
Yes, because I heard from Chairman Bond, and he said, hey, the idea of this letter of protection, right? And we've heard about this letter of protection. Why do we have the letter of protection? Because so many physicians will now say, I'm not touching it, I don't want to do it, because they don't want to get involved in litigation. And so you do have a lawyer that will have a letter of protection with a physician to say this person can't pay, but we believe it's a righteous case, and when they get a recovery, you're going to be paid back. And those doctors are willing to participate, to provide care from people that are routinely turned around from other places. We're not talking about that. This doesn't say anything about only providers who are under letter of protections need to respond. It just says providers. That's every one of your hospitals. That's every one of your physicians potentially. It is a broad definition that's going to catch up. I proudly represent the medical community in the medical center. I don't see that there's any exception in here for, hey, we only want the people tied to TV lawyers,
Representative,
billboard lawyers.
in the interest of time,
Yep.
what we're trying to do, I want to be clear. If I'm going to make a decision tonight, I want to fully understand this particular amendment if you're looking for my vote, okay?
Yep.
And so you're saying that the bill states only those that are under a letter of protection don't have to report.
No. What I'm saying is this definition is so broad that it says any hospital or healthcare provider who has a patient within 2 years that's been referred by an attorney. My amendment acknowledges that you are welcome to get from the attorney the number of persons an attorney has referred to a provider. You can get the information one way. Ask for it from the attorney and make the attorney answer, yes, I've sent 10 clients to this particular provider.
So the attorney instead of the medical provider.
Correct. So keep
And that's
the
all
attorney.
that your amendment does?
That's all it does. It just says you can get this information from the plaintiff's attorney. Do not go after the healthcare provider and do a fishing expedition on discovery from them.
I get that part. So the attorney would then provide that during the case, or they have to provide that in advance?
Oh, no, they would have to provide it as part of the discovery before you ever get to trial. And the attorney would say, hey, I've sent 10 people to this. And then I'm sure the defense attorney's going to go with that where they want. Right now, the bill says attorney provides it, and healthcare provider, you give us a list as well. And all I'm asking for is ask it from the attorney. I think that's fair. But don't ask providers
Thank you, Representative.
to dig through their information. And I move adoption.
Mr. Speaker,
Mr. Suit, for what purpose?
will the lady yield for questions?
Will the lady yield for questions?
Yes.
The lady yields.
I kind of think I know where you're going, but I have a few things. So it seems like this is pretty limited. It only gets triggered in B in the bill whenever you have a situation where a provider is treating an injured individual who then sues for personal injury. So we're starting with injured guy in lawsuit, and we've got discovery about that injury. It's starting there, right? The
Yeah, so
context here.
Let's say patient A.
Patient A has been injured and has filed a lawsuit, and
Correct.
patient A happened to be treated by Dr. B. Now, if
At hospital ABC.
there we go, hospital C, we'll keep it easy, ABCs.
And so my amendment just says that you get the lawyer who is representing patient A. To that lawyer say, I have referred patient A, B, C, and D to hospital ABC.
Yeah.
What I'm asking is that you not then send discovery to hospital ABC and say, we need to know all patients you've had in the last 2 years that might be tied to this lawyer. I think it's an impossible administrative burden on the hospital. The attorney is going to know that information and can provide it. The hospital is not part of the litigation of the lawsuit. So why would we shift discovery to them in a burden of discovery and production when they're not a party?
So I don't know if you're aware, I practice personal injury defense. And so we send out requests for medical records to providers all the time.
And you get it for that case, right?
Yeah, and so usually when we're sending out these types of, discovery requests, we're having a situation where it's the hospital. I'm going back, maybe, I think I heard you mention the ambulance comes up and picks up A off the side of the road.
Yep.
In that case, that guy is not referred by an attorney to the hospital because the ambulance just brings him to the hospital. And so in that case, it seems to me, let's take a typical hospital. Typical hospital, the answers to these two questions are going to be 0 and 0. And so, but what we're trying to get at with this bill is a situation not where we have a typical healthcare provider like Dr. Bonin or Dr. Oliverson, but rather where we have a situation that a provider has been set up specifically to treat only cases or predominantly cases referred to them by counsel. And so it seems to me and that you would not have burden from this provision being put on the regular hospital. You would have burden put on somebody who's doing this for a living.
Okay, but I appreciate what you have said there.
Yeah.
However, let's say that it is not the ambulance that pulls up, but it is somebody that's in a car accident, has me as a sister or somebody else, and I say you may be injured. And by the way, you need to get the best possible treatment for your injury. You should go to Texas Hospital ABC, right? I'm with you. If the goal is to catch up attorneys that are running cases with people who are maybe not qualified medical personnel, I think you get that from the attorney. I don't see that this provider limitation would provide the protection that you and I described, and I'll give you, that's right. If the ambulance shows up, who knows? Maybe the lawyer said you should go here. Who knows who they call or how it goes down? My point, as somebody who represents the medical community and sees how these costs get passed down to everybody else, if we create an administrative burden on the hospital to participate in litigation and discovery pre-litigation or pre-being a party to the suit, I think it's going to have a consequence of people not wanting to do treatment.
I guess I would be more maybe open to your position if it was a situation where hospitals don't already have to get involved in the litigation process by responding. So I'll give you an example. So let's say I had a DWQ.
They may be engaged with me as patient A, but this asks them to provide information on patients, whoever.
Well,
so
but,
those are not parties to the lawsuit. Those are just other patients of the hospital that are now going to have their records provided in a claim that they have nothing to do with.
But for example, if I'm serving a DWQ under this, what I'm going to
What's
do,
a DWQ?
Deposition on written questions.
Okay.
All right, I'm sending a deposition on written questions with a business records affidavit. Okay, I want these records. Give me medical, radiology, et cetera, and billing. Okay, those 3 buckets. When I get it back, I'm just going to ask the question, and the answer is going to be 0 most of the time, I think.
Move adoption.
Ms. Johnson sends up an amendment to the amendment. Dr. Bonin moves to table. The question is on the motion to table. If you're in favor of the amendment, vote no on the motion to table. If you're opposed to the amendment, vote aye on the motion to table. This is a record vote. The clerk will ring the bell. Show Dr. Bonin voting aye. Show Mr. Tepper voting aye. Show Mr. Vasut voting aye. Have all voted. Show Ms. Garcia of Dallas voting aye. No, I'm sorry, nay. Show Ms. Plessa voting nay. Have all voted. There being 80 ayes, 66 nays, the motion to table prevails. The following amendment to the amendment, the clerk will read the amendment to the amendment.
Amendment by Oliverson.
Chair recognizes Dr. Oliverson.
Thank you, Mr. Speaker, members. So the purpose of this amendment is essentially to redefine the construct that is contemplated in this bill with regards to what types of billing information would be appropriate in this type. You know, if the point of this bill is to help a jury figure out what the fair market value should be to award for medical services, we want that to actually be fair market value. And let me just begin by saying that if you're a physician and you're taking on this type of case, and I have in the past, I don't do it often, but I have, it is the only time in healthcare where you are likely to take care of a patient. There's no guarantee that you're ever going to get paid. If you do get paid, it could be months, if not years, before you get paid. And the reality is that you're trying to make a decision about how to spend your day. You have a business to run. You're trying to make an economic decision about which patients you want to see, and there are a lot of patients that need to be seen. And so the question is, what is the fair market value? What is the opportunity cost for a doctor or a chiropractor or any medical provider for that matter at what point does it become worth your time and worth your effort to take care of somebody in the event, the possibility that you either never get paid or you have to wait 10 times longer than you normally would have to wait in order to get paid at all. I understand that there are situations where abuses happen and that there are unscrupulous folks that hyperinflate their charges, and that is wrong. And I don't think that should ever be the case, and I would very much like to see a bill pass. I think it could be this bill, excuse me, that provides a construct moving forward to help juries to adequately and accurately assess what the fair market value is in those situations. But remember, members, those situations are not the same situations as the people that you would normally see in the course of doing business, where you have a 100% guarantee of getting paid. You often have a contracted rate that exists, so you already know what you're going to get paid in advance, and you're going to get paid in a 30 to 60 day timeline max, as opposed to a year. And so as I thought about that and what this bill is trying to do, what I tried to do with this amendment was redesign the construct around some better metrics that would take into account all of the possible information that a jury would need, but to do it in a way that is more fair to everybody, including the provider, but also something that already exists in state law that we've been using since 2019. And so what this amendment does is it allows the use of Medicare, but only in certain circumstances where the patient is actually a Medicare beneficiary, which makes sense. And it also allows the use of worker comp rates to be considered, but only in the circumstance where a patient is actually covered by workers' comp. But outside of those circumstances, it uses the exact same model that we have successfully used in this state in the insurance code under Senate Bill 1264, which was passed in 2019, which Representative Martinez Fisher and I worked on together. Many of you voted for that. It is such a successful model that it became the No Surprises Act at the federal level. That's how good our state law was. It actually became federal law. And so this amendment would allow the jury to look at the 80th percentile of billed charges, which right now the jury could look at full billed charges. So the 80th percentile actually cuts out the people who are disproportionately pricing themselves out of the market, artificially inflating their prices. So that actually puts downward pressure and pulls those people right out. But on top of that, it allows you to look at average contracted rate. And that has been a highly successful model that we've used in Texas. The only other thing that this amendment does that's, I think, really substantive is it basically says if we're going to use Medicare rates as a benchmark for Medicare patients, we want to use it inside this construct, but we're not intending to have that extrapolated to all other sections of code and other situations where there might be a need to determine what fair market value is. And so with that, I'll take any questions.
Mr. Turner, for what purpose?
Would the gentleman yield for questions?
I will.
The gentleman yields.
Thank you, Dr. Alverson. It's a big amendment. I caught most of what you said in your layout, and I agree with a lot of what you said, namely the workers' comp provision and not applying those rates to non-workers' comp situations. Can you, on page 1, just so I understand it, can you talk about the 80th percentile of all billed charges
Sure.
for healthcare service? That language, what that's achieving?
Yeah, so that's a great question. So again, the 80th percentile of billed charges there are databases that keep track of billed charges, and those are available down to the GeoZip, which is actually smaller than a zip code. And so by using the 80th percentile, we're actually factoring out all of the people who are artificially inflating their charges above and beyond, which is what this bill is designed to address, right? Is situations where people are massively inflating their charges above and beyond what anybody would consider to be normal. So by looking at the 80th percentile, you've already gotten rid of all those people. And so that's what you're looking at. And I think, and not just me, but I think nationwide that is regarded as a highly effective way to determine what is fair market value with regards to what a provider would charge. So that gives the jury far better facts and information than just looking at the provider's billed charges.
I see. Okay. Thank you for the explanation. So, but on page 2 of the amendment, you've got line 20, about the 50th percentile of amounts allowed for healthcare
Right.
services supplier device. So what is the differentiation there with that?
So again, think of it like a goalpost, like you're kicking a field goal. So the fair market value is somewhere in between. And so what you're looking at is, on one side, you're looking at the 80th percentile of billed charges, and we explain why we picked 80th percentile instead of billed charges.
Right.
But on the other side, you're looking at the average that people who are in network and have contracted rates are paid by commercial insurance carriers in this state. So the idea, of course, is that fair market value is between the uprights. And so that's essentially what this construct does. And it's done it so successfully that not only have we used it in Texas since 2019, but it's actually gone on to be the blueprint for federal law.
Okay. That's a good analogy with the goalpost.
Yeah.
Thank you. So on the following page, page 3 of the amendment, actually if you go halfway down, so starting line 17, page 8, line 20, we're going to add some language there and renumber the sections. So it looks like that's moving into a different part of the bill. What is that achieving in that?
So we're looking at a section here that is specifically trying to tighten up the language regarding the use of medical records for healthcare services. And I think this is sort of similar to what Representative Johnson was talking about. I've heard from a lot of providers that provide care for injured patients, not just doctors, but chiropractors, other healthcare providers. And they're very nervous about what the effect of this bill might be in terms of kind of getting into their practice and data mining. And so I think that's what we're trying to address here.
Great.
And then I think, that some of this is just sort of language, different, for example, on line 9, page 4, the correct term now is advanced practice registered nurse, not nurse practitioner. So we're just sort of cleaning that up a little bit. Yeah, but then we get into this section at the bottom of page 4, which is what I was talking about, which is a legislative intent section where, we're just asking for clarification that the fact that we're using Medicare here doesn't mean that we intend it to be applied everywhere else too.
So in this section of pages 4, 5, and 6 of the amendment, basically saying this is the legislature's intent with respect to how
Correct.
this statute's to be applied.
Right. We passed a very good law, as you may recall, at least from my perspective, a good law about making sure that whatever's in the bill, whatever's the plain language of the law, that's what can be looked at. And so we wanted to make sure there was a statement of legislative intent actually in the law, as opposed to from the back mic, because obviously that's not going to be admissible going forward.
Understood. So going through those findings or statements of intent, I guess.
Yep.
So on page 5, only intended to serve the limited purpose of giving clear and specific guidance to courts and juries on the guidelines to be used.
Yep.
And so the purpose of that language is?
Gentleman's time has expired.
Mr. Speaker,
Move adopt.
Mr. Turner, for what purpose?
parliamentary inquiry.
Please state your inquiry.
Under Rule 11, Section 6, is an amendment to the amendment considered an original amendment?
No.
Thank you, Mr. Speaker. Mr. Speaker,
Mr. Turner, for what purpose?
I respectfully raise a point of order against further consideration of Dr. Alverson's amendment under Rule 11, Section 2.
Please bring your point of order down front.
Thank you.
The point of order is withdrawn and the amendment is withdrawn. Does anyone wish to speak on, for, or against the amendment as amended? Dr. Bonin to close on the amendment.
Move adoption.
The question occurs on the adoption of the amendment. This is a record vote. The clerk will ring the bell. Show Dr. Bonin voting aye. Show Mr. Vasut voting aye. Show Ms. Gervin Hawkins voting aye. Show Ms. Zwiener voting aye. Show Mr. Canales voting aye. Show Ms. Gonzalez of Dallas voting aye. Have all voted. There being 136 ayes, 3 nays, the amendment is adopted as amended. The following amendment, the clerk will read the amendment.
Amendment by Bonin.
Dr. Bonin to explain the amendment.
Sorry, thank you, Mr. Speaker. What this amendment does is it is an adjustment to the definition of an LOP, and essentially it says that the payment can be from or after a judgment or settlement to be compliant with that definition. I move adoption.
Dr. Bonin sends up an amendment. The amendment is acceptable to the author. However, a record vote has been requested. The clerk will ring the bell. Show Dr. Bonin voting aye, Mr. Vasut voting aye, Mr. Moody voting aye, have all voted. There being 141 ayes, 0 nays, the amendment is adopted.
Mr. Speaker.
Mr. Doorkeeper,
Mr. Speaker, I have a message from the Senate at the door of the House.
please admit the messenger.
Thank you, Mr. Speaker. I am directed by the Senate to inform the House that the Senate has taken the following action. The Senate has passed the following measures. HB 26, Hull, sponsor Kolkhorst, relating to requiring contracts with Medicaid.
The following amendment, the clerk will read the amendment.
Amendment by Bonin.
Chair recognizes Dr. Bonin to explain the amendment.
Thank you, Mr. Speaker. This amendment replaces the definition of physician within Senate Bill 30, and it references 74.001, which includes nonprofit health organizations within the definition of physician. This then means the nonprofit health organizations can be deleted from the definition of provider because it is subsumed by the definition of physician. I move adoption.
Dr. Bonin sends up an amendment. The amendment is acceptable to the author. As there a record vote has been requested, the clerk will ring the bell. Have all voted. There being 142 ayes, 0 nays, the amendment is adopted. The following amendment, the clerk will read the amendment.
Amendment by Bonin.
Chair recognizes Dr. Bonin.
Thank you, Mr. Speaker. This amendment does a couple of things. First of all, What it does is, the first is in the introductory paragraph to the part of the bill that now requires a provider to state the number of cases referred to him by the plaintiff lawyer and the amounts of money received from the lawyer over the previous 2 years. It's saying that this information is required only if the provider is testifying at trial or if the records are being used in the trial. The second part of this amends the part stating that LOPs are admissible, making clear that they are admissible if relating to that provider and the injured individual. So LOPs from other cases are not admissible.
Mr. Speaker,
Mr. Canales, for what
the
purpose?
gentleman yield for questions.
Gentleman yield for question.
Happy to.
Gentleman
Thank you,
yield.
Dr. Bonin. What is the goal of admitting LOPs as you're stating?
So the purpose of this amendment is to clarify that only an LOP that is relevant to this particular case is what would need to be admitted.
When you say relevant to the particular case, would that be previous LOPs as well?
This would be, and let me read that to you again, making
Thank
clear
you.
they're admissible if relating to that provider and the injured individual. So LOPs from other cases are not admissible.
Thank you. That was my question.
Mr. Speaker,
Ms. Gonzalez, for what purpose?
does the gentleman yield?
Will the gentleman yield for questions?
Yes, thank
Gentleman yields.
So if letters of protection are admissible, will also the fact that if there's insurance that exists, an insurance policy, is that going to be admissible in trial too? Because
This amendment deals strictly with the LOP.
I understand, but usually letters of protection are for situations when somebody maybe doesn't have insurance to pay for it out of pocket, right? And so providers are willing to give this treatment to someone because they can't pay for it out of pocket because they don't have health insurance. And so, if it's good for the goose, it's good for the gander. If we
Yeah,
can't
so
make,
not
if we
necessarily.
can't,
Sometimes actually, the patients are encouraged not to use their insurance and to operate under the LOP.
okay, all right, thank you.
Move adoption.
Dr. Bonin sends up an amendment. The amendment is acceptable to the authors. Record vote. The clerk will ring the bell. So Dr. Bonin voting aye. Mr. Moody voting aye. Have all voted. Being 126 ayes, 13 nays, the amendment is adopted. The following amendment. The clerk will read the amendment.
Amendment by Morgan.
The chair recognizes Mr. Morgan to explain the amendment.
Thank you, Mr. Speaker. Members, this is a simple amendment. All it does is ensure that attorney-client privilege and doctor-client privilege is maintained and secured in this bill. I move adoption. Oh, sorry. I believe it's acceptable to the author as well.
Mr. Morgan sends up an amendment. The amendment is acceptable to the author. This is a record vote. The clerk will ring the bell. Show Mr. Morgan voting aye, Dr. Bonin voting aye, Mr. Vasut voting aye, Mr. Patterson voting aye. They've all voted. Being 140 ayes, 2 nays, the amendment is adopted. The following amendment, the clerk will read the amendment.
Amendment by Martinez Fisher.
The chair recognizes Mr. Martinez Fisher.
Thank you, Mr. Speaker. Members, this is an amendment that I offer in conjunction with Dr. Tom Oliverson. In 2019, Dr. Oliverson and I worked on a concept called balance billing. You go to a hospital, you see somebody out of network, you get treated, you come home, and you have a bill for a balance of charges because you were out of network. We came up with an idea that said if we set up an arbitration system and we made that experience between the provider and the insurance company, took the patient completely out of it, and let them argue what this is reasonable and necessary, what is the rate. It was a bipartisan proposal on the House side, Chair Oliverson, Chair Lucio, myself. Senate side, it was Senator Kelly Hancock and Senator John Whitmire. And what we said, we spent a tremendous amount of time. I wrote the arbitration piece. Dr. Oliverson, being in the OR in lots of instances, wrote the piece about what is a fair fee. And we set those guardrails. And the guardrail said we would set it at 80th percentile of the bill charge. And that's what this amendment does. In this current bill, that has been reduced to 50%. The argument we heard earlier when there was a discussion about Medicare rates or workers' comp rates for patients that don't even qualify as comp beneficiaries or Medicare beneficiaries, the argument was, well, this is just evidence of the market. This amendment is evidence of the market. This is what we set up in balance bill. This is what's working. This is what insurance companies and providers are used to arguing over to come up to a resolution. And we do not want to set an inconsistent standard by lowering that threshold down to 50% and give the triers of fact and the evaluators of evidence to look at what would be a floor and another floor. We should have the full range, which is this 80th percentile number and those other payable rates, which in my view are really more like cost containment
Mr.
rates.
Speaker.
Dr. Oliverson, for what purpose?
Would the gentleman yield for a question?
Will the gentleman yields.
Representative, appreciate it. And I know we're trying to get work done. I don't want to belabor the point. But again, the point of this bill, as I understand it, is to be able to identify for a jury when somebody's massively inflating their charges. Is that your understanding?
It is.
And so you already have billed charges for that provider in this bill. What we're seeking to do is replace average contracted rate with the 80th percentile of billed charges for that GeoZip or zip code, which, as I explained earlier, is the single best way to instruct a jury in terms of who's inflating their charges and who's not, if you're looking at the 80th percentile. Would you agree with that?
I do, and I remember it very well because you did draft after draft, pulling in stakeholders, hospital association, medical association, insurance providers. Everybody was at the table, and they came up with a fair process, and we know it's fair because our balance bill mechanism is working very well. And as you mentioned, this is the policy that went to Congress and became part of their national standard. It was the Texas model.
Yeah, and this is the gold standard. If you want to know whose charges are inflated, you compare this number in a GeoZip to what that provider is charging, and you will absolutely pinpoint with 100% accuracy whether those charges have been inflated or not.
You're absolutely right, and that's why we need to have it on here. And so, members, Dr. Oliverson and I would ask you to stay with us on this amendment. We'll find out if it's a straight-up vote or a table. But thank you for your indulgence.
Chair recognizes Dr. Bonin in opposition.
Yeah, thank you. And I think we need to clarify what's actually going on here because that was pretty misleading. So let's be clear. The data that's in here includes billed charges. And what's being done in this amendment is they are now pivoting to remove the 50th percentile of amounts allowed to participating providers in the GeoZip. In other words, that is what providers are actually contracted and being paid. Okay, that is real world, that is what they're getting. They're striking that and removing it and instead putting in 80th percentile of billed charges. Now, if they wanted to strike, for example, billed charges and put in 80th percentile of billed charges and say that should be the ceiling, and leave in, as another data point, 50th percentile of amounts allowed to participating providers in the GeoZip during the calendar quarter in which the service supplier device was provided. That would make sense. But this actually is going to remove the most accurate data point of what's really happening in the market and replace it with a price point that nobody actually pays. So I oppose this amendment and move to table.
Mr. Martinez Fisher to close on the amendment.
Thank you, Mr. Speaker. Just being clear, we're setting evidence of what the market is. And healthcare is hard, and reimbursements are hard, contracts are hard. Let's just put this in another analogy. If this was an auto claim, the language in the bill would say, you don't get to go to the dealer, you don't get OEM parts. You got to go to AutoZone and get replacement parts because that's all we're going to pay for. That's what the current bill does. This amendment says we're going to up it to what the 80th percentile of the billed rate is. That's what's fair. We know it already works in the balanced bill system, and it's working fine. This is just consistency. So I ask that you stay with Dr. Oliverson and myself by being a no on the motion to table.
Mr. Martinez Fisher sends up an amendment. Dr. Bonin moves to table. The question is on the motion to table. The clerk will ring the bell. Show Dr. Bonin voting aye. Mr. Martinez Fisher voting nay. Mr. Vasut voting aye. Mr. Money voting aye. Have all voted. Have all voted. There being 83 ayes, 62 nays, the motion to table prevails. Does anyone else wish to speak on, for, or against Senate Bill 30? Hearing none, the chair recognizes Dr. Bonin to
Move
close.
passage.
Question occurs on passage to third reading of Senate Bill 30. This is a record vote. The clerk will ring the bell. Show Ms. Jones of Harris voting nay. Have all voted. There being 94 ayes, 52 nays, Senate Bill 30 is passed to third reading. Mr. Dutton, for what purpose?
Mr. Speaker, Parliament inquiry.
Please state your inquiry.
Can I raise a point of order against this bill?
Against what?
Against Senate Bill 30.
No, sir.
I'll do it tomorrow.
Members, we've got some postponed bills that we're going back to before we get back on the calendar. The chair lays out Senate Bill 57 as a matter of postponed business on second reading. The clerk will read the bill.
SB 57 by Zaffarini relating to the provisions and plans by public schools to ensure the safety of the individuals with disabilities or impairments during a mandatory school drill or a disaster or emergency situation.
Chair recognizes Ms. Gonzalez of El Paso to explain the bill.
Thank you, Mr. Speaker. Members, I was not on the floor when this bill came up, so I apologize. I had to be postponed. But it's a simple bill that makes sure that kids with disabilities are taken care of in emergency situations. Oh, I have an amendment.
The following amendment, the clerk will read the amendment.
Amendment by Gonzalez of El Paso.
Ms. Gonzalez.
Members, I filed this amendment 3 days ago, but all it does is it does the same thing that the bill does, but we had to move it from a different section because there were some complications, and it was approved by the Senator and Lieutenant Governor, everybody. I move adoption.
The question occurs on the adoption of the amendment. This is a record vote. The clerk will ring the bell. Have all voted. There being 97 ayes, 43 nays, the amendment is adopted. The chair recognizes Mr. Gonzalez to close on the bill.
I move passage.
The question occurs on passage third reading of Senate Bill 57. Record vote. The clerk will ring the bell. Have all voted. There being 95 ayes, 43 nays, Senate Bill 57 is passed at third reading. The chair lays out Senate Bill 552 as a matter of postponed business on second reading. The clerk will read the bill.
SB 552 by Huffman relating to changing the eligibility of certain persons to receive community supervision, including deferred adjudication community supervision.
Chair recognizes Mr. Leach for a motion.
Thank you, Mr. Speaker. Members, I move to postpone further consideration of Senate Bill 552 until 7 a.m. Tuesday, tomorrow.
Mr. Speaker,
Mr. Martinez Fisher, for what purpose?
parliamentary inquiry.
Please state your inquiry.
What is a motion to lay on the table subject to call mean?
It allows you to lay a bill on the table and still be able to call it back.
Mr. Speaker, does that mean that if a member were to do that, we would not have to entertain 18 motions to postpone?
Members, you've heard the motion. Is there objection? Chair hears none, so ordered. The chair lays out on second reading Senate Bill 512. Clerk, read the bill.
SB 512 by Cold Course relating to prohibiting the imposition of a monetary fine or penalty for a violation of a money service business's terms of service agreement, providing a civil penalty.
Chair recognizes Mr. Schofield to explain the bill.
Just kidding. Mr. Speaker, members, this is a consumer protection bill that says a money transmission licensee can't take money out of your account unless you buy something. And Mr. Speaker, I have an amendment.
The following amendment, the clerk will read the amendment.
Amendment by Schofield.
Chair recognizes Mr. Schofield to explain the amendment.
Members, what this amendment does is the underlying bill says if they don't want to do business anymore with you, they can close your account. What this amendment says is if they close your account, they have to refund the balance of the account to you. They don't get to keep it. And it is acceptable to the author.
Mr. Schofield sends up an amendment. The amendment is acceptable to the author. However, a record vote has been requested. The clerk will ring the bell. Show Mr. Schofield voting aye. Have all voted. There being 137 ayes, 0 nays, the amendment is adopted. Chair recognizes Mr. Schofield to close on the bill.
Mr. Speaker.
Mr. Canales, for what purpose?
Gentleman will yield for questions.
Gentleman yield for questions.
I do.
Gentleman yields.
Can you define what money services business is under the terms of the bill?
Yes, it's entities that are regulated under Section 152 of the Finance Code. What they are mostly are third-party entities that you park money with when you make transactions. PayPal is the example that comes right to my mind. I give them money, and then if I buy something from you, you're able to take the money out of it. They serve as an intermediary.
And so, other than PayPal, what businesses is this affecting?
Anybody that's in that business. It doesn't affect, say, crypto. They're a different section of the code. And I believe Western Union is a different section of the code because they don't keep your money. They just send it to where it's going.
Why would we be exempting crypto transactions from this bill?
Sir?
Why would we be exempting crypto transactions from this bill?
They're not in the bill. They're not in that section of code that's being amended. They're in Section 160.
And why weren't you amending those? Why didn't you include them?
I'm sorry, Mr.
Why didn't you include them?
Because this is about entities that they take money and they park it for you until you buy something and then they use it to pay it. And crypto is a different thing entirely. It's basically an investment.
Okay, and so other than PayPal, can you give me, the body, some examples of businesses that are doing this that you're trying to regulate?
I don't know the names of the different entities. PayPal came up because they actually tried to start fining their customers where they would take money out of your account because they didn't like things you were saying or whatever. And so we started looking into it and realized they could take money out of your account for any reason that violated their terms of service. And as you know, when you download one of these, you're scrolling for days to get to the terms of services.
So is this a PayPal bill? Is this bill against PayPal?
Cash App, Venmo, any company that takes your money, parks it there while you make until you make a transaction with somebody else.
And so it's prohibiting the imposition of a monetary fine or a penalty for violation of money services terms of the service agreement. Now, are you saying that this is dictated by the service agreement? If there's a violation of that service agreement, you're going to
Right.
provide a civil penalty?
If you violate their service agreement, so if they say, somewhere buried in those 30 pages, they could say anything like, if you don't make a transaction every 30 days, we can take money out of your account. They could say anything. And these things are so long, the consumer doesn't really have effective notice of what's in them. So what the bill says is, if you don't want to do business with me because you don't like me, that's fine. You can cancel my account, but you can't take my money out that I left with you until I buy something else.
Now, I'm not necessarily against your bill, but my question is, there's a service agreement. That's correct.
Yes.
Okay, and that service agreement is agreed to between the person that is acquiring those services and that money services business. Is that correct?
Theoretically, as I say, when you download one of these apps, you can be scrolling for an hour going through
Sure,
there.
but that's a contract.
People
And so-
don't have effective notice of this.
Well, we're responsible as adults to read whatever we're getting into.
And I do, which is why I don't use, there are certain services I don't use because you and I are both lawyers. I know enough to go all the way through. I've spent over an hour looking at Ubers before I decided I wasn't going to download.
My concern is that you're effectively overriding contracts between a consumer and a provider by legislating contracts from this House floor that are otherwise being provided. It's not like they're hiding the contract. You're just saying people aren't reading them, and therefore we need to wrap the world in bubble tape and make sure nobody gets hurt.
Well, I think they are hiding them because the terms of service are so long that effectively consumers are not going to be going through them.
Okay, so, but you are essentially abrogating, you are overriding a contract here in this, with this bill.
No, because it only applies to contracts entered into after the date of the effective date of the bill.
So, but moving forward, if there's a sales or service agreement that this applies to, you're overriding that.
Right. We have all kinds of consumer contracts that we override in that sense.
So so the answer is yes. You're overriding a written contract between two individuals, between an individual and a company. We're now rewriting contracts from the House floor.
No, what we're saying is going forward in Texas, you can't bind a consumer to a contract that does this. We're not overriding any that are currently in effect.
So this company that is providing a service now, they're not bound to the contract, and neither is the consumer. So what's the purpose of the service agreement?
There are plenty of things in the service agreement that you can be bound by, but
Well, why don't you exclude those two, since we're just going to exclude whatever it is you don't like?
Because this was particularly egregious. The purpose of the entity and the purpose of the contract with them is that you can park money with them until you make a transaction with somebody else, and they were just taking it and putting it in their own pocket.
Okay, but that was part of the terms of the agreement that the consumer agreed to ostensibly.
No, actually, it never got to that stage. They proposed that they were going to do it, and the backlash was so big that they didn't. And in fact, their own former chief executive officer described it as, I can read it to you. I can read his quote to you. What he said, this is David Marcus, the former president of PayPal. He said, "This goes against everything I believe in. A private company now gets to decide to take your money if you say something they disagree with. Insanity." And that's the guy that used to lead the company.
Okay, thank you for answering my questions. I appreciate you.
Thank you. I move passage.
The question occurs on passage to third reading of Senate Bill 512. This is a record vote. The clerk will ring the bell. Have all voted? Being 146 ayes, 0 nays, Senate Bill 512 is passed the third reading. The chair lays out on second reading Senate Bill 241. The clerk will read the bill.
SB 241 by Flores relating to prohibitions on camping in a public place.
Chair recognizes Mr. Capriglione to explain the bill.
Thank you, Mr. Speaker. Members, Senate Bill 241 updates existing statute to better enforce the state's public camping ban and ensures local jurisdictions are enforcing the ban. So just a little bit of background, even with the passage of House Bill 1925 in 2019, which made it a state crime to camp in a public location outside of a designated campsite, many places, as you know, still have open campsites throughout their cities. The burden of cleaning up these campsites has fallen on the state, which has resulted in significant costs for abatement efforts. Additionally, the Attorney General has found it challenging to seek injunctive relief under the existing statutory framework. What this bill does is specifies that local entities must investigate and enforce violations of the public camping ban following written complaints. Now, once a complaint is submitted by the public, the local entity has 90 days, 3 months, to resolve the complaint. If the local entity does not resolve the complaint within that time, the Attorney General issues a written declaration that the local entity is a violating local entity. This bill authorizes the Attorney General or DPS to enforce the camping ban and allows a comptroller to withhold sales taxes for the amount of money the state spends enforcing the ban. Additionally, the bill clarifies that local entities may not use designated properties for camping unless they have applied for and received approval from the Texas Department of Housing and Community Affairs. These changes are needed to make sure that we enforce the ban and continue to allow open camping in local jurisdictions.
Ms. Hinojosa, for what purpose?
Will the gentleman yield for questions?
The gentleman yield for questions.
Yes.
The gentleman yields.
Thank you. Representative Capriglio, so my understanding of your bill is, and you gave a pretty good explanation, but just let me check for understanding. So this is giving the Attorney General and DPS enforcement authority over people who are homeless, who are on the streets, if they,
No.
so cleaning up any encampments, but even just an individual who is homeless who the city is not taking action to clear off the streets if there's a complaint made? Is that right?
No, what it does is it allows the Attorney General to enforce, along with the comptroller, to enforce the current laws that are in place by reinforcing the fact that the law is the law, and that if they don't enforce the current camping ban, even after a complaint by local citizens, then they will pay for that enforcement to occur.
Okay, you give the authority to, and the enforcement of what? To clear out a site or to take somebody who is homeless off the street?
In 2019, we passed a camping ban that says that cities have to enforce those laws, that they have to enforce individuals who are unlawfully camping in public spaces.
Okay, and so to enforce would mean to clear them out. Is that correct?
This bill is to enforce, and I hate to put it this way, but it's to enforce the enforcement. The law already is that those cities and those counties should be doing this already. But as you can see here in Austin and cities like Dallas and other places, that those ordinances that have kind of prevented those camps from being removed are still in place, and that those enforcements are not happening. So that's why this legislation is absolutely needed, because the state has been the one footing the bill for the cities that have failed to address the homeless camping in their jurisdiction. And whether it's in my area in Fort Worth or in Dallas or here we're in Austin, everybody knows that these camping restrictions, on homeless camping restrictions, have not been enforced. So that's why this legislation is necessary, to make sure that once and for all that it is being done.
Okay, so you said the enforcement authority to enforce is given either to the Attorney General or DPS. What would it look like? What does it look like for the Attorney General to enforce the enforcement, as you said?
So let's start at the beginning. What happens is, again, this is a law and it already should be happening. But citizens have noticed that it is not. So what this requires is for these municipalities or the county to be able to have an intake where individuals can complain. And in the city of Fort Worth, for instance, there's an app where individuals can easily go and take a photo and ask the city to enforce the current law. At that point, the cities are given 90 days to do that, and if not, they will be considered a violating local entity. And once that happens, then DPS or the Attorney General will go and request for that enforcement to occur. There will be a cost to that, and that cost will come out of that government entities who's in violation of this law.
Okay, but I'm asking a very specific question again. What does it look like for the Attorney General to enforce? What specifically does the Attorney General do to enforce the enforcement?
I feel like I've answered your question. I mean, what it does is it says under the Attorney General section, for each complaint received, the local entity should take an action. If the local entity does not take the required action, the Attorney General shall issue a written declaration that the local entity is a violating local entity for that fiscal year, and the Attorney General then shall send a copy of those declarations to the local entity and the comptroller, and once the comptroller receives that written notice, then part of what will happen is certain tax receipts will not be remitted back to the state, to the government entity.
Okay, but what you're just saying is that there's a declaration issued by the Attorney General, and then they withhold money, but that does nothing to impact a homeless camp that's not being taken care of.
Well, if a municipality or a county does not want to lose those sales tax receipts, if they don't want to lose those dollars, they will pay for it. And the cleanup or the removal of that homeless camping will, unfortunately, once again, come down to the state to take care of, but this time there will be an invoice.
How does the state take care of it? The Attorney General's enforcing. You say they issue a declaration, then they take money away from the city, but how are they enforcing? What happens to the people living on the street is what I keep trying to ask you in many different ways.
Well, if you go back to the camping ban that we had, there's, first of all, TDHCA has the ability to go and create locations where this is allowable. There's also, as you know, the state has funded through appropriations support for nonprofit organizations and others to be able to help those homeless that are in need, whether it's on work, whether it's on housing. There's a variety of services that are available to those who are homeless, everything from mental health to emergency care to, in some cases, even housing. And some of that cost has absolutely been appropriated by us to go and help those organizations, and some of that has also been given to the state. I don't know what you're leading to, but the same conversation I had almost exactly 6 years ago today was that there is no criminalizing of this. There's none of this is to go and put the homeless in jail or anything like that. Ultimately, what this bill will do and what this law will do is it will do what I think we all want to happen. Nobody here, I hope nobody here, wants these homeless individuals to stay out in the street. None of us want them to live under a bridge in the cold like happened in Winter Storm Uri, where so many of them were either seriously hurt, even amputated in some cases. But the right place to put individuals who are unsheltered is not to live under a bridge, to live in a encampment, is to get them help. And as you know, various cities have put funds aside to do that, and so have the state.
Okay. And my understanding of the many people who died during Uri, many of them were actually housed. So I know there may have been some that
I'm
were
talking
not.
about homeless individuals who
Right.
we've heard stories of, and I talked about, again, seems like yesterday, but 6 years ago, so many of them who were frostbitten or worse.
Yes.
Because the city of Austin refused to find them shelter. The city of Austin and other cities seemingly are okay with these unsheltered individuals being in harm's way. And what this bill does is it continues the efforts to find them assistance in getting them out of these areas.
So you're saying that the way the state is going to enforce the ban on people living on the streets, the homeless ban, is by giving people services. You said mental health care services and creating locations for the people who are on the streets?
There's two different things, right? So the first thing this does is it makes sure is that the cities are enforcing the current laws, which essentially do clear these areas out. Secondly, separately, through appropriations both from the cities, the counties, and our state appropriations, there are services that are available for these.
Gentleman's time has expired. The following amendment, the clerk will read the amendment.
Amendment by Hinojosa.
Chair recognizes Ms. Hinojosa.
Mr. Speaker and members, what this bill does is it penalizes localities, cities, mostly urban cities, for a homelessness problem that exists within our cities that we don't want. As the author of this bill said, nobody wants people living on the streets. But during the interim, I came to find out something that I think you would find very interesting. You see, I represent this part of Austin, and there is a church, St. David's Episcopal Church, and they have a wonderful homelessness ministry. I am friends with the woman who runs that. Her name is Andy Brower. Some of you may know her. And she asked me, can I come and meet with you with some of these people who are living on the streets in Austin? And I said, of course, come. She filled my office with all these people living on the streets. And I heard their story. And there was this one gentleman sitting so close to me, and he said, the thing is, I was brought here to Austin by the state of Texas. I have no connection to Austin, but the Department of Criminal Justice brought me to a halfway house on the east side of Austin. And then when I was paroled out, I was just here in Austin. I know nobody. I have no job. I have no family. I have no where to live. And by the way, I have no way to get the medication I need for my mental health problems. And by the way, you want me on my medication because the reason I ended up incarcerated is because I was not on my medication. He said, and many of us living on the streets come from that halfway house in East Austin. So that piqued my interest. And I went and I visited what is known as a transition center. It's the Austin Transition Center. It is a 421-person bed on the east side of Austin. I went and I started asking questions. It is run by a private prison corporation by the name of Core Civic. They have another operation in Dallas, another operation in Fort Worth, El Paso, and Corpus Christi. And what I learned was that of the entire population there in 2024, 1,371 people there, just 8% were from my county. Just 8% were from Travis County. The rest were brought to my county by the state of Texas, by TDCJ. When I met with the woman who runs the program, she said, oh, I am sure that many of the people who are living on the streets here in Austin come from this location because they get let out. We try to have a 100% employment rate. I asked, what is your employment rate? It was under 20%, and they count day labor as employment. The state is letting people out of the system. These are former offenders, formerly incarcerated people, into our community.
The gentlelady yield for questions.
Will the gentlelady yield?
Let me just finish this point.
Absolutely.
Not at this time.
Into our community with no resources, no connection to anyone, and they are out here to fend for themselves in our city, and then we are blamed, like the author of this bill is doing, we are blamed for our homelessness problem in Austin when it is the state of Texas who is in large part creating a problem, because that is what happens when you don't have a safety net. We don't have a safety net. We're not bleeding libs, that's why we have a safety net. We have safety nets because it keeps our communities safe, right? I had one person once tell me, I want your kid to get an education, not because I care so much about your kid, but because I don't want your kid robbing my house. That's what happens when we don't give people the help that they need to get back on their feet when they come out of the system. We throw them into a community they have no connection to, and they end up living on the street. So what this amendment says is that you should not penalize the city for the problem when it is caused by an offender, a former offender who is living in your city, who was not who did not come from your city, who was brought here by the state of Texas. And that is my amendment, and yes, I will answer your question.
Mr. Speaker,
Mr. Canales, for what
will the
purpose?
gentlelady yield for questions?
Yes.
The lady yields.
So I'm listening to your story, and so we, during an interim hearing and the time I've been in the legislature, did you know that cities play homeless wars? Meaning they round up their homeless, give them $100 and ship them to Corpus Christi. Or they round up their homeless and give them $100 and ship them to other cities. Are you aware that cities play homeless wars with each other?
I had never heard that before.
Well, they
actually,
do because it
Representative
came out in
Canales.
the testimony. And so what you're talking about is not only a TDCJ problem, is that cities, major cities, give homeless people $100 and a bus ticket and ship them to other cities. And so I'd just like this body to know that those are some of the facts that what we're living with in the state of Texas is some of the largest municipalities play games with each other to ship each other homeless. And instead of solving this problem, we're penalizing people.
Absolutely. And in fact, what we learned in this investigation into what this is all about is that the largest percentage of people we have in this transition center in the East Austin actually come from Bexar County, where they don't have a transition center because that community was able, through zoning and fighting, able to not have that in their county. So this is in large part a state-created problem, and what I'm saying is, don't make our cities pay for it when you're creating it. If the problem and if the population you're dealing with is more than half of people who are not from your locality but were formerly incarcerated and brought to your city by TDCJ, then the city should not have to give up its tax receipts, its sales tax receipts, because it's being punished for something that is the state's fault. That is the amendment. It's a matter of basic fairness, and I hope the author of the bill will support this amendment, and I move adoption.
Mr. Speaker,
Mr. Wu, for what purpose?
would the lady yield for questions?
The
I
lady
do.
yield for questions. The lady yields.
Yes.
Representative Hinojosa,
Yes.
would it be fair to say that especially people who have just left prison, that they don't have any ability to take care of themselves if they don't have a job, they don't have a home, they don't have their medicine, they're not going to be able to take care of themselves, right?
That's right.
And it's not a matter of, well, why don't you just go somewhere else? They have nowhere to go. They have no ability to go anywhere.
That's right. And in fact, I asked the question, does TDCJ have to offer them a ride back to where they came from? And the answer is no.
So for all intents and purposes, if someone spent the last 10, 15 years in prison and they're just dumped off in Austin, they're essentially stuck in Austin.
They are. Yes,
Right.
they are. And our city really has invested so much to solve this problem, but it is very expensive. Austin spends upwards of $4,000 per person, $4,000 per person to provide temporary transitional housing for Texans. But for Texans who require more permanent housing, it's about $15,000 to $20,000 a year per person experiencing homelessness. And the thing is that if we have this spigot of this from the state of formerly incarcerated people being just left in our community with no ties to the community, we will never solve the problem of homelessness.
And
in
these
Austin.
people, these former incarcerated people, they have families somewhere else. They have homes somewhere else that they might be able to go to, but because they're left here, they don't have the ability to go back to where their loved ones are, where there's family support for them, and so they become a burden on the city.
Right. When you've hit rock bottom, you need family, you need friends, you need a support network to get back on your feet. When you are dropped off in the middle of a community that is foreign to you, you can't have that help that you need. You don't often have that help that you need because you don't know anybody. And so, yes, people end up living on the streets in desperation, and it is very tragic, very sad, and Austin is doing everything we can, and cities all over the state
Ladies,
are
time
doing
has expired.
everything they can, but need some help. I move it.
The chair recognizes Mr. Capriglione in opposition.
Mr. Speaker, members, I know it's late, but I do want to talk about this amendment because I don't want anyone to accidentally vote for it. If you go and you look at this amendment, and I know folks here maybe have a hard time pulling it up, it has been this session, so I'd like you to pull up this amendment. And with all due respect to what Representative Canal says, that's not what this amendment does. In fact, what this amendment says is that the subsection, in other words, the enforcement of these camps should apply everywhere, except, and I quote, if more than 50% of the persons camping in that camp were released from prison. Literally what this amendment would do was allow only those encampments that were full of people that were released from prison, murderers and rapists. So, what I would do is when you look at this amendment and you read it, lines 5 through 8, you will realize that it is the exact opposite of the way you think it should be. This will only allow camps in Texas that are more than 50% of people that were released from prison by TDCJ and were left there from somewhere else. So with all due respect, not just no, Mr. Speaker, but no way.
Mr. Speaker,
Mr. Wu, for what purpose?
would the gentleman yield for questions?
The gentleman yield for questions.
I do.
The gentleman yields.
Mr. Capriglione, what do you want the cities to do instead?
I would like to talk about this amendment, and what I would like them not to do is
If you're rejecting
what,
this amendment,
okay, in terms of this amendment, what I would like the cities to do is nothing that this amendment says. I would like the cities to enforce this universally to everyone and not give an exception to those encampments that have more than 50% of the people that camping there released from prison. That doesn't make any sense.
so the cities, your expectation is the city disperses these people, tell them to go somewhere else, correct?
Well, if we're going to go back to this amendment, unless they're ex-cons, right?
That's very well.
What I would say is that we should vote this amendment down, and if we want to have a conversation about the merits of the bill itself, about enforcing the current law, we can have that. But I am not going to entertain the thought that we should only allow those camps full of ex-convicts.
Mr. Capriglione, you understand that the city is helping provide services, keeping an eye on people who are in these camps, making sure that they try to stay out of trouble as much as possible. We're trying to make sure that they get their medicine. You understand that if you tell them, go somewhere else, they probably will go somewhere else. They'll go into people's neighborhoods. They'll wander around somewhere else. They'll move to wherever you're not looking because they have nowhere else to go. So you would rather have people released from prison, you would rather them wander off where the city can't keep an eye on them, the city can't provide them with services, city can't provide them with medicine,
as opposed to
and go into your
camping in public
neighborhoods?
spaces near our schools and under bridges. I mean, listen, what we've all agreed in the past and we have on our budget is that we should fund and appropriate dollars to help people who are unsheltered, who need mental health, who to help them get ready to go to work, to go and get the support and assistance they have. And that we can agree on and we can have a conversation on. But since we're talking about this amendment, I would respectfully ask everyone to not vote to allow camps full of ex-cons.
So instead of that, you're going to say, send them everywhere else. Send them into the city, send them into the neighborhoods.
No, I'm not saying
Why
that
would
at
it not
all.
be
That's
better
not
to
what this
have them?
amendment says.
If
That's
the
not what
city
this
of
bill-
Austin is providing them with support and providing them with help, keeping an
There
eye
is-
on them.
there is-
If the city is trying to
I'd
do
like to
this,
answer at least one of your
but the
questions. I won't
state
remember
keeps
all of
dumping
them.
more people,
The members will refrain from speaking over each other so that the rest of the members can hear the debate.
What I would say, getting back to the amendment that's on the table, is that there isn't a single community in Texas or in this country or in this world that would be okay with this amendment.
to keep
I close.
Ms. Hinojosa, to close on the amendment.
Members, I don't want you to accidentally vote for this amendment. I want you to vote for this amendment on purpose. The author of this bill is either mistaken in his reading of this amendment or misrepresenting. What this amendment says is that the state cannot require approval from them, the first part, approval from them if they have created the problem. If they've created the problem, we can't wait for them to fix it. It is a decision of the local community first. The second part of the bill says that we get information in the report that is required in this bill. We get information about how many of those people experiencing homelessness are from TDCJ and not from the locality. And the final part of this amendment says you can't penalize us financially by taking our sales tax money if the problem that the Attorney General is alleging based on a complaint is about somebody experiencing homelessness that the TDCJ brought to our community and has created the problem. We're saying you cannot punish the cities. You cannot put the heavy hand of the state on the locality and tell you how you're going to fix it when they created the problem themselves. And you certainly should do what we can to get information so we understand the scope of this problem, because I'm telling you, in Austin, it is big.
Mr. Speaker,
Mr. Wu, for what purpose?
would the lady yield?
Will the lady yield for questions?
Yes.
The lady yields.
Representative Sosa, how is a city supposed to solve this problem if every time they relocate people, they help people get somewhere else, they help people find homes, they help people find jobs, they clear out the camps, and the next day the state drops off more?
No, we will never solve the problem. The state is trying to blame the cities, trying to micromanage and put us through bureaucratic morass when we're trying to deal with a very real problem affecting the everyday lives of people in our local communities. The state wants to say no, first we have to approve, and then, by the way, if you don't do what we want, then we're going to take your money, and by the way, we don't even want to get information about the reality of the problem that's going on. That's what you're hearing from the author of this bill right now, who is opposing the amendment, because they know this is a problem that the state is creating. The state has created a homelessness problem in our cities and does not want to take responsibility for it.
Even under this bill, even if the city dealt with it and the people kept getting dropped off, the city could still lose money because they would say, well, you didn't keep dealing with it. You dealt with it yesterday, but there's more people there. And the city's like, we can't control that.
Right. It's a never-ending problem. And really the insult to injury is that the city can't act until the state approves the plan of the problem the state created, right? So it is tying the hands of the local communities. That is what the first part of this amendment does. And really, we need help. We don't need the state making it harder for us to solve this problem and taking away sales taxes that we need to do this work in our local communities. And I move adoption.
Ms. Hinojosa sends up an amendment. The amendment is not acceptable to the author. This is a record vote. The clerk will ring the bell. Show Mr. Capriglione voting nay. Show Ms. Fairley voting nay. Have all voted? Have all voted? There being 54 ayes, 90 nays, the amendment fails to adopt. The following amendment, the clerk will read the amendment.
Amendment by Busey.
Chair recognizes Mr. Busey.
Hey, Mr. Speaker, members, the purpose of this amendment is to give cities more capacity to address the problems identified by the Attorney General and the residents of the city without impacting the 90-day timeline. And I believe it's acceptable to the author, and I move adoption.
Mr. Busey sends up an amendment. The amendment is acceptable to the author. A record vote has been requested. The clerk will ring the bell. Show Mr. Busey voting aye and Mr. Capriglione voting aye. Show Ms. Fairley voting aye. Have all voted? There being 122 ayes, 20 nays, the amendment is adopted. The following amendment, the clerk will read the amendment.
Amendment by Flores.
Chair recognizes Ms. Flores.
Thank you, Mr. Speaker. Members, we can all agree that homelessness is an issue that must be addressed at every level of government. I completely agree with the bill's author that this means we cannot stand by when local governments refuse to take action despite calls to action from their constituents. However, as written, this bill fails to define what that action should be. The words "shall take an action to resolve the complaint" could mean anything from issuing citations to individuals that we all know cannot afford a meal, much less a fine, to forcefully removing homeless individuals without providing them with anywhere else to go. This amendment will clarify what actions a local entity must take to avoid being deemed a violating local entity and ensures that those actions are based on what the evidence tells us actually helps to reduce homelessness and subsequently homeless encampments. In response to a complaint about an illegal homeless encampment, a local entity must make a reasonable effort to connect the violating individual with housing resources, whether that be directing them to a legal encampment, providing them with resources from an appropriate nonprofit, or even helping them reconnect with family. These are tactics that we know work. These are methods that programs focused on homelessness, who understand it the best, are asking us to do. A comprehensive review of studies on Housing First programs indicates that focusing on finding housing for homeless individuals decreased homelessness by 88% and improved housing stability by 41%. Meanwhile, the providers who frequently interact with homeless individuals have repeatedly come out and stated that property seizures and arrests only decrease the trust that homeless individuals have in the government, making them less receptive to attempts to provide them with resources in the future. Let's look out for our constituents, those with and without a place to sleep at night, by instructing local governments to respond to these encampments with evidence-based solutions. I move passage.
Mr. Capriglione in opposition.
Mr. Speaker, members, some of this is already being done, and some of it really hasn't been fleshed out and would be very costly to locals. For those reasons and more, I oppose.
Mr. Speaker.
Mr. Wu, for what purpose?
Would the gentleman yield for questions?
Will the gentleman yield for questions?
Yes. Yes.
The gentleman yields.
Thank you. Mr. Capriglione, I thought for sure you would accept this. Because
Did you really?
This is exactly what you want. You're telling people, you're telling cities, you cannot have these people here in these encampments. They need to go where they're supposed to go. This provision says you must tell people where they're legally supposed to go.
Well,
and instead of going somewhere else that they're not supposed to be.
Because I'm more than happy to do the A part of it. So what happened during the last, and what's in already the law in 2019, is some of those things that you just mentioned are already required. So that part is completely unnecessary.
Which part is already required?
Well, the part about letting people know and how to get help and how to get assistance, that's already in statute. The part that isn't, that's being added to this, is to require housing and alternative housing 150 days after the date the complaint is received. First of all, that's completely untenable and impractical because it is unlikely for us to know all the people that were subject of that camping 150 days after, because as you can tell, and as you know, they're unsheltered, so that would A, be impossible to do, and B, an expense to the localities, and so it would be an unfunded local mandate. I don't know how expensive, and neither do you, and neither does the author of this amendment. So for those reasons and more, I oppose this amendment.
The amendment says a reasonable effort to connect each person. That could be as little as handing someone a card. Here are the list of shelters
again,
that are in place.
Well, no, it's not handing someone a card. It says making an effort to connect each person who is the subject of the complaint with alternative housing. So no.
A reasonable effort to connect them, like give them a phone number, give them a person to talk to, tell them, hey, the local shelter is at this location. I don't understand why that's so hard. Like, instead of suggesting that we do it in the law, why can't we say in the law, just do it? Tell them where they're supposed to go legally instead of being harassed and arrested every single time they go somewhere else.
I disagree with your understanding of the amendment.
That's
Thank
very
you.
unfortunate.
Ms. Flores, to close on the amendment.
I'll read what the amendment says so that we can understand it. It says that instead of taking action to resolve the complaint not later than the 90th day after the date the complaint is received, it substitutes the following. Make a reasonable effort to connect each person who is the subject of the complaint with alternative housing not later than the 150th day after the date the complaint is received, including by 1, providing the person information regarding locations where the person may legally camp and information regarding transportation to that location. 2, assisting the person with contacting a family member or other person to assist the person in vacating the campsite. And 3, assisting the person with contacting an appropriate government agency or nonprofit organization that provides housing assistance within the political subdivision. I myself have helped in an individual who I've seen in my park who had nowhere to go, super cold weather outside, and was just, helping him with giving him some food and something warm and dry to wear, and telling him, here are some numbers, here's the local shelter. You don't have to sleep in the park or under a bridge in the freezing cold. You need to go, and here's this shelter, and here's who helps, and here's where it's located. So, yes, I will yield to the gentleman with a question. Mr. Speaker?
Mr. Wu, for what purpose?
Mr. Speaker, would the lady yield for questions?
Yes, I will
The
yield
lady
for a
yields.
question.
Representative Flores, to be absolutely clear, when this amendment says make a reasonable effort, it goes ... by, including by, right? The reasonable effort are these three things, correct?
Right,
Number one, tell them where they're supposed to go legally.
right.
Tell them where they're not supposed to go legally, right?
Right.
Tell them where, if you can't camp here, if you can't be here, where are you supposed to go?
Right.
Isn't
Exactly.
that what Mr. Capriglione wants?
I thought so, and I think these are pretty reasonable steps to take. As I said, I've taken them as a person myself, so people that are in the position to help the homeless can do these things.
If they're already not supposed to be there, and people don't want them in their neighborhoods, don't want them somewhere else, wouldn't we want them to know where they're legally supposed to go?
Absolutely, as any compassionate person would. You would want to make sure a person had shelter.
I mean, not even, even without going into compassion, if you just want public safety, you want this problem to be dealt with, would you not want people who are homeless, who are unsheltered, to go where they're supposed to go, to where the people are helping them?
Absolutely, absolutely. But
The second-
I always lead with compassion first.
The second point, if somebody says, hey, I have a family member that can come pick me up, shouldn't we just say, hey, let me help you find a phone that you can call that person so they can come pick you up and you don't have to be here anymore? Isn't that what we want?
Absolutely.
How hard is that?
It shouldn't be that hard.
And the third one, contacting an appropriate government agency or nonprofit. Couldn't that just be, hey, here's a card with whatever nonprofit is in this area or the state agency that is in charge of helping you?
Absolutely, absolutely.
Why is that so difficult?
It shouldn't be difficult
It
at all.
shouldn't be. And on a bill that says on a law that says we will give you criminal charges if you don't leave, shouldn't we make sure that the people that we don't want to have to arrest know what they're supposed to do so they don't get arrested again?
Absolutely right. And I think we should. I mean, these are very reasonable steps, and I think we should be doing this.
I'm just floored. This is exactly what this bill and this author calls for, and he's not accepting it.
Members, these are perfectly reasonable steps for a local entity to take, and I say we lead with compassion, and I please ask for that you vote yes on this amendment. Thank you.
Ms. Flores sends up an amendment. The amendment is not acceptable to the author. This is a record vote. The clerk will ring the bell. Show Ms. Flores voting aye, Mr. Capriglione voting nay. Ms. Fairley voting nay. Have all voted. There being 57 ayes, 87 nays, the amendment fails to adopt. The following amendment, the clerk will read the amendment.
Mr. Speaker,
Mr. Tinderholt, for what purpose?
parliamentary inquiry.
Please state your inquiry.
Is the Speaker aware that this bill's taken over 40 minutes so far?
Chair is not advised.
Mr. Speaker, parliamentary inquiry.
Please state your inquiry.
Would the Speaker consider it dilatory for members of the House to stall and chub throughout the process so that other people's bills, important bills for senators, important bills for, I don't know, people's districts, are being killed?
Not a proper parliamentary inquiry.
Mr. Speaker, parliamentary inquiry.
Please state your inquiry.
If there's a call to question, what is the maximum number of minutes that are allowed to be spoken during the entire process on any given bill? If I were to do a call to question or someone were to call it on any given bill, what is the maximum amount of time that can be spent speaking for and against?
After the previous question is ordered, the author of the proposition gets to close.
Mr. Speaker, parliamentary inquiry.
Please state your inquiry.
Would that be 10 minutes?
Yes.
And would it be 10 minutes pro, 10 minutes con?
Just the author of the proposition.
So, Mr. Speaker, parliamentary inquiry.
Please state your inquiry.
Does that mean that if someone did that motion on any given bill or all bills, moving forward, that the maximum amount of time to be spent on a bill would be somewhere between 10 and 20 minutes?
That is a hypothetical inquiry that the chair will not entertain.
Thank you very much, Mr. Speaker.
Following amendment, clerk read the amendment.
Amendment by Jones of Dallas.
Ms. Jones.
Thank you, Mr. Speaker. Members, this amendment ensures that we, as a state government, are not unnecessarily meddling in the affairs of well-functioning local government by limiting the authority of the Attorney General and DPS to enforce Section 48.05 of the Penal Code to the local entities that are in violation of the requirements in this bill. I do not disagree with the author that if local governments are unwilling to respond to the complaints of their constituents, that we may step in to give Texans the support they need. However, if a local entity is following the law, if they are successfully managing any encampments within their jurisdictions, if they have a system that works between them and their constituents, who are we to interfere with that? Why should we punish compliance with excessive control? Local governments can best manage local problems because they know their area and people better than any state or federal government could ever. Anyone who supports the freedom of local government and opposes state interference should understand the importance of this limitation and vote in favor of this amendment.
Chair recognizes Mr. Capriglione in opposition.
What does it do? Did you say what it does? Yeah, I did. Let me read the amendment. All right, so
Mr. Speaker, members, I obviously just got this right now, but by looking at it, what it does is it removes the ability for us to enforce the current laws, and that's the whole entire purpose of this bill. And again, what's happened, members, as you can see, is that while we all in this legislature approve this law, the enforcement is not happening, and so any efforts to dilute that is not acceptable, so I say vote no.
Mr. Jones to close on the amendment.
I move adoption.
Mr. Jones sends up an amendment. The amendment is not acceptable to the author. This is a record vote. The clerk will ring the bell. Show Mr. Capriglione voting nay. Show Ms. Fairley voting nay. Mr. Tinderholt voting nay. Have all voted? Have all voted? There being 57 ayes, 87 nays, the amendment fails to adopt. Members, we're waiting on an amendment. The following amendment, the clerk will read the amendment.
Amendment by Troxclair.
The chair recognizes Mr. Troxclair to explain the amendment.
Right now. Mr. Speaker,
Ms. Garcia, for what purpose?
I raise a point of order against further consideration of the Troxclair Amendment under Rule 11, Section 2 on the grounds that it is not germane to the bill.
Please bring your point of order down front. The point of order is withdrawn. The amendment is withdrawn. Anyone else wishing to speak on, for, or against Senate Bill 241? The chair recognizes Mr. Capriglione to close on the. Mr. Wu, for what purpose?
Mr. Speaker, I raise a point of order against further consideration of SB 241 under Rule 8, Section 1, Article 3, Section 35 of the Texas Constitution on the grounds that the caption fails to give reasonable notice of the subject of the proposed measure.
Please bring your point of order down front.
Point of order is withdrawn. Mr. Capriglione for a motion.
Okay, Mr. Speaker, I move to postpone further consideration of Senate Bill 241 until June 3rd, 2025.
Members, you've heard the motion. Is there any objection? Chair hears none, so ordered. Chair lays on second reading of Senate Bill 1718. Clerk, read the bill.
SB 1718 by Sparks, relating to the eligibility of the National Rifle Association annual meetings and exhibits of other annual events of the National Rifle Association for funding under Major Events Reimbursement Program.
Mr. Guillaume.
Thank you, Mr. Speaker. Members, this bill expands eligibility under the Major Events Reimbursement Program to include the National Rifle Association's annual meetings and exhibits, as well as other annual events hosted by the NRA. Move passage.
Following amendment, the clerk will read the amendment.
Amendment by Goodwin.
It's a good one.
Thank you, Mr. Speaker. Members, just this weekend, we remembered the 3-year anniversary of the tragedy at Robb Elementary School in Uvalde. 19 children and 2 teachers were taken from us, from their families, their classmates, their community, and from Texas. Out of that devastation, those families formed a nonprofit organization called Lives Robbed. Started by Kimberly Mata Rubio, Gloria Casares, and Veronica Mata, who have worked tirelessly to bring awareness and advocacy to gun violence prevention. Lives Robbed is a group made up of people who have had every reason to walk away, but instead formed a gun violence prevention organization. They chose to speak up, they chose to act, they chose to gather. This amendment adds Lives Robbed to the list of organizations whose public events can be eligible for reimbursement under the same program that this bill expands, the Major Events Program. If we are willing to include the National Rifle Association, a national lobbying group that actively influences this legislature, then we can also
Mr.
include...
Governor Hawkins, for what purpose?
Would a general yield for
Gentlelady
questions?
yield for questions?
In just a minute.
Not at this time.
Then we can also include a nonprofit founded by grieving Texas families trying to build something better out of what they have lost. The NRA didn't stand with these families. The
Mr.
NRA
Speaker.
lobbied against the
Mr. Kane, for what purpose?
the very reforms that may have made our schools and our children safer. Lives Robbed brings people together through remembrance, civic engagement, and public advocacy. Their gatherings are deeply rooted in Texas and grounded in service and healing, not partisanship. And on today of all days, we must say with clarity, we will not put these families behind the NRA. We will not elevate political power while leaving public pain unseen. We have a choice in this.
Mr. Speaker.
Mr. Kane, for what purpose?
I raise a point of order against further consideration of this amendment under Rule 11, Section 2 on the grounds that the amendment is not germane to the bill.
Bring your point of order down. Point of order is withdrawn. Amendments withdrawn. Following amendment, the clerk will read the amendment.
Amendment by Goodwin.
Ms. Goodwin.
Sorry. Thank you, Mr. Speaker. Members, this amendment is targeted and clear. If the NRA wants taxpayer dollars to help fund its convention in Texas, the local government must vote to approve it in a public hearing. This doesn't block the event. It doesn't even block reimbursement. It just says that the city council or county commissioner's court, the people closest to the community, must hold a vote in a public hearing. Because what happened the last time the NRA came to Texas? Dallas saw protests, increased policing costs, national controversy, and local residents were never asked. This amendment gives communities the basic dignity of being consulted before a highly politicized event is publicly subsidized with their own tax dollars. And make no mistake, the NRA is not just another trade group. It's a lobbying organization that scores our votes and campaigns in our elections. If it wants a piece of public funding, it should have to face the public. I urge you to support this amendment. Let's bring these decisions closer to the people who live with the consequences. Move adoption.
Mr. Guillen in opposition.
Thank you, Mr. Speaker. Members, this amendment is redundant as the goal of it is already covered in the Government Code, Chapter 478, Subchapter C. That means that the goal of this amendment is already in an existing statutory prerequisite of the program. I therefore move to table the amendment.
Ms. Goodwin to close.
So we're saying that something that's very different from the other events in the major events category is going to be allowed to be reimbursed by our...
Mr. Speaker,
Mr. Perez, for what purpose?
does the gentlelady yield?
General yield for questions?
Yes.
She yields for questions.
Representative Goodwin, I mean, you were talking about the differences on that this isn't just a tourism draw, that the NRA actually lobbies in campaigns. Can you talk a little bit more about that distinct difference into why you're proposing this amendment?
Yeah, I mean, most of the events in the major events fund law are sporting events, football, soccer, Olympics, basketball, but the NRA is very different. They have a very strong view, obviously, on guns, and I think local communities, it's not like sporting, where local communities typically all get behind that sporting event. They may choose different sides that they are rooting for, but the NRA, there's a lot of people who don't support what they're behind, the policies that they want, and they spend money in campaigns. It's just a very different type of event.
And Representative, I don't know if you, specific to your amendment, but do you know how much the NRA would be receiving potentially under this legislation?
That I'm not sure.
But now, just to be clear, your amendment does not prohibit the NRA from coming to Texas or from participating in this program.
Absolutely. In fact, you know, the argument could be made that they have been here many times before. I believe in 2024, 2022, 2018, 2005. So honestly, the NRA has had many annual events in Texas anyway. They don't need us to pay for them to come here.
And simply just your amendment would just give the public an opportunity to have a voice in the process.
Absolutely, and I think that we should give the community that choice because, like I said, when they came to Dallas, it cost the city quite a bit of money to have extra law enforcement and to deal with the protests.
Okay. Thank you, Representative.
Thank you. I move adoption.
Questions on the motion to table, record vote, clerk ring the bell. So Mr. Guillen voting aye, Mr. Goodwin voting no. Mr. Verdell voting aye. Have all members voted? Have all members voted? 86 ayes, 53 nays. The motion to table prevails. Following amendment, clerk will read the amendment.
Amendment by Howard.
Ms. Howard.
Thank you. Mr. Speaker,
Mr. Kane, for what purpose?
raise a point of order against further consideration of this amendment under Rule 11, Section 2 on the grounds that the amendment is not germane to the bill.
Bring it down front. The point of order is withdrawn. The amendment's withdrawn. Anyone wish to speak on, for, or against?
Mr. Speaker,
Ms. Goodwin, for what purpose?
I raise a point of order against further consideration of Senate Bill 1718 under Rule 4, Section 32C1 on the grounds that the bill analysis is material or substantially misleading.
Bring your point of order down front.
You got the BMP?
Ms. Goodwin raises a point of order against further consideration of the committee substitute for Senate Bill 1718 under Rule 4, Section 32C1 on the grounds the background and purpose statement in the bill analysis is substantially materially misleading. The background and purpose states the bill author informed the committee that the NRA is not being included in the Major Events Trust Reimbursement Program, discouraged the NRA from hosting events in Texas. Ms. Goodwin argues that this is misleading since NRA has recently hosted events in Texas and may host events again in the future. However, the word discouraged does not mean that the organization would never come to the state. It is self-evident that not having the benefits of being included in the Major Events Trust Fund program would make it less likely that they would come to this state. Accordingly, the point of order is respectfully overruled. Mr. Gann. Nope. Ms. Goodwin in opposition.
Mr. Speaker, members, this weekend was the anniversary of the mass shooting at Robb Elementary School in Uvalde. 19 children and 2 teachers were killed in their classroom in our state. And today, on this day, we are being asked to vote on a bill that would use taxpayer dollars to help fund the National Rifle Association's convention. Let me say that again. On the anniversary of Uvalde, we are voting to subsidize the NRA. The same NRA that lobbied against raising the age to purchase assault-style weapons. The same NRA that opposed every single piece of gun safety legislation these families begged us to pass. The same NRA that still gives elected officials a grade based on how well they block reform. And now they want a check from Texas taxpayers. Senate Bill 1718 would make the NRA's annual meeting eligible for funding under the Major Events Reimbursement Program, a fund originally created to attract major sporting events and conferences, not partisan lobbying groups. The NRA is not neutral. It is not economic development. It is political machinery. We are not talking about Formula One. We are not talking about the Super Bowl. We are talking about subsidizing a group whose central mission is to shape our laws, including the very laws that failed the children of Uvalde. I can't vote for that. And I ask you from the bottom of my heart, not just as a legislator, but as a parent, as a Texan, to ask yourselves what message this vote sends on this day in particular. Vote no on SB 1718.
Mr. Speaker,
Ms. Rodriguez-Ramos, for what purpose?
will the gentlelady yield?
Gentlelady for questions?
Yes.
She yields for questions.
Thank you, Representative Goodwin. So in this bill, we're asking, the NRA is asking for reimbursement from the Major Events Reimbursement Program from the
That's
state of
correct.
Texas. And were you aware that in 2021, the NRA filed for bankruptcy?
Yes.
And were you aware that their bankruptcy case was dismissed by the court because it was a bad faith filing?
I wasn't aware of that.
Yes, and were you aware that the court said that NRA was trying to gain an unfair advantage and avoid regulations?
That doesn't surprise me.
And that the NRA was not only trying to avoid regulations, but escape accountability. And in fact, they were using NRA funds for their own leadership's own personal piggy bank. Were you aware of that?
I had heard that story. So this does not sound like the kind of organization that we should be funding.
Right, and so it sounds like the NRA had no problem spending their own money for their own lavish trips, in fact, trying to file bankruptcy and getting denied by the bankruptcy court because it was a bad faith filing. And it appears now the NRA is asking us, the Texas taxpayers, to fund their lavish trips and their lavish exhibits, and they want us, the taxpayers of Texas, to fund them when they themselves could not even, when they themselves are using their own money in irresponsible ways. Were you aware of that?
Yeah, and you know what? I find it really insulting, to be honest.
Absolutely. I think it's insulting, too, when we spent an hour debating homelessness in Texas, but yet we're talking today about giving the NRA money when they themselves are wasteful and not being held accountable in their own wasteful spending. So thank you so much for your opposition speech, and I too want to protect taxpayer dollars for taxpayer purposes and not to fund a political group that is wasting their own money and now wanting to waste ours. Thank you so much.
Thank you, Representative.
Mr. Guillen.
Move passage.
Question occurs on passage third reading. Record vote. Clerk ring the bell. Mr. Verdell voting aye. Mr. Morgan voting aye. Mr. Canales voting aye. Mr. Kane voting aye. Mr. Schatzline voting aye. Have all members voted? Have all members voted? 93 ayes, 52 nays. Senate Bill 1718 passed the third reading. Chair lays out Senate Bill 140. Clerk read the bill.
SB 140 by Hall relating to certain definitions relating to the regulation of and private rights of action arising from certain solicitation-related communications.
Mr. Anchio.
Thank you, Mr. Speaker and members. This is a bill that your constituents are going to thank you for. This bill that Senator Hall has drafted seeks to address an issue that gives us all universal and bipartisan animosity, and that is scam calls and texts and messages. This bill is simple. It simply takes the definition under current statute from Chapter 304 and places it in Chapter 302 so that you do not get more telephone calls, texts, and messages that are unwarranted or unsolicited. Move adoption.
Question occurs on passage third reading. All those in favor say aye. All those opposed say nay. Ayes have it. Senate Bill 140 passed third reading. Chair lays out on second reading Senate Bill 2055. Clerk read the bill.
SB 2055 by West relating to the participation in Texas Leadership Scholars Program.
Dr. Lulani.
Mr. Speaker, members, SB 2055 is a cleanup bill for the Texas Leadership Scholars Program, which was passed into law last session. This bill clarifies the legislative intent that all higher education institutions are eligible for Texas Leadership Scholars Program. I move passage.
Question occurs on passage third reading. All those in favor say aye. All those opposed say nay. Ayes have it. 2055 passed third reading. Chair lays out on second reading Senate Bill 2075. Clerk read the bill.
SB 2075 by Zaffarini relating to the establishment, powers and duties, terms, and governance of certain advisory bodies for programs administered by the Texas Department of Licensing and Regulation.
Speaker Phelan.
Thank you, Mr. Speaker, members. Before I begin this layout, I just want to give a warm, heartfelt congratulations to the sponsor of this bill, the author of this bill, Senator Zaffarini, who on May 15th casted her 75,000th consecutive vote in the Texas Senate. She's passed over 1,041 bills since 1987. I feel like I've passed about 10 of hers this session. She has 307 filed this session and 65 that are still alive. 65 bills still moving through the process. And so it's been great to work with her this session. And this bill is one of hers that deals with the uniformity across all statutes dealing with the advisory councils and advisory boards within TDLR, and just modernizes them and redefines them. And I move passage.
Question occurs on passage third reading. This is a record vote. Clerk ring the bell. Have all members voted? 106 ayes, 33 nays. Senate Bill 2075 passed third reading. Chair lays out on third reading Senate Bill 2018. Clerk read the bill.
SB 2018 by Paxton relating to strong family credit against certain taxes for entities that contribute to certain organizations.
Mr. Harris.
Thank you, Mr. Speaker. Members, this Strong Families Tax Credit. I do have an amendment.
Following amendment, clerk read the amendment.
Amendment by Harris.
Mr. Harris.
Thank you, Mr. Speaker. Members, this amendment removes HHSC as a certifying organization and replaces it with the One Star Foundation. I move adoption.
Harris sends up an amendment. So to the author. It's a record vote. Clerk ring the bell. Have all members voted? 107 ayes, 33 nays. The amendment is adopted. Mr. Harris.
Move passage.
Question occurs on passage third reading. Record vote. Clerk ring the bell. Have all members voted? Have all members voted? 92 ayes, 42 nays. Senate Bill 2018 passed third reading. Chair lays out on second reading. Senate Bill 1534. Clerk, read the bill.
SB 1534 by Zaffarini relating to a study and report by the Texas Higher Education Coordinating Board regarding health physics education in this state.
Mr. Lambert.
Thank you, Mr. Speaker. Members, if Texas is committed to being the leader in nuclear energy in the future, we need a workforce to support that industry. Senate Bill 1534 would create a study to address workforce development in the growing fields of nuclear energy and radiological safety. Move passage.
Question occurs on passed third reading. It's a record vote. Clerk, ring the bell. Vasuit voting no. Have all members voted? 106 ayes, 38 nays. Senate Bill 1534 passed third reading. Chair lays out on second reading. Senate Bill 1567. Clerk, read the bill.
SB 1567 by Betancourt relating to the authority of the home rule municipalities to regulate the occupancy of dwelling units.
Mr. Vasuit.
Mr. Speaker,
Scriven Hawkins, for what purpose?
will the gentleman yield?
Gentlemen, have for questions?
Sure.
Yes, he yields for questions.
Thank you, Representative Pursuit. So when you talk about the local municipality limiting the number of folks that can live in the home, could you explain that a little bit better?
Sure. It's kind of modern day redlining. So what's going on is in some cities in the state, and it's most pronounced in cities that are small and mid-sized with a mid or large-sized college campus, but it can happen in other areas. What they're doing is they've adopted ordinances that discriminate against college students to prohibit them from living together, regardless of whether or not the house has enough space for them. And I'll give you an example. Some of these cities have adopted ordinances that say no more than 2 unrelated people can live in a house in the city. And what happens, particularly for college students or young working professionals who can't afford a house, to buy a house, or maybe there's not an apartment available and they want to be able to pool their resources together, they'll go into a 3-bedroom, 2-bath house. 2 of them can live with each other, but their third friend can't because they're not related. Whereas next door, there may be 6, 7, 8 people in the exact same type of house, same square footage, same number of bedrooms, and the only difference, they're related. That's it. So that's the problem I'm trying to solve, is to make sure that people, particularly those that are young working professionals or our college students, have access to affordable housing. And these types of restrictions, this kind of form of redlining, prohibits them from doing so.
So how do you determine a group of friends versus a frat house?
Well, the key deal there is, one, frat houses are subject to a separate governing statute. And 2, nothing in the bill prohibits a city from enforcing any other ordinance. The bill does.
So do you do carve-outs in here?
So,
I wasn't able to find any.
Yeah. So there are carve-outs. Let me tell you. Let me explain really briefly what the bill does and what it doesn't do. The only thing the bill does is for any city that it applies to, and I'm going to come back. That's one carve-out in a second. So any city it applies to, you cannot impose an occupancy restriction based off of age, familial status, occupation, relationship status, or whether they're related within a certain degree of affinity or consanguinity. That's it. That's the only prohibition. And the exceptions, the carve-outs from that are, 1, the bill only applies to university towns right now, and there's going to be some amendments that are going to come that are going to narrow it even further. And 2, any other type of ordinance, zoning restriction, that doesn't limit occupancy on those 5 factors is allowed.
So I want to be clear.
Yes.
You're limiting this to college towns so that you can ensure that a group of friends, a group of students could live in a dwelling. Is that what you're attempting to do?
My principal goal when I filed the House companion of this was to ensure that cities are not discriminating against people using characteristics that have no relation to the goals the cities have.
So 2 10-year-olds can live in the same dwelling?
Well, I would hope so. Otherwise, Mom and Dad are going to have to get rid of one kid.
The parents pass away, something happens, you're saying 2 10-year-olds, you got age in here.
Well, that's a whole host of other issues, Ms. Gervin Hawkins, not the least of which is, of course, a minor cannot be home alone unattended. It's a felony. So, but if you had 2 18-year-old adults that were going to school or working, wanted to pool their resources, they should be able to do so. The key thing here is that cities ought to be able to enforce ordinances that ensure the private property rights of neighbors are
In the interest
protected,
of
like
time,
noise and
Representative.
traffic, etc. They don't need to enforce familial status to do so.
All right, in the interest of time, we're focusing more on our university students.
Sure.
Thank you.
Thank you, Ms. Hawkins.
And for what purpose?
Well, gentlemen, you have for
Gentlemen,
questions.
you look for questions?
Certainly.
Mr. Rassout, do you have some amendments you're going to add to the bill?
We do. We have 3 that are coming right up.
Okay, I'd like to take a look at those before
Sure, absolutely.
doing anything hostile.
Let's lay them out. I've got one perfecting to start with.
Following amendment, clerk read the amendment.
Amendment by Vasu.
Mr. Vasu.
Thank you, Mr. Speaker.
Mr.
Members.
Speaker,
Ms. Wiener, for what purpose?
I raise a point of order under Rule 11, Section 2, against further consideration of the Vasu amendment on the grounds that it is not germane.
Bring your point of order down front. Point of order is withdrawn. Mr. Pursuit, you may continue.
Thank you, Mr. Speaker. Members, all this bill does, the bill already has a property owner action. This just conforms the property owner action to mirror the language that we've been putting in all the other bills, like SB 15 and so on. It just simply says they can bring an action, that they can get injunctive relief, they can get their attorney's fees, which is already in the bill, and that the appeal goes to the 15th. That's it. Move adoption.
Question occurs on the Vasu amendment. Mr. Bryan, for what purpose?
Mr. Speaker, will the gentleman yield for question?
Gentlemen, for questions?
Gentleman yields.
He yields.
Would you just slow down and tell us now what does the bill do if your amendment's adopted?
If this amendment is adopted, the only change is that it clarifies that you can get the 3 categories of relief I think you could probably already get under the existing law: declaratory, mandamus, or injunction, and that an appeal goes to the 15th. That's really all it does.
Oh, okay. Are you going to do anything to the bill to change the cities that are covered by the bill?
Yeah, that's coming up.
Thank you.
Move adoption.
Mr. Vasu moves adoption. Questions on his amendment. Record vote. Clerk, ring the bell. Mr. Vasu voting aye. Tepper voting aye. Have all members voted? Have all members voted? 93 ayes, 45 nays. The amendment's adopted. Following amendment, clerk will read the amendment.
Amendment by Schofield.
Mr. Schofield.
Mr. Speaker, members, the underlying bill is designed to apply to municipalities that have a university. So this defines a university as an institution of higher education, as is already defined in the code, and then it limits it to campuses of more than 5,500 because kids aren't living at smaller schools than that anyway. I would move adoption.
Schofield sends up amendments acceptable to the author. It's a record vote. Clerk, ring the bell. Vasu voting aye. Tepper voting aye. Have all members voted? Have all members voted? 113 ayes, 24 nays. The amendment is adopted. Following amendment, clerk will read the amendment.
Amendment by Tepper.
Mr. Tepper.
Thank you, Mr. Speaker. This amendment limits the bill to only a home rule municipality with an institution of higher education with less than 250,000 people. This would bracket out Houston, San Antonio, Dallas, Fort Worth, Austin, El Paso, Arlington, Corpus Christi, Plano, Lubbock, Laredo, and Irving. Move adoption.
Ms. Lawson, for what purpose?
Will the member yield for a question?
Gentlemen, yield for questions?
I will.
Yields for questions.
Will this bracket out Stephenville?
What is the population of Stephenville?
22,000.
No.
Thank you.
Mr. Tepper sends up an amendment. It's acceptable to the author. It's a record vote. Clerk, ring the bell. Massoud voting aye. Tepper voting aye. Have all members voted? Have all members voted? 114 ayes, 24 nays. The amendment is adopted.
Is that it for amendments? Mr. Speaker,
So knows for what purpose?
will the gentleman yield for a question?
Gentleman yields for question.
Mr. Vasut,
Yes.
to close on his bill. Ms. Hinojosa, for what purpose?
Will the gentleman yield for a question?
Gentleman, yield for questions.
Gentleman yields for
Yes, he'll yield for questions.
Representative Vasut, did you just agree to amendments that bracketed out your own district for your
No.
bill? What is the bracket that is now after these two amendments?
All right.
What is this bill bracketed to?
This issue is predominantly occurring in small and mid-sized communities with significant college campuses. So Pearland is in my district and will be covered by this. You don't really see this issue in towns with a 1,000 student community college because one, they're commuter schools, they're not university schools, so you're not having this issue there. You would have had this issue in the city of Austin, but the city of Austin is one of the few towns that took their unrelated ordinance away. And so this doesn't apply to Austin. We don't have an issue there. Houston doesn't have an ordinance. Dallas doesn't have an ordinance. And the large communities that do have so much available housing that it's less of an issue. I've not received any complaints from Lubbock, from Fort Worth, and otherwise. But the complaints have come, and where the rights are being deprived are in these small and mid-sized communities with mid-sized and larger universities.
So, and I understand the rationale for your bill. I voted for your bill. I don't understand now, though, that you've added the amendment to go to the 15th court, how that will impact my city, since my city has an ordinance that does this. If there is some allegation, now that my city is violating the new state law, now my city is put in the 15th court, whereas it wasn't before. Is that correct?
Well, what I would say is that the way that we have been structuring these appeals from municipal action have been to the 15th because it is uniquely situated to deal with kind of these agency interpretations. It's a specialty court. As we know, we may be rehashing the arguments from last session. But that was the reason for that. That was language that was requested.
I understand that there's a rationale for sending everything to the 15th court that is affecting our governments. It's what happened to the lawsuits that the school districts brought against the state on the accountability system, and the 15th court overruled the lower courts. You have essentially all Abbott appointees overseeing the lawsuits against the state at this point. I don't think it's good. I think most Texans wouldn't think it's good. I'm suspicious of now putting my city in the hands of a 15th court that is not an elected court at this point. And so while I was in support of your bill, I do now have concerns because it's putting my city in that jurisdiction, in that court.
What I would note, I think from your district and the area that it represents, I think now, one, to start with, I don't think your city would have ever violated because they don't have this ordinance, but two, they've been bracketed out. So I don't think it would impact your city at all. Thank you.
Dollars for what purpose?
Does the gentleman yield?
Gentleman, you have questions?
Absolutely.
And I'm sorry, Representative Asu, I
was kind of also for your bill, and now I'm really confused after this and listening to the conversation, and I'm not a lawyer. So, and I'm also, it's midnight and I'm really tired, and I guess I just
You
want to,
bet.
if I go home and I get in trouble, I just want to know what I can explain
So-
to what we're doing here. Sorry.
El Paso's not in the bill.
But something about the courts now, we would be overseen by a different court?
No, it is that an appeal from a decision relating to a violation of this law, again, would not apply to El Paso, so it has nothing to do with your district, but an appeal from a violation of this law would go, like various other appeals relating to agency actions or city actions, would go to the 15th Court of Appeals. That's the only change.
And if you hadn't had done that, what would have been the alternate direction?
The alternate direction would be an appeal. Well, it depends, of course, on the claim, because the 15th does have jurisdiction, right, on certain claims, right? But depending on the claim, it might have gone to the Court of Appeals for the particular region, if applicable.
Okay. Thank you.
You bet. So, members, what this is simply about is making sure that we're not discriminating against people with housing for something that has nothing to do with anything. If you want to regulate noise, regulate noise. Traffic, regulate traffic. Occupancy, regulate occupancy, but don't discriminate on the basis of how people are related. Move passage.
Question occurs on passage. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 96 ayes, 44 nays. Senate Bill 1567 passes third reading. Chair lays out on second reading Senate Bill 785. Clerk, read the bill.
SB 785 by Flores relating to the regulation of the new HUD code manufactured housing.
Mr. Guillen.
Thank you, Mr. Speaker. Members, this is a small but important step toward
Mr. Speaker?
addressing...
Mr. Griffin-Hoggins, for what purpose?
Gentlemen, you?
Gentlemen, yield for questions?
Yes.
Yields for questions.
Are you saying that manufactured housing could go in any neighborhood?
No.
Then define it, because what I'm hearing, reading is the zoning's issues will be thrown out the window.
It's just making sure that they designate an area in the city for them to have them.
So if they designate a area or a tract, but they still have to go through the regular zoning process. So a developer can't just come and say, I'm zoning this for manufactured housing. They will still have to go through the local municipality zoning process.
Absolutely.
Thank you, sir.
Yeah. Members, this is a small but important step toward addressing the challenge of housing affordability for working Texans. Move passage.
Following amendment. Clerk will read the amendment.
Amendment by Guillen.
Guillen.
Thank you, Mr. Speaker. Members, this amendment clarifies requirements for the city and extends the time frame for deed restrictions by 1 year. It's acceptable to the author and a move.
Ms. Weiner, for what purpose?
Will the gentleman yield for a
Gentlemen, yield
question?
for questions?
Yes.
Yields for questions.
Yeah, Representative Gain, I apologize. It's taken a moment to pop up. Can you walk through the amendment again?
Yeah, so it strikes subsection G2 on page 2 of the bill, removes the term substantial from subsection G3 on page 2 of the bill, and it changes 2025 to 2026 on line 10 of page 3 of the bill. So the first two increase discretion by the municipality, and the latter gives residents and developers the ability to change their deed restrictions after the enactment of this bill.
Okay, thank you.
Move adoption.
Guillen says of amendment. Said will the author. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 109 ayes, 24 nays. The amendment's adopted. Mr. Guillen to close.
Move passage.
Question occurs on passage third reading. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 83 ayes, 51 nays. Senate Bill 785 passed third reading. Chair lays out on second reading Senate Bill 1233. Clerk, read the bill.
SB 1233 by Hancock relating to information regarding prenatal palliative care, creating administrative penalty.
Ms. Swanson.
Thank you, Mr. Speaker. Members, This bill extends the compassion and dignity we owe to every expectant mother and father who walk into a doctor's office expecting joy, but leave with heartbreak. Senate Bill 1233 ensures that in those darkest moments when a life-limiting diagnosis is delivered, note there are 3 amendments, Steve, no families left to face it alone. So what?
Keep going.
Okay. This legislation affirms that even when a cure isn't possible, care still is. SB 1233 codifies a compassionate framework of support called perinatal palliative care, a model that walks with families from the moment of diagnosis through delivery and even in the year that follows. No mother or father should have to search in grief for answers, and no baby, no matter how brief their life is, should be denied dignity. Senate Bill 1233 directs the Health and Human Services Commission to develop clear, life-affirming materials to be provided at the time of diagnosis. These materials explain perinatal palliative care, what it is, where it's offered, and how families can access it. And this is something that is just so important. It's about a mother who may never plan a first birthday party, but deserves the chance to hold her baby and whisper, "You matter, you are loved." This is what healing looks like. This is what Senate Bill 1233 makes possible. Members, this important legislation passed the Senate with major bipartisan support, and we do have amendments. Thank you.
The following amendment, clerk will read the amendment.
Amendment by Howard.
Ms. Howard.
Thank you, Mr. Speaker. Members, I am in total support of what Representative Swanson is trying to do here. Perinatal palliative care is a critical component of what we need to be offering all parents who are suffering the loss of a pregnancy, a loss of a child that they were expecting to have, who they get the horrible diagnosis that that child is not going to be able to survive. And we have these wonderful programs that actually work with these families and help them, just like we do at end of life with adults, help them to have the moments that they want to have with either a stillborn or a baby who is born and dies immediately after being born. It is a beautiful program that means a great deal to families, and I am in total support. This amendment, all it does is says, let's go ahead and just trust that we've given the information by checking it off in the electronic medical record, rather than forcing the family, the mom, to have to sign an affidavit that she's been given this information. All healthcare providers, all hospitals, all doctors' offices want to give whatever resources they can to grieving families. That is not an issue. I trust the medical professionals. I trust the doctors, the hospitals, and the nurses to make sure that if they have palliative care information to provide them, that they will give it to them, because that's in the best interest of their patients. I will tell you that when my daughter lost her firstborn, luckily it wasn't as far along, but still, she was put on a gurney in the hospital, being wheeled into the emergency room, and had papers shoved into her face to sign at that point to say, do you want a private or a mass burial? She was not prepared for that. She didn't need to be traumatized to sign that form then. This is devastating news for these families. I definitely support what Representative Swanson's trying to do here, but I do not think we need to be traumatizing women, moms, by making them sign something that say, oh yeah, you gave me the piece of paper that told me about palliative care. Let's give them the information they need, document it in the electronic health record, and be done with it. That's all this is documentation in the electronic health record, as opposed to forcing the mom to have to sign something.
Mr. Moody, for what purpose?
Will the gentlelady yield for some questions?
Does the gentlelady yield
Yes.
for questions? Gentlelady yields for questions.
Yes.
Ms. Howard, I just want to understand. So the amendment you have still captures the same information that the bill would want to capture. Is that correct?
That's correct.
And I think you've raised a very important point. Who gives that information and how that information is collected is important, is it not?
Absolutely.
And so for those families, for those mothers who would be dealing with an incredibly difficult and tragic situation, we're not forcing them to sign an affidavit in the midst of that tragedy under your amendment.
That's correct.
We're still going to gather the information. We're just not going to traumatize them by having them sign that affidavit.
Absolutely. We can document it in the electronic health record without having to make them sign a paper when they're going through this horrific experience.
So same information's gathered.
Yes.
Everything that the bill author wants to be gathered is going to be there.
And it's distributing information,
And
making
it's
sure
still-
that they have it. Yes, it's all the same.
Okay, I know we're at a late hour, and I would like the members to understand that your amendment does not change the data
No.
that we're gathering. We're just changing the manner and means in which we're gathering it so as not to re-traumatize people who are going through a horrifically tragic experience.
Absolutely. I feel like it's the compassionate way to do this.
Ms. Howard, thank you so much for this amendment.
Thank you. Ma'am? I like a medical power of attorney? Yes, ma'am. Thank you, Ms. T. I move adoption.
Chair recognizes Ms. Swanson to speak in opposition to the amendment.
Thank you, Mr. Speaker, members. This bill is too important not to make sure that it happens. The difference in sending a woman home with a devastating diagnosis and making sure that she receives this information, there's support groups she can talk to, who can walk through this with her. There is mental health. There are so many things available. It's too important to leave it to chance and hope somebody hands it to her. Another point, Ms. Noble, is that people tend to remember what the information is if they actually signed it. If it's just in a big old stack, then how are they even going to remember what, are they even going to get told about it? And the point number 3 is that the medical providers should want this because this is the proof that they followed the law. This is their only proof. So they need to get that signature. So it's really good for everyone's. So I urge you to vote no on the amendment. Thank you.
Chair recognizes Ms. Howard to close on the amendment.
Thank you. I think this is just a differing opinion here about whether or not we trust our medical professionals to actually provide the information to their patients. I do trust them. They will provide the information. They want the best for their patients. And this is not to do anything to change that. It's to be compassionate in the way that we share the information and ensure that we're not re-traumatizing patients with one of the worst diagnoses that they will get. I would ask you to vote for the amendment.
Ms. Howard sends up an amendment. The amendment is not acceptable to the author. This is a record vote. The clerk will ring the bell. Show Ms. Swanson voting nay. Show Dr. Oliverson voting nay. Show Ms. Flores voting aye. Show Ms. Isaac voting nay. Have all members voted? Have all members voted? There being 65 ayes and 80 nays, the amendment is not adopted. The following amendment, the clerk will read the amendment.
Amendment by Rose.
The chair recognizes Ms. Rose.
Thank you, Mr. Speaker. Members, this amendment will remove the administrative penalties while maintaining a compliant structure for mothers who do not receive the perinatal palliative resources. This amendment assures that moms who are not given this information can still file complaints with HHSC, and the Commission can use existing processes to impose a penalty on a hospital when appropriate. The current bill would levy a $1,000 fine if a provider fails to give a mom the required informational materials. But there are many reasons why a provider may not be able to provide this to a patient or to a family. This law will require hospital staff to interrupt families who are processing devastating news about their unborn child's diagnosis, and then to ask them to review and sign certification forms. And if a healthcare provider determines that this is not the appropriate time for them to ask for a signature, they should be able to do so without a $1,000 fine over their heads. Without this amendment, I worry that providers will be forced on compliance over compassion. And so they need to be able to provide compassionate medical care, making decisions to avoid a fine rather than focusing on the medical needs of the mother during an incredible, difficult time. So members, this amendment maintains accountability while allowing healthcare professionals the flexibility to provide the appropriate patient care. And it's acceptable to the author.
The chair recognizes Ms. Swanson to speak against the amendment.
No, you did not.
You did.
No, you did not.
I said you said, not me.
Thank you, my dear friend, Representative Rose. I don't want to hurt your feelings, but
I'm here for the people.
okay, but I want to just let you know this is so important that these women and fathers, if they're their siblings, that they receive this information. To go home devastated and try to figure it out alone is just a horrible situation. We must make sure they get it. There is no reason to for anybody to ever end up in trouble. They just follow the law. So please vote no. Thank you.
Chair recognizes Ms. Rose to close on the amendment.
Thank you, Mr. Speaker. Members, I will say this. I know this session we have made so many enhancements. We've made all these penalties for everyone. And if we already have a medical shortage here in the state of Texas as it is. And if we keep putting all of these barriers up for medical professionals, we won't have the workforce that we need if something was to happen to us. But I would ask that you all would please support this amendment to avoid this fee. Again, compassion over compliance. Move passage.
Ms. Rose sends up an amendment. The amendment is not acceptable to the author. This is a record vote. The clerk will ring the bell. Show Ms. Swanson voting nay. Show Ms. Rose voting aye. Show Ms. Flores voting aye. Show Dr. Oliverson voting nay. Have all members voted? Have all members voted? There being 62 ayes and 82 nays, the amendment is not adopted. The following amendment, the clerk will read the amendment.
Amendment by Flores.
Ms. Flores.
Thank you, Mr. Speaker. Members, this amendment would add a study to make sure that perinatal palliative care resources developed by HHSC would be based on science and the needs of the patients and the medical community. While the Palliative Care Interdisciplinary Advisory Council has focused on a number of palliative care issues, providing a report annually on the state of palliative care services, they have not had a particular focus on palliative care for perinatal services. This is a relatively recent area of care and in need of more study, and in particular from the lens of perinatal issues. Under this amendment, we would have the Perinatal Advisory Council provide a review on the current state of palliative and bereavement services across the state and make better recommendations in which to inform the materials being provided to mothers receiving these devastating diagnoses and to shine a light on best practices. This is about ensuring we have the information we need to develop the informational materials described in the bill. Move adoption.
Ms. Swanson.
Thank you. Thank you, Mr. Speaker. Members, as you heard, this is already being done by HHSC, so it's not needed. I'd urge you to vote no. Thank you.
Ms. Flores to close.
Thank you. I ask that we just conduct this study so that we can make sure that HHSC is providing best information and the best services possible. I move adoption. Thank you.
The question occurs on the Flores amendment. Record vote. Clerk, ring the bell. Show Ms. Swanson voting nay, Dr. Oliverson voting nay, Ms. Flores voting aye. Ms. Isaac voting nay. Have all members voted? Have all members voted? 60 ayes, 85 nays. The amendment fails to adopt. Chair recognizes Ms. Howard on the bill.
Thank you, Mr. Speaker. Members, just very quickly, I do support what Representative Swanson's trying to do here, and so I am going to be voting on the bill, though I think that it is unnecessarily punitive, unnecessarily intrusive into a very difficult period of time. Medical professionals do the best for their patients. This is an assumption that somehow they're not going to provide the information that they know that their patients need. I find that just so unbelievable that we're here talking about this in such a way that we don't trust our doctors, our nurses, our hospitals to provide this very necessary information to their patients. So because I support the program, I support palliative care, I think we need to be doing it. I'm going to be voting for the bill despite the fact that I think it is unnecessarily punitive.
Ms. Swanson to close.
Thank you, members. I move passage.
Question occurs on passage. Record vote. Clerk, ring the bell. Ms. Swanson voting aye. Have all members voted? Have all members voted? Being 95 ayes, 45 nays, Senate Bill 1233 passes third reading. Chair lays out on second reading Senate Bill 1580. Clerk, read the bill.
SB 1580 by Blanco, relating the composition of the governing body of the local mental health authority.
Mr. Van Dever.
Thank you, Mr. Speaker. Members, this bill just simply requires local mental health authorities to include a veteran in their governing body. I move passage.
Question occurs on passage of third reading. All those in favor say aye. All those opposed say nay. Ayes have it. Senate Bill 1580 passes third reading. Chair lays out on second reading Senate Bill 1663. Clerk, read the bill.
SB 1663 by Zaffarini, relating notification procedures concerning groundwater contamination.
Mr. Guillen.
Thank you, Mr. Speaker. Members, this ensures Texans, especially those in rural areas using private wells, receive timely notice when groundwater contamination is detected nearby. Move passage.
Question occurs on passage third reading. It's a record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 118 ayes, 25 nays. Senate Bill 1663 passed third reading. Chair lays out on second reading Senate Bill 413. Clerk, read the bill.
SB 413 by Middleton, relating to the meetings of the Board of Trustees of Independent School Districts.
Mr. Buckley.
Thank you, Mr. Speaker. Members, Senate Bill 413
Mr. Speaker.
requires school boards to
Mr. Hawkins,
publish.
for what purpose?
Will gentleman yield for questions?
Gentleman yields
Yes.
for questions. He yields for questions.
So you're outlining what a board, what independent school district should provide. Do you know they already provide this information?
No, right now they're required to post either the minutes or recordings, and this would make them post both, and then also give details of the actual resolutions that they pass as in terms of the vote counts or the record votes.
So disclosure for schools are already there, so now you're adding an additional burden because you also put in here they have to do it within 7 days.
Well, we actually have an amendment that will make sure that doesn't have to be done until the minutes are official. But right now the burden is on individual parents and taxpayers because they often have to go through the recording of a meeting to see exactly the way different members of boards voted. This would just provide it in a format where we could see.
So you're giving them more time to do it?
Yeah. I think this is adequate, and it'll be within the time frame that they can logistically post those.
So no longer your amendment takes away the 7 days and puts it when they finish their official?
Yeah, it just says that it's not due until the minutes are official.
So it takes out the 7 days, yes or no?
No, it just makes it when they are official. We've not even laid the amendment out yet, so let the author of the amendment lay that out.
All right, you got it.
Okay.
Following amendment, clerk will read the amendment.
Amendment by Gonzalez of El Paso.
Ms. Gonzalez.
Thank you, Mr. Speaker. Members, this simply clarifies that the minutes, will, after the minutes, to include as reported by the Board of Trustees, which they have to do according to Robert's Rules of Order, and it's acceptable to the author. But I can ask if there are any questions. No, okay.
Ms. Gonzalez sends up an amendment. It's acceptable to the author. It's a record vote. Clerk, ring the bell. So Mr. Buckley voting aye. Ms. Gonzalez of El Paso voting aye. Scriven Hawkins voting aye. All members voted. 142 ayes, 1 nay. The amendment is adopted. Dr. Buckley.
I move passage.
Question occurs on passage third reading. All those in favor say aye. All those opposed say nay.
Nay.
Ayes have it. Senate Bill 413 passes. Chair lays out on second reading Senate Bill 447. Clerk, read the bill.
SB 447 by Juan Hinojosa relating to the authorizing certain municipalities to change the date on which their general election for officers is held.
Mr. Morales.
Thank you, Mr. Speaker. The electorate of the City of Mission voted by 77% margin to have the municipal election date moved from May to November. We have an amendment.
Following amendment, clerk, read the amendment.
Amendment by Morales of Maverick.
Mr. Morales.
The amendment is acceptable to the author and allows also cities and community college districts to change the date if necessary before the end of the year. Move adoption.
Mr. Morales sends up an amendment. Record vote. Clerk, ring the bell. If all members voted, 139 ayes, 0 nays, amendment is adopted. Mr. Morales.
Move passage.
Question occurs on passage third reading. All those in favor say aye. All those opposed say nay. Ayes have it. Senate Bill 447 passed third reading. Chair lays out on second reading Senate Bill 519. Clerk, read the bill.
SB 519 by Middleton relating to the creation of a grant program to promote educational engagement with Texas history.
Mr. Metcalf.
Thank you, Mr. Speaker. Members, Senate Bill 519 is about preserving Texas history and creating a grant program through Texas Historical Commission. Move passage.
Question occurs on passage third reading. All those in favor say aye. All those opposed say nay. Ayes have it. Senate Bill 519 passed third reading. Chair lays out on second reading Senate Bill 467. Clerk, read the bill.
SB 467 by Paxton relating to the reappraisal for ad valorem taxation purposes of the real property for which a building completely destroyed by a casualty is located.
Mr. Hefner.
Thank you, Mr. Speaker. Senate Bill 467 just provides tax relief for people whose house is burned down. Move passage.
Question occurs on passage third reading. Record vote's been requested. Clerk, ring the bell. If all members voted, 144 ayes, 0 nays. Senate Bill 467 passed third reading. Chair lays out on second reading Senate Bill 1579. Clerk, read the bill.
SB 1579 by Blanco relating to the appointment of a receiver for and sale of an acquisition of eminent domain of certain parcels of land that are abandoned, unoccupied, and undeveloped in certain municipalities.
Ms. Gonzalez.
Thank you, Mr. Speaker. Members, this is a purely local bill for El Paso County that will create a more streamlined process for our local municipalities to determine when undeveloped parcels of land is abandoned and unoccupied. Oh, I have an amendment.
Following amendment, clerk will read the amendment.
Amendment by Gonzalez of El Paso.
Ms. Gonzalez.
Thank you, Mr. Speaker. Members, this amendment was some recommendations from some stakeholders to make sure that we are aligning ourselves with some property tax regulations that already exist. I move adoption.
Ms. Gonzalez sends an amendment to record vote. Clerk, ring the bell. Have all members voted? If all members voted, 87 ayes, 59 nays. The amendment is adopted. Ms. Gonzalez to close.
Members, it's a purely local bill for El Paso County. I move a passage.
Question occurs on passage third reading. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 86 ayes, 57 nays. Senate Bill 1579 passed third reading. Chair lays out on second reading Senate Bill 1191. Clerk, read the bill.
SB 1191 by Creighton relating to the development of a standard method of computing a student's high school grade point average.
Ms. Harris-Davila.
Mr. Speaker,
Ms. Gervin Hawkins, for what purpose?
will gentlelady yield?
Gentlelady
I
yield for
do.
questions? She yields for questions.
Talk to us a little bit about the standard computing of a student's high school grade point average, because some schools have a 5 point, some have a 4 point. Explain to us a little bit more how that works.
Yes, ma'am. So what this bill does, it says that for advanced coursework in high school, so your AP coursework, your international baccalaureate coursework, or dual enrollment, all gets weighted equally towards a student's GPA. And the reason we're wanting to do this is some students take dual enrollment courses at trade schools, but those are not always equally weighted towards their GPA. So sometimes they're not considered for scholarships or other opportunities like other students are that engage in other coursework like AP or IB coursework. And so we're wanting to help these students out.
Wow. Help them out. I'm a little concerned. So what you're saying is those that have more of a vocational flavored grade, no doubt you have to have your core subjects.
Yes.
And we already have the type of diploma, your distinguished, and your basic, and things like that. So you're changing the model in which schools are now calculating grade point averages, and you're saying those that take AP courses and or college courses should be weighted separately from those that take more career-based courses?
No, we're wanting to put them all at the same level. Right now they are separated, but this bill would put them all at the same level, if that makes sense.
It doesn't at all.
Okay, sorry. Okay, so right now, some school districts in Texas will weight a student's GPA based on, an AP course. They'll give a student more credit towards their GPA for taking an AP course than they'll give a student who takes a dual enrollment course. They'll weight a dual enrollment course less towards that student's GPA. So what we're saying is we want an equal playing field. We want to make sure that students have an equal weight between an AP course's impact on their GPA and a dual enrollment course's impact on a GPA.
I know you talk about APA and dual enrollment. Let's talk about the vocational. Let's talk about the career piece student.
Yeah, that would count under the dual enrollment. That would be a dual enrollment course.
So if someone is taking a CTE course or earned a industry-based credential,
yes,
you're saying that is a qualifier with an AP or a dual enrollment?
That qualifies under that dual enrollment umbrella, yes.
All right, thank you.
Thank you. Thank you, members. I know this bill will really help our students who are pursuing a career in trade, and I move passage.
Question occurs on passage third reading. All those in favor say aye. All those opposed say nay. Ayes have it. Senate Bill 1191 passes third reading. Chair lays out on second reading. Senate Bill 1021. Clerk, read the bill.
SB 1021 by Huffman or Lane, changing the eligibility for community supervision of a person convicted of a stalking into the offense of improper contact with the person's victim.
Mr. Harless.
Thank you, Mr. Speaker. Members, Senate Bill 1021 amends the Code of Criminal Procedure to include a conviction of stalking as an offense that disqualifies a person for community service. I move passage.
Question occurs on passage third reading. All those in favor say aye. All those opposed say nay. Ayes have it. Senate Bill 1021 passed third reading. Chair lays out on second reading. Senate Bill 1838. Clerk, read the bill.
SB 1838 by Zaffarini relating to the appointment of attorneys ad litem and compensation of certain attorneys ad litem in suits affecting the parent-child relationship filed by a governmental entity.
Mr. Moody.
Thank you, Mr. Speaker and members. A couple things that are covered under this bill. Right now, we're only appointing attorneys in certain protection suits and child protection suits. And so this would expand the opportunity to appoint attorneys in SAPSR suits generally. For those of you who don't know the vernacular, that's a suit affecting parent-child relationship. And so we're going to allow those appointments to take place. However, we're going to also change how those rates are reimbursed for those attorneys that are appointed by the court in those cases. So just for y'all to understand, if the parent can pay those fees, and the parent is going to be responsible for those fees. In the event that that parent is indigent and there's an indigency finding, we're going to have a schedule of fees. So there's a uniform schedule of fees for that county, which doesn't exist now. And the county commissioners in that court, like they do for any other court-appointed fees, they would set a fee structure for those particular cases so that we have some uniformity, at least within those counties that are doing this. And this will allow for parental rights to be maintained, and to make sure that even those who are indigent are still going to be able to have these attorneys available to them. And we're going to do it in a way that I think is responsible, and will place that burden on the county commissioners in that particular county. And I move passage.
Question occurs on passage third reading. All those in favor say aye. All those opposed say nay. Ayes have it. Senate Bill 1838 passed third reading. Chair lays out on second reading. Senate Bill 2807. Clerk, read the bill.
SB 2807 by Hagenby, relating to the considerations when determining whether an operator of a motor vehicle is an employee of a motor carrier of an independent contractor.
Chair recognizes Mr. Curry.
Thank you, Mr. Speaker. This is a bill that makes trucking safer for everyone. Move passage.
Question occurs on passage third reading. All those in favor say aye. All those opposed say nay. Ayes have it. Senate Bill 2807 passed third reading. Chair lays out on second reading. Senate Bill 2835. Clerk, read the bill.
SB 2835 by Johnson, relating to municipal regulation of a stairway requirements in certain apartment buildings.
Salarico.
Thank you, Mr. Speaker. Members, this gets rid of an outdated regulation so we can build more housing. Move passage.
Question occurs on passage third reading. All those in favor say aye. All those opposed say nay. Ayes have it. 2835 passes third reading. Chair lays out on second reading. Senate Bill 546. Clerk, read the bill.
SB 546 by Menendez, relating to seatbelts on buses that transport children.
Mr. Curry.
Thank you, Mr. Speaker. This is Dean Craddock School Bus Bill. Move passage.
Question occurs on passage third reading. All those in favor say aye. All those opposed say nay. Ayes have it. Senate Bill 546 passed third reading. Chair lays out on second reading. Senate Bill 2121. Clerk, read the bill.
SB 2121 by Johnson, relating to the regulation of certain business entities that act as data brokers.
Mr. Bell.
Thank you, Mr. Speaker. Members, Senate Bill 2121 removes references to a revenue threshold in the definition of a data broker, ensuring the law affects applicable companies and is enacted as originally intended. Thank you, Mr. Speaker, and I move passage.
Question occurs on passage third reading. All those in favor say aye. All those opposed say nay. Ayes have it. 2121 passed third reading. Chair lays out on second reading. Senate Bill 2167. Clerk, read the bill.
SB 2167 by Paxson, relating to licensing and regulation of massage therapy.
Mr. Bumgarner.
Thank you, Mr. Speaker. Members, Senate Bill 2167 builds on the successes of the legislators' efforts to crack down on human trafficking at massage parlors. This bill would allow TDLR to delay the approval of new massage establishments for schools. I move passage.
Question occurs on passage third reading. All those in favor say aye. All those opposed say nay. Ayes have it. 2167 passed third reading. Chair lays out on second reading. Senate Bill 2035. Clerk, read the bill.
SB 2035 by Hughes, relating to prohibiting contributions, expenditures, and related activities involving political committees that support or oppose a ballot measure, creating criminal offense, and providing a civil penalty.
Mr. Sheen. Mr. Romero, for what purpose?
Thank you, Mr. Speaker. I raise a point of order against further consideration of Senate Bill 2035 under Rule 8, Section 1A on the basis the caption fails to give reasonable notice on the subject of the bill.
Bring your point of order down front. Point of order has been withdrawn. Machine for a motion.
Mr. Speaker, I move to postpone further consideration of SB 2035 till June 3rd, 2025.
Members, you've heard the motion. Is there objection? Chair is none, so ordered. Chair lays out on second reading. Mr. Van Dever for a motion.
Thank you, Mr. Speaker. I move to suspend House Rule 8, Section 5D for SB 2024 to designate the following members as co-sponsors: Morales Shaw.
Members, you've heard the motion. Is there objection? Chair is none, so ordered. Chair lays out on second reading Senate Bill 2024. Clerk, read the bill.
SB 2024 by Perry, relating to prohibition on marketing, advertising, or selling of certain e-cigarette products, creating a criminal offense.
Mr. Leach.
Thank you, Mr. Speaker. Members, Senate Bill 2024 is aimed at a growing problem here in the state of Texas, specifically as it relates to our minors. In recent years, some vape pen companies have continued to deliberately target our children in the state of Texas. Bad actors have now begun disguising vape pens as other products, like school supplies, office supplies, anything other than what it is, an electronic cigarette. For instance, I've got a few of these up here, members. All of these, I've got 3 of them up here. This one you can actually play Tetris on. This is manufactured in China and shipped into the United States.
Mr. Speaker?
This one right
Mr.
here.
Rounds, for what purpose?
I raise a point of order under Rule 8, Section 1, because the caption does not give the legislature and the public reasonable notice of the subject of the proposed measure under Rule 8, Section 3 and Section 35, Article 3 of the Texas Constitution, because the bill impermissibly contains more than one subject.
Bring your point of order down front.
The point of order is withdrawn. The following amendment, the clerk will read the amendment.
Amendment by Leach.
Chair recognizes Mr. Leach.
Thank you, Mr. Speaker. Members, this is just a floor amendment that is pretty self-explanatory. I'm happy to answer questions. This floor amendment simply clarifies that prescription medications are not included in the bill or the definition of e-cigarette. With that, I move adoption of floor amendment 1.
Mr. Leach sends up an amendment. The amendment is acceptable to the author. However, a record vote has been requested. The clerk will ring the bell. Show Mr. Leach voting aye. Show Mr. Vasut voting aye. Show Ms. Hicklin voting aye. Show Mr. Morgan voting aye. Show Mr. Van Dever voting aye. Have all voted. There being 136 ayes, 0 nays, the motion is adopted. The following amendment, the clerk. The following amendment, the clerk will read the amendment.
Amendment by Leach.
Chair recognizes Mr. Leach.
Thank you, Mr. Speaker. Now that we have express severability in the bill, the next amendment, this amendment in front of you now is very important. I'm not going to go through it in detail, but it essentially does 3 things. First, since no products that are manufactured in China are FDA compliant and have not been approved by the FDA, the amendment references FDA approved products, said that those are legal products we're talking about, increases the offense for those illegal products. Second, thank you for standing behind me, members. Second, to address concerns by reputable retailers who are trying to follow the law, the amendment allows the Comptroller's Office to compile a list of the legal products and post it to their website. Finally, we've heard a couple of concerns about timing and about component parts that are not e-liquid but that are manufactured in China, like batteries, for instance. In an attempt to work with those parties, I'm pushing the effective date of the bill out to 2026 and adding language to ensure that the component parts are not prohibited to be manufactured. With that, I move adoption of the amendment.
The following amendment. To the amendment, the clerk will read the amendment to the amendment.
Amendment by Van Dever.
The chair recognizes Mr. Van Dever.
Thank you, Mr. Speaker. This amendment to the amendment would simply ensure that the manufacturer that a manufacturer that timely filed FDA applications but are currently undergoing an FDA approval process or under appeal with a court-ordered market are not unintentionally excluded from the comptroller's approved list. I believe it's acceptable to the office.
It is, yes. Yes. Yeah.
Mr. Van Dever sends up an amendment. The amendment is an amendment to the amendment. The amendment to the amendment is acceptable to the author. However, a record vote has been requested. The clerk will ring the bell. Show Mr. Van Dever voting aye, Mr. Patterson voting aye, Mr. Leach voting aye, Mr. Metcalf voting aye, Mr. Tinderholt voting aye, Mr. Morgan voting aye, Mr. Lowe voting aye. Have all voted. There being 138 ayes, 0 nays, the amendment to the amendment is adopted. The following amendment to the amendment.
Amendment by Kane.
Mr. Kane.
Mr. Speaker, can I get my stool? Okay. Thank you, Mr. Speaker. Members, this amendment would ensure that when we're discussing China, that not only is it not allowed to be wholly or partly manufactured in China, it can't contain any part or component part manufactured in China. And you'll notice we've got this list of additives like mushrooms and cannabis. We're adding tineptine. Let me talk to you about tineptine. On May 8th, 2025, the chairman of the FDA, Marty McCurry, released a document to notify the states and all of his colleagues, writing, by the way, we call this gas station heroin. I'm writing to draw your attention to a dangerous and growing health trend facing our nation, particularly young people, the increasing number using tineptine. It's a brand new drug out on the streets, guys, bad for kids, and so we're adding it in to make sure this isn't legally allowed to be mixed in there. With that, I move adoption.
Mr. Leach in opposition.
Thank you, Mr. Speaker. Members, with all due respect to Representative Kane, I'm going to move to table this. Much of this is already included in the bill, and it's not necessary. I move to table and ask that you stick with me.
Mr. Speaker.
Mr. Wu, for what purpose?
Would the gentleman yield for questions?
Which one?
Mr. Leach has moved to table. The chair recognizes Mr. Kane to close on the amendment.
You have a question for me? Mr. Speaker,
Mr. Wu, for what purpose?
would the gentleman yield for questions?
Mr. Kane?
Yes, absolutely.
Mr. Kane,
The gentleman yields.
you're aware that virtually 99% of all consumable vapes are currently produced in China, right?
Yes,
Or
yes,
have,
sir.
have components made in China. And there's basically only one company that can claim that their products are not, correct?
No, I think they all would claim that they have parts in it.
Parts
so-
in China, but
yeah, and so
a
this
few-
just ensures that there's no carve-outs for a single company.
So, like, if the original bill and the amendment that Mr. Leach offered said not manufactured in China, that would be cutting out about 99% of the competition.
Correct.
Leaving room for only one company to sell, correct?
Yes, sir.
And so I think if our concern is components made in China or things made in China, let's do all things made in China, not just assembled in the US, but let's do everything, including the battery, including the plastic, including everything. That would be the fair thing to do, make a level playing field, correct?
That's correct.
Okay? Let's
it.
not be anti-competition, right?
That's it. We just want to make sure it's fair for everybody. Nothing's from China then. That's it.
Yep. If
Really
we're going to do it for one, let's do it for everyone.
Yes, sir. Also, members, when you vote no on this, I'm going to remind you, we're also trying to prohibit the use of gas station heroin, brand new drug. You'd also seen it in the Austin American Statesman a few weeks ago. That was the first article in Texas discussing it. With that, I ask that you vote against the motion to table.
Mr. Kane sends up an amendment to the amendment. Mr. Leach moves to table. The question is on the motion to table. The clerk will ring the bell. Show Mr. Leach voting aye. Show Mr. Capriglione voting aye. You've all voted. You've all voted. There being 66 ayes, 71 nays, the motion to table fails. The amendment is now acceptable to the author. The question is on the adoption of the amendment to the amendment. This is a record vote. The clerk will ring the bell. Show Mr. Leach voting aye. Have all voted. There being 129 ayes, 10 nays, the amendment to the amendment is adopted. Is Mr. Kane on the floor of the House? The chair recognizes Mr. Leach to close on the amendment.
Close on the amendment, move adoption of the amendment.
Mr. Leach sends up an amendment. The amendment is acceptable to the author. This is a record vote. The clerk will ring the bell. Show Mr. Leach voting aye. Show Mr. Alders voting aye. Show Ms. Gervin Hawkins voting aye, and Mr. Schatzline voting aye. Have all voted. Being 142 ayes, 0 nays, the amendment is adopted. The chair recognizes Mr. Leach to close on the bill.
Move passage.
The question occurs on passage to third reading of Senate Bill 2024. All those in favor say aye. All those opposed say nay. The ayes have it, and Senate Bill 2024 is passed to third reading. Chair lays out on second reading Senate Bill 1032. The clerk will read the bill.
SB 1032 by Cole Course relating to participation in Governor's University Research Initiative.
Chair recognizes Mr. Leach.
Thank you, Mr. Speaker. Members, Senate Bill 1032 will allow private and independent universities to apply for grants through the Governor's University Research Initiative. Established in 2015, this initiative grants contribute up to $5 million for the purpose of recruiting distinguished researchers, such as a Nobel laureate or member of the National Academies. By allowing our private institutions to compete for this funding, we enable some of our finest institutions like Baylor and Rice to continue their research goals. With that, I move passage.
The question occurs on passage to third reading of Senate Bill 1032. This is a record vote. The clerk will ring the bell. Show Mr. Leach voting aye. Show Mrs. Weiner voting aye. Have all voted. Being 106 ayes, 33 nays, Senate Bill 1032 is passed to third reading. Chair lays out on second reading Senate Bill 1049. The clerk will read the bill.
SB 1049 by King relating to excused absences from public schools for the purpose of attending a release time course.
Chair recognizes Mr. Frank.
Thank you. Mr. Speaker, members, SB 1049 will ensure that Texas schools have a framework for allowing voluntary religious education outside of schools. The bill allows school districts to adopt their own policies so districts can adopt guardrails that work for their district in order to ensure regular class time isn't disrupted. I move passage.
Question occurs on passage third reading of Senate Bill 1049. For record vote has been requested. The clerk will ring the bell. Show Ms. Hull voting aye. Have all voted. Being 127 ayes, 17 nays, Senate Bill 1049 is passed to third reading. Chair lays on second reading Senate Bill 1266. The clerk will read the bill.
SB 1266 by Alvarado relating to Medicaid provider enrollment and credentialing processes.
Chair recognizes Ms. Hall.
Thank you, Mr. Speaker. This bill will ensure that the provider support team shepherding Medicaid providers through enrollment and re-enrollment processes is regularly evaluated with clear objectives for provider support. Currently, providers only receive electronic notification of disenrollment. This would require both written and electronic notification of provider disenrollment no less than 30 days before disenrollment. Move passage.
Question occurs on passage third reading of Senate Bill 1266. All those in favor say aye. Opposed say nay. The ayes have it. Senate Bill 1266 is passed to third reading. Chair lays out on second reading Senate Bill 1400. The clerk will read the bill.
SB 1400 by Cole Course relating to a study on measurable outcomes for certain transfer students for performance tier funding under the Public Junior College State Finance Program.
Chair recognizes Mr. Kitzman.
Mr. Speaker and members, Senate Bill 1400 is a study bill to inform the legislature not only of the kinds of educational experience the state junior college students already possess, but to make sure that junior colleges who successfully transfer students to a four-year degree are properly rewarded in the performance funding. I move passage.
Question occurs on passage to third reading of Senate Bill 1400. This is a record vote. The clerk will ring the bell. Show Mr. Kitzman voting aye. Show Mrs. Weiner voting aye. Have all voted. Being 99 ayes, 39 nays, Senate Bill 1400 is passed to third reading. Chair lays out on second reading Senate Bill 1302. The clerk will read the bill.
SB 1302 by Cole Course relating to eligibility to use a general permit to discharge waste into or adjacent to waters in the state.
Chair recognizes Mr. Bell of Montgomery.
Thank you, Mr. Speaker. Members, the intention of this legislation is to make sure an appropriate employee at TCEQ reviews applications from discharger who has a denial or suspension, closes a loophole which bad actors have exploited. To do this, the bill amends Section 26.05 of the Water Code so that the TCEQ Executive Director must provide approval for the discharger to resume, does not allow for automatic process. Move passage.
Question occurs on passage third reading of Senate Bill 1302. All those in favor say aye. Opposed say nay. The ayes have it. Senate Bill 1302 is passed to third reading. Chair lays out on second reading Senate Bill 401. The clerk will read the bill.
SB 401 by Paxton relating to participation by non-enrolled students in University Interscholastic League sponsored activities.
Chair recognizes Mr. Frank.
Thank you, Mr. Speaker. Members, this bill makes two important changes to a bill that I have worked on more than any other in my political career. 4 years ago, we allowed ISDs to allow homeschoolers to participate in UIL activities. Over the past 4 years, 46 different ISDs have voted to allow homeschoolers. According to UIL, there have been no problems. This bill does two quick things. It allows, dang it.
All right, Mr. Speaker.
Ms. Hinojosa, for what purpose?
Will the gentleman yield for a question?
Will the gentleman yield for questions?
You're
Don't
killing
you-
me, Smalls, and
Gentleman
I'm killing
yields.
myself. I'm sorry. Yes.
Don't you have an amendment to this bill?
No, I worked with Trent Ashby, and I really do appreciate Chairman Ashby working with me with the coaches. They don't have a problem with any of the recruiting stuff. They like it the way it is and trust UIL to make the rules the way that will fit. So the coaches
Thank
are
you.
happy, at least according to Trent. Thank you very much, Chairman Ashby. With that, I move passage.
The question occurs on passage to third reading of Senate Bill 401. This is a record vote. The clerk will ring the bell. Show Ms. Schaffner voting aye. Show Ms. Zwiener voting nay. Have all voted. Being 109 ayes, 28 nays, Senate Bill 401 is passed third reading. Chair lays out on second reading Senate Bill 1596. The clerk will read the bill.
SB 1596 by Hagan B. repealing the prohibition of short barrel firearms.
Chair recognizes Mr. Hayes to explain the bill.
Thank you, Mr. Speaker. Because of the ATF reclassification of pistols equipped with stabilizing braces as short barrel firearms and anticipation of future reclassifications, Texas law must be amended to end its
Mr.
reliance
Pettis, for what
upon the
purpose?
federal government's whim.
Mr. Speaker, I respectfully raise a point of order against Senate Bill 1596 under House Rule 4, Section 32C2.
Please bring your point of order down front. Point of order is withdrawn. The chair recognizes Mr. Hay.
Move passage.
The following amendment, the clerk will read the amendment.
Amendment by Goodwin.
Chair recognizes Ms. Goodwin to explain the amendment.
Thank you, Mr. Speaker. Members, this amendment isn't about stopping the bill, though I strongly oppose legalizing short barrel firearms. But if this body chooses to move forward, we have a duty to put real safeguards in place. This amendment requires a background check on every sale or transfer, including private sales of short barrel firearms. These aren't ordinary guns. They're small, easy to hide, and built for close range killing. If we're going to legalize them, the least we can do is make sure they don't end up in the wrong hands. No background checks means no accountability. That's how tragedies happen. So this background check would cover every transfer or sale, including private and unlicensed sellers. It would prevent another tragedy, such as what happened at Santa Fe. At Santa Fe High School in 2018, a short barrel firearm was used to kill 10 and injure 13. This amendment prevents these firearms from getting into the wrong hands. This is the bare minimum, members, so I move adoption.
Chair recognizes Mr. Hayes in opposition.
I appreciate the amendment by my good friend Goodwin. I wish I could say this was a good amendment, but it is not. What this amendment seeks to do is require any time that you're selling a short barrel firearm that you have to go through a registration process. I want you to, and remember she said because it's small. I want you to think of the irony. In this day of constitutional carry, where you can carry a handgun, which is a lot smaller than a short barrel firearm, and you can carry a long barrel long gun, and that's okay, but you can't carry a short barrel long gun. So I would ask you to vote against the amendment.
Will the gentleman yield?
Mr. Bryant, for what purpose?
Will the gentleman yield for question?
Will the gentleman yield for questions? The gentleman yields.
Mr. Hayes, these short barrel weapons are on a short list of weapons which are illegal to possess in this state. Isn't that correct?
That's true. That's why we're repealing it.
And why was it put on the list in the first place?
Well, back in the 1930s, when we did the National Firearm Act, it had a number of prohibited guns, and Texas mirrored that. But what we've come to learn is it's such an inconsequential ownership that the state of Texas does not track how many criminal offenses are committed with short barrel firearms or the results of those criminal offenses.
No, but we don't track much of anything, do we?
Members not advised.
To what use, sir, are you going to put your short barrel firearm, your sawed-off shotgun? That's what we're talking about here. To what use will you put it?
I don't own one. I know there are members that do. And what prompted the bill, Representative, is that when the ATF, under the Biden administration, made it illegal to have a pistol brace, and those were originally designed for people who had handicaps where it would fit on your arm so that you could stabilize the gun. It was called a stabilizing brace, that those all of a sudden became short barrel firearms. That made somewhere between 350,000 to 900,000 guns in the state of Texas illegal. So this bill seeks to repeal that situation so that people don't have to be fearful of having a prohibited weapon.
But you could have repealed just those, the law with regard to just those people and left the general prohibition on short barrel firearms in the law if you'd chosen to, couldn't you?
Not really.
Not really? No. I think really you could have if you'd have chosen to. Instead, you're removing one of 3 prohibited weapons, an explosive weapon, a machine gun, and a short barrel firearm. You're removing short barrel firearm from the list of weapons that are illegal, aren't you?
That is true. But like what I said a while ago is think of the irony. You can have a handgun, you can have a long gun, but you can't have a long gun with a short barrel, but the pistol barrel is shorter than the short barrel firearm barrel.
I'm not thinking about the irony. I'm thinking about all those people that got shot in that church that Mrs. Goodwin spoke of just a moment ago with one of these weapons.
That is true that a short barrel firearm was used in Santa Fe, but let me tell you what. It was properly owned, it was properly registered with the federal government, and the $200 tax stamp that the federal government extracts from people to have a short barrel firearm had been paid. That was a legally owned gun, and if it's a legally owned gun and someone commits a heinous offense, what can you do?
This is an organized crime amendment. This isn't the case that they put this in the law in the first place because these things are highly lethal and they're also easily concealable, and they were used to shoot cops and innocent people by gangsters. Isn't that the case?
I think that was the case back in the 30s, Representative, when the bill was originally passed. We just don't have that kind of gangland style shooting these days with short barrel firearms.
We don't have gangland style shootings these days. I don't think
Not
you're
with
right
short
about
barrel
that.
firearms.
Pardon me. We have shootings that vastly exceed what we once had. That we've never had a greater epidemic of constant shootings than we have today. In those days, they didn't have that.
Yeah. What's the question?
Why are you carrying an amendment like this on the anniversary of the killing of all those children in Uvalde? That's my question.
I had nothing to do with the calendar. Thank you. Move passage. We got an amendment. My bad. Yeah, I oppose it, and I'll move to table the amendment.
Ms. Goodwin to close on the amendment.
Right. If you're for saving lives, if you are for gun violence prevention, vote no to table this amendment. Thank you.
Ms. Goodwin sends up an amendment. Mr. Hayes moves to table. The question is on the motion to table. Record vote. The clerk will ring the bell. Show Mr. Hayes voting aye. Ms. Goodwin voting nay. Mr. Schatzline voting aye. Mr. Alders voting aye. Have all voted. Mr. Jones of Dallas voting nay. Have all voted. There being 87 ayes, 53 nays, the motion to table prevails. Mr. Hayes to close on the bill.
Short people move
back it up,
for
members.
short
Back it
barrel
up.
firearms.
Back it up, members. Chair recognizes Mr. Bryant in opposition to the bill.
Members, I know it's late, but I don't think it's too late to call out possibly the most irresponsible thing that we've done here since we convened together back in January. This prohibition on short barrel firearms is accompanied by a prohibition on machine guns and explosive weapons. That's how serious the prohibition is. It's been in our law a long time because these weapons have no sporting use. They're not necessary for self-defense. They're just used because they're concealable and they're highly lethal in killing law enforcement officers and innocent people. We don't have any business taking this out of our current law, and I strongly oppose the bill, and I hope that you'll vote no. I'll be happy to yield to the gentleman.
Speaker.
Mr. Verdell for
Will
what?
gentleman yield for questions?
Gentleman yields.
Representative, do you know the difference between a short-barreled rifle and a machine gun?
I probably know the difference about as well as any normal person, yeah.
Okay. Do you know the difference between a 16-inch, the velocity difference between a 16-inch barreled 5.56 AR-15 rifle and an 8-inch barreled AR-15 rifle.
Let me tell you something. I'm not into all that BS, okay? To me, it's all a bunch of nonsense. It's a bunch of gobbledygook you guys cook up to cover your addiction to guns and weapons.
So is it safe to say?
I'm not going to play your game. I don't want to know the difference between all these weapons. You know why?
So you're
Because
saying you don't
I don't
know.
lay awake at night dreaming about getting to use those guns and being a hero like you guys do. You know, you live in a fantasy world, and your fantasy world is costing people their lives.
Untrue. Are you saying
I'm
that you
sorry.
don't understand the difference, but you're opposed to them?
I'm saying I think it is outrageous that you and your allies nitpick these differences when people are dying every single day because of their
Okay.
infatuation with these weapons.
Please confine your remarks to the
Yeah.
contents of the
Thank you.
bill.
I hope
I know.
you'll vote no.
All right.
Mr. Hayes to close on the bill.
Close. And I move passage.
The question occurs on the passage to third reading of Senate Bill 1596. This is a record vote. The clerk will ring the bell. Show Mr. Hayes voting aye, Mr. Alders voting aye. Have all voted. There being 88 ayes, 54 nays, Senate Bill 1596 is passed to third reading. Chair lays out on second reading Senate Bill 1281. The clerk will read the bill.
SB 1281 by Parker relating to certain criminal offenses involving mail or a mail receptacle, key, or lock, creating criminal offense, increasing criminal penalty.
Chair recognizes Mr. Alders.
Thank you, Mr. Speaker. Members, Senate Bill 1281 cracks down on the organized theft of checks, also known as negotiable instruments, while they are in our mail system, as well as the theft of mailbox arrow keys. I move passage.
The question occurs on passage to third reading of Senate Bill 1281. All those in favor say aye. Opposed say nay. The ayes have it. Senate Bill 1281 is passed to third reading. Chair lays out on second reading Senate Bill 1242. The clerk will read the bill.
SB 1242 by Birdwell relating to the acquisition of land and facilities by Texas State Technical College System.
Chair recognizes Colonel Wilson.
Thank you, Mr. Speaker. 1242 removes the outdated provisions requiring THECB to review TSTC acquisition. Move passage.
Question occurs on passage to third reading of Senate Bill 1242. All those in favor say aye. Opposed say nay. The ayes have it. Senate Bill 1242 is passed to third reading. Chair lays out on second reading Senate Bill 1343. The clerk will read the bill.
SB 1343 by Johnson relating notice requirements of a data broker registration statement and an internet website.
Chair recognizes Ms. Harris Davila.
Thank you, Mr. Speaker. Members, SB 1343 updates a law passed last session by requiring data brokers with websites or apps to clearly inform consumers how to exercise their data privacy rights under the Texas Data Privacy and Security Act. I move passage.
Ms. Harris Davila, the question occurs on passage to third reading of Senate Bill 1343. All those in favor say aye. All opposed say nay. The ayes have it. Senate Bill 1343 is passed to third reading. Chair lays out on second reading Senate Bill 310. The clerk will read the bill.
SB 310 by Hughes relating termination of a majority vote in certain elections.
Chair recognizes Mr. Patterson.
Thank you, Mr. Speaker. Members, good evening, good morning.
Mr. Speaker, will the gentleman yield for some questions?
Not right now.
Sounds good.
Not at this time.
Mr. Speaker and members, before I was interrupted, Senate Bill 310 would ensure that Texas elections are never carried out via the preferred method of Mike Waltz ranked choice voting, also known as instant runoff voting. Ranked choice voting has been shown to be confusing to voters, which is true, and would fundamentally change Texas elections. Our one-person, one-vote system is the foundation for election integrity. And the introduction of ranked choice voting would turn that on its head. 13 states have already banned ranked choice voting, including Florida, Tennessee, and Louisiana. Let's make Texas the next state to stand up and say no to Mike Waltz's favorite choice of voting. Ranked choice voting.
Mr. Busey, for what purpose?
Will the gentleman yield for a few questions?
Will the gentleman yield for questions?
Not at this time. The
Not at this time.
NAACP head slammed ranked choice voting and called it voter suppression, calling for an overhaul of the bumbling New York City Board of Elections. I'll be happy to answer questions now.
Mr. Speaker,
Mr. Busey, for what purpose?
will the gentleman yield for some questions?
Will the gentleman yield for
Not at this
questions?
time. I'm just kidding. Yes, I will.
I'm curious.
Gentleman yields.
I'm curious, but I'm trying to go as slow as I can to ask this question to match your tone. You said in your layout, if I wrote this down right, let's make Texas the next state to stand up to ranked choice voting. Is that correct?
I said stand up and say no.
And say no. Hold on, let me write that down.
Ranked choice voting.
And
I think I called it
say
Mike Waltz's.
no to ranked. I just
But
want
I
to write
meant
down.
Tim Waltz. I get his name
Let
confused.
me ask you a question. You want Texas to be the next state to stand up and say no to ranked choice voting. Is that correct?
Well, you know, Florida, Tennessee, and Louisiana already have, so I figured it's about time.
Wow. Are you aware that another state did it in 1985?
Oh, is that Texas?
Oh, Texas did it in 1985. Do you know what bill number that was?
I don't remember the bill number, but I do have the Attorney General and Secretary of State's opinions here.
Well, I'm glad you bring them up because we're going to go there next. But in 1985, members, the Texas legislature enacted, they did things differently back then. Some of y'all were here. Senate Bill 1, which overhauled the state's election laws. It was Senate Bill 1, and Texas led the way. You said the next state to stand up and say no.
That's
But
right.
in 1985, I think we're the same age. So you and I were 1 year old. 1 year olds. You were 2.
2.
All right. You're a little bit older. We were learning to read, so maybe we missed that bill in 1985. But in 1985, Senate Bill 1 passed, and it banned ranked choice voting in Texas. So we wouldn't be
Apparently
the
not.
next state. We would be redundantly big government redoing the same thing.
Well, you would think so, but we've got
Well-
cities like Austin and others that
Do they do it?
they want to do it.
Oh, sure.
They're trying to do it, and so
There was a good bill this session,
yeah.
which I supported, that calls on changing daylight savings time
Yeah.
to permanent. We want to do it. I want to do it. I'm a joint author. We're not allowed to do it.
Well, we're not
So
allowed to do a
Austin
lot of
wants
things
to
that
do
our
it,
cities do.
but they're not allowed to do
and they'll
it.
pass ordinances to do it. For example,
Has Austin done it?
the city of Denton passed an ordinance freeing the weed. It's against federal law. It's against state law. But the city of Denton did it. Now they've repealed that. They've come to their senses and they've repealed that.
Has Austin
So we
done
want
it?
to be explicitly clear in our law, which is what this bill does. We are
So-
explicitly clear. I'm sorry, I'm still answering your question.
Which
we want to
question are
be
you answering?
explicitly clear in our law to define what this means. When we say a majority vote, that means that a majority of voters are going to pick who wins an election, not based on some complicated system.
So, yes or no, since you're going to answer the questions. Yes or no, has Austin done it? Have they held an election through ranked choice voting?
Not advised.
Wow. It's a hard Google search. I use chat, though. Let me ask you this. In 2001, the Secretary of State issued an opinion stating that 1985 law does not allow for ranked choice voting. Is that correct?
Not advised.
Can I ask you a question? You were going to reference the Secretary of State opinion earlier. What year was that from?
Not advised.
The one you wanted to reference, you're not advised of anymore?
Not advised.
That's fascinating. So you want to pass a law to ban something we banned in 1985, and multiple times Secretary of State has reaffirmed.
I appreciate your support on this bill.
Is that yes or no?
Well, what this bill does is it clarifies in the code what this is, because it's not clarified in the code. It does say that you have to get a majority vote, but it doesn't actually define what ranked choice voting is. This bill defines what ranked choice voting is and makes sure that our elected officials will be approved by a majority of voters.
So the legislature in 85 and then Secretary of State in 2001 and 2003, they're all confused. So we got to pass more big government legislation to make sure they're not confused.
I'm sure you understand that despite our current Secretary of State being
Thank
a
you, Mr.
former legislator, The Secretary of State doesn't actually pass bills. That's up for
Mr.
this
Speaker.
body.
Ms. Rhodes, for what purpose?
Will Mr. Patterson yield for a question?
Not at this time. I'm sure that Mr. Busey is
Not at
aware,
this time.
just to finish the answer to this question, that the Secretary of State actually doesn't pass laws in the state. That's what the House and the Texas Senate do. And so that's what we're going to do with this bill is we're going to pass laws. Look, I don't know what y'all dream up, this gobbledygook that folks on the left want to dream up at night about how to make our elections less complicated or more complicated. We're here to make them less
And we
complicated.
don't know why you would have to sit up there and be a jerk, because that's what you're
Oh, I
doing
was just
right
re-
now.
I was just repeating the
That
last
is what
speaker.
you're doing. You're not.
I was repeating the last speaker.
Ms. Rhodes, for what purpose?
Will Mr. Patterson yield for a question?
Will the gentleman yield for questions?
I'd be happy to.
The gentleman
Mr.
yields.
Patterson, in your remarks, you addressed or you made a comment about the national organization, National Association of. You got me so upset.
NAACP.
I can't even get it out. You got me so frustrated. But you made a comment about them. Could you please elaborate and state that comment again?
Yes, I'd love to. In fact, I'll read the entire article here. It says the head of the NAACP in New York slammed the new ranked choice voting system as, quote, voter suppression while calling for an overhaul of the bumbling New York City Board of Elections. Quote, ranked choice voting is not beneficial to minorities. It's, quote, voter suppression. Hazel Dukes, president of the NYS chapter of
Please,
the
wait a minute. Ms.
NAACP,
Dukes
said
recently
Thursday in a
passed,
phone
so
interview.
please don't be derogatory toward Ms. Hazel Dukes, who was an icon. Please do not address her in this comment. Please don't.
I'm just simply reading an article that they are quoted multiple times talking about how ranked choice voting screwed up this election. This is an article. I'll share it with you if you want to come down. I'll even give you a copy of it. I have multiple articles here where it talks about how voters in New York viewed it as against their civil rights.
Okay, but Mr. Patterson, you're addressing things that happen in New York. What is going on in Texas that makes you feel that this bill is necessary?
Well, we don't have a proper definition of ranked choice voting in our laws. And so that's what this bill does. It defines it and it makes sure that voters have the integrity, see the integrity of our elections, that we are going to elect people with a majority vote and that only a majority vote is going to win in our elections.
Is that not what happens now?
Well, you know, there's a lot of things that I think we take precautionary measures against, and there's folks that want to change laws or cities that want to enact their own ordinances that are against
But
federal and state
has
law.
that been done? I mean, usually when you bring legislation, you're trying to prevent a problem or you're trying to address a problem. But to me, it seems like you just, again, as they stated, always continue to try to suppress people from not being able to vote, making all these barriers that would stop people from voting. That's what voter suppression is. And that's what,
And that's what ranked choice voting is, and that's what they called it in New York because it's an incredibly complicated system, and we're not going to have that in Texas.
Mr. Speaker,
Mr. Tallarico, for what purpose?
I raise a point of order against further consideration of Senate Bill 310 under Rule 4, Section 32C2 on the grounds that the bill analysis is incorrect.
Please bring your point of order down front.
Point of order has been withdrawn. Mr. Patterson for motion.
Mr. Speaker, I move to postpone further consideration of SB 310 until Mr. Busey's birthday, June 26, 2025.
Members, you've heard the motion. Is there objection to chair? That's ordered. Chair lays out SB 1346. Clerk, read the bill.
SB 1346 by Hughes relating to prohibited sales to persons attempting to purchase all possible winning tickets to a lottery drawing.
Mr. Patterson.
This bill prohibits group purchases in the Texas lottery, trying to solicit or trying to purchase all numbers in the lottery to rig the game, and I move passage.
Question occurs on passage second, third reading. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 127 ayes, 1 nay. Senate Bill 1346 passed third reading. Chair lays out on second reading Senate Bill 2753. Clerk, read the bill.
SB 2753 by Hall relating to a study on the feasibility of integrating early voting by personal appearance and election day voting, including the manner in which election returns are processed and other related changes.
Ms. Isaac.
Thank you, Mr. Speaker. Members, Senate Bill 2753 requires the Secretary of State to conduct a study examining the changes necessary to simplify the process by instituting a single voting period and allowing the use of a single set of equipment, and there are amendments.
The following amendment. Clerk, read the amendment.
Amendment by Money.
Mr. Money.
This bill just restores it to the Senate version of the bill, so it's not a study; it's an implemented election bill. So I move adoption.
Following amendment to the amendment. Clerk will read the amendment to the amendment.
Amendment by Hayes.
Mr. Hayes.
Thank you, members. Earlier in this session, we passed Senate Bill 985. What? Is this the amendment to the amendment? Yes. Go. I'm amending this. Anyway, we passed Senate Bill 985. In that bill, we amended Section 420051C of the Election Code. The amendment to the amendment that's before you that Mr. Verdell has brought also amends that same section. This is what sorry, Mr. Money. We're trying to get the wording to be parallel. So my amendment just says, let's use the one we already adopted. It's on the governor's desk for signature right now. And so I would move adoption of the amendment to the amendment.
Mr. Hayes sends up an amendment to the amendment. The amendment to the amendment is acceptable to the author. The record vote. Clerk, ring the bell. It's Isaac voting aye. Busey voting aye. Have all members voted? Sheen voting aye. Turner voting aye. 115 ayes, 19 nays. The amendment to the amendment is adopted. The following amendment to the amendment. Clerk, read the amendment to the amendment.
Amendment by Isaac.
Ms. Isaac.
Thank you, Mr. Speaker. Members, this amendment just simply moves this act out 2 years, effective September 1st, 2027. I move adoption.
Ms. Isaac sends up an amendment to the amendment. It is acceptable to the author. Record vote. Clerk, ring the bell. Mr. Busey voting aye. Ms. Isaac voting aye. Mr. Sheen voting aye. Have all members voted? Have all members voted? 135 ayes, 4 nays. The amendment to the amendment is adopted. Ms. Isaac on the amended amendment. Mr. Money.
Move adoption.
Question occurs on the Money amendment. Record vote. Clerk, ring the bell. Mr. Busey voting aye. Mr. Shaheen voting aye. Ms. Isaac voting aye. Have all members voted? Have all members voted? 109 ayes, 26 nays. The amendment is adopted. Ms. Isaac to close on the bill.
Thank you, Mr. Speaker. Members, move passage.
Question occurs on passage, third reading, record vote. Clerk, ring the bell. Mr. Busey voting aye. Mr. Sheen voting aye. Have all members voted? Have all members voted? 118 ayes, 19 nays. Senate Bill 2753 passes the third reading. Chair lays out on second reading Senate Bill 2703. Clerk, read the bill.
SB 2703 by Creighton, relating the authority of a municipality or county to regulate condominiums.
Dr. Alverson.
Thank you, Mr. Speaker. Members, this piece of legislation is actually very, very straightforward. All it says is that condominiums are not subdivisions. And so what it does is it just says there's a chapter of code, Chapter 82, the Uniform Condominium Act. That is what cities and counties are supposed to follow in the approval process for a condominium, and do not follow other sections of code that are specific to single-family home subdivisions. And that is simply all it does.
Mr. Speaker,
Ms. Weiner, for what purpose?
will the gentleman yield for questions?
Gentleman yield for questions?
I yield for questions.
Gentleman yields for questions.
Representative Oliverson, is there anything in the Uniform Condominium Act that prevents developers from essentially building single-family homes under a condominium regime?
So, to my understanding, condominiums are not single-family home subdivisions. That is a single tract of land where you have private ownership of common areas, and sometimes they are attached, and sometimes they are detached, but it is essentially distinctly different from a subdivision, and all we're trying to do here is to make sure that they follow the applicable chapter and code that already exists. We're not adding to the code, we're not taking away from the code, we're just saying you have to follow the code.
So Representative Oliverson, I know there's a plain meaning of condominium that we understand, but unfortunately, I don't think that's how this chapter has been used necessarily. I've had county commissioners raise to me issues of quote-unquote condominium regimes that involve 2,000 square foot single-family homes, using it as a way to get around county setback requirements. Can you point to me what in the Uniform Condominium Act prevents that shared ownership from being a common space so that we couldn't do single-family homes?
What I can say, Representative, is that regardless of whether the units are attached or detached, condos complexes, condominium complexes are distinctly different from single-family home subdivisions. They have private roads. They do not have county or city roads going through them. There are certain size requirements based on how large could a privately held road be, and so they're distinct and they're different. And I don't have the whole code in front of me, so I can't read through every aspect of Chapter 82. But Chapter 82 is for condominiums, and Chapters 212, 232, and 242 are for subdivisions. And all we want is for condos to be treated like condos and subdivisions to be treated like subdivisions. That's all this bill does.
So Representative Oliverson, we have existing language in statute that you're amending around that says a local government can't treat a condominium regime different based on the actual physical buildings that are being constructed, correct?
Well, all it says in my bill is that it is that a municipality, and I think what you're talking about is part 2, it says a municipality or county may not require the preparation and submission for approval of a subdivision plat, which is not a condominium plat, in connection with the creation or alteration of a condominium under this chapter. So again, all this bill does is say condos follow Chapter 82, subdivisions follow other chapters of code.
So the plats that are required under the Uniform Condominium Act, who reviews those?
So those are reviewed by a licensed professional engineer.
Does anyone with the county review those?
They are filed with the county. They're not required to go through an approval process with the county.
So they're filed with the county clerk, correct?
As far as I know.
Are you aware of any county clerks that actually review those plats?
I'm not advised.
So Representative Oliverson, if someone was to file a plat that they were going to be building in the floodplain, is that something that would be caught through this process?
If the engineer reviewing the plat wanted to keep their license, yes, I would say so.
How would that be enforced?
Well, because again, there's a licensed professional engineer that has to review and approve all of these plats.
And again, how does that prevent this construction from going forward if there's a bad actor or a
Because
mistake?
that is part of the approval process, and these are all licensed individuals.
Representative Oliverson, you just acknowledged there is no approval process. These
There-
condominium plans are done by people hired by the developer and filed with the county. No one at the county approves
They are
those.
supposed to be neutral third-party reviewers, professional engineers who are licensed, who are held accountable by the state to follow certain requirements and guidelines, no different than any other license holder that would be required to follow certain guidelines under the state. There is a strong process in place for making sure that professional engineers are doing their job and not just passing shoddy plans on and shoddy plats without doing the proper review process. There's a whole chapter, Chapter 82, the Uniform Condominium Act, where all of these requirements are contained.
Representative Oliverson, does the word floodplain or flood appear in the Uniform Condominium Act?
I'm not advised.
I will represent to you that it does not. Will you
Okay.
take me at my word on that?
I would just simply say to you again, as I've said to you repeatedly, that when a licensed professional engineer has to sign their license and put their license on the line to approve these processes, that is a very good check and balance against building in a floodplain.
Representative Oliverson, is it also consistent with your understanding of the Uniform Condominium Act that these plats are mostly focused on the layout of the buildings and not the land itself?
I'm not advised.
Representative Oliverson, are you aware that filing as a condominium regime can be a way to get past mandatory county setback rules and lot frontage rules?
I have no idea, but I take issue with the use regime.
What language would you prefer?
These are typically developments, like any other type of development. These just happen to be condominium developments. I think the word regime is somewhat pejorative.
I would disagree, but I will endeavor to use a different one. Are you aware that using the Uniform Condominium Act to develop allows these developers to get around minimum county setbacks?
I think the Uniform Condominium Act, Chapter 82, is legislation that we have passed in the past in order to govern the process for site development for condominiums. It is inappropriate to use other sections of code that are not specific to condominiums to do things to require them to double plan, double plat, just because maybe we want to make them go through a subdivision process when they are not a subdivision.
So Representative Oliverson, our current county setback rules are in the subdivision rules, correct?
I'm not advised. All I know is that condominiums are supposed to follow Chapter 82, and subdivisions follow several separate sections of code. There are different requirements because they are different development types. And that is a conversation that we decided some time ago when both of these different chapters were created for different developments and different purposes.
Representative Oliverson, do you know when we passed the Uniform Condominium Act?
I do not.
We passed it in 1993, I believe.
Awesome. Oh, I'm sorry, Chairman Bell is shaking his head no behind you.
95, Representative Bell? Maybe that's when it was last majorly amended that I was looking at. Huh? 94. Sorry,
94.
I
That was
bet-
a good year. I graduated from college.
I
that
bet
year.
on not an even year, but I guess that was a rough year for the legislators.
I think Bush's first album came out that year.
Representative Oliverson, what I am asking here is, do you think circumstances on the ground may have changed a little since 1993?
I think if that was a bill you wanted to file to amend Chapter 82 of the Uniform Condominium Act, then that is a bill for that purpose. All I'm seeking to do is make sure that cities and counties aren't inappropriately applying subdivision platting requirements to condominiums. The legislature is very clear, the statute is very clear about which goes in which.
The statute does not currently prohibit that platting. That is what you are attempting to do right now.
Because we have a separate chapter of code specific to condominiums.
And they're currently required to follow other county rules and city rules for that matter. Now, Representative Alderson, we have seen explosive growth in counties outside of city limits in the past decade, have we not?
I'm sure we have.
So Representative Alderson, is part of the reason you're filing this bill is because now we're seeing this type of development in the unincorporated areas of counties that we used to mostly see in
I think
cities?
the main purpose of this legislation is to ensure that condominiums maintain a certain level of affordability in your community and mine, and don't become just as expensive as single-family homes because of an egregious site development process.
It's fairly unaffordable if your home's destroyed by a flood, is it not?
I think that's what insurance is for, but you know, floods hit single-family homes the same as they do other types of developments.
The gentleman's time has expired. Following amendment, clerk will read the amendment.
Amendment by Zwiener.
Chair recognizes Ms. Weiner.
Thank you, Mr. Speaker, members. I understand Representative Oliverson's attempt to try and reduce duplication. The bill applies to both municipalities and counties. I understand where he's coming from with municipalities because municipalities do have rules like zoning, like impact fees, like building codes that they can enforce and keep an eye on building to make sure it is done in a safe way that makes sense for the site. Unfortunately, counties do not have those same tools. Members, I'm going to read to you a message I received from one of my Republican county commissioners from Hayes County. SB 2703. This is a clear effort to minimize the ability for counties to manage growth in their areas in an effective way. This provision would allow for condo subdivisions without calling it a subdivision, and the implications of the legislation are substantial. For example, there is one development in Hayes County which contains 35 homes, each freestanding with an average square footage over 2,000 feet, clearly a neighborhood community. This neighborhood was established as a condo to try and circumvent local authority and inhibit the ability of local government to require setbacks, adequate water and sewage requirements, and locally recognized standards. Local elected officials continue to see issues with the designations contemplated by this bill and with bad actors. For example, in Hayes County, one developer has multiple times created warehouse districts with tens of thousands of square feet and neither noticed the county for permitting of septic or the sale or conversion to a condo, and never shared the information at the inception of the development. He never got driveway permits, septic permits, or fire marshal permits, claiming as a condo, none were needed. The buildings were then sold, and when issues then arose, the eventual owners were forced to deal with non-compliance, and the developer was long gone. This legislation gives cover to these bad actors. Members, this bill, as currently written, is setting our counties up for bad actors to use the Uniform Condo Act to hijack around rules like setback requirements and minimum lot frontages, things that this legislature, this session already, has fought to protect. My amendment takes the bill down just to municipalities, meets the author's stated requirement of trying to remove duplication, but it protects the county's ability to do the work they are doing right now, making sure septic is in compliance, making sure that we have setbacks and minimum lot frontage, making sure that we're not building in floodplains, and making sure that we are meeting minimum fire standards. I urge y'all to support this amendment so that our fast growth areas have the tools they need to manage growth without having a get-out-of-jail-free card by raising their hand and claiming condo.
Mr. Speaker,
Mr. Romero, for what purpose?
does the gentlelady yield for questions?
Gentlelady for questions?
I do.
She yields for questions.
Representative Zwiener, so what you're saying is that there could be conditions where if there was an actor that wanted to build in the floodplain, You want minimum standards for that future buyer.
I want minimum standards for those future buyers. I don't want them to be left holding a mess.
And if you have somebody that lives in the country, that moved out to the county because they like the peaceful life, and somebody decides that they want to build something next door, that they don't just pack them in like a matchbox with the setback requirements. I think that's what you're describing when you say setback. Some folks don't know what that means. That could mean the setback from the front of the street, from the front of that county road, minimizing your ability to view and see around a curve. It also is a setback requirements between home to home, or in this case, condominiums, which some folks say, well, that's even closer together. But that certainly is not what folks are used to seeing. So is this just as much about protecting the country life that people are used to seeing when they move out to the county?
I think that's one factor, but it's also about these areas where we are seeing urban level growth in the county. And that might make sense, and it often does make sense, but we still need some of those base protections, those setbacks, like you said, making sure that we don't have homes pushed right up to the street, causing safety issues, making it hard for school buses to operate, making sure that we have good fire standards so that people have a safe egress out of the development. All of those things are critical to protecting our communities. And quite frankly, the Uniform Condominium Act is getting misused, and this legislation makes it easier for it to be misused and is going to ramp up that misuse.
I was really alarmed. I was just trying to read the bill. I'm sorry I got here late, but when I heard the author say that that's what property insurance was for, or flood insurance was for in the floodplain, I think the reality is some folks won't be able to get that insurance because they've built in the floodplain, and they will have no recourse on how to repair their home, especially if they were in a drastic flood. So thank you for your amendment.
Yeah, thank you, Representative Romero.
Ms. Jones, for what purpose?
Yes, does the gentlelady yield?
Gentlelady yield for questions?
I do.
She yields for questions.
So, do you realize that Hayes County is not the only place where they have these issues? Did you know that?
Absolutely. This is a statewide bill, and it is going to protect all of us.
And I know back
to take this amendment.
When I was on city council, we had the same problem with people trying to increase density of homes. So for example, in my neighborhood, where we had big lots for the inner city and we had big yards, some developers came in and bought some homes, and then they tried to create condos and put like 8 units where there used to be one house. And do you realize that when you replace that grass with concrete, that increases flooding?
In getting rid of impervious cover can increase flooding, and that's actually one of my concerns. We've got to have the county looking at impervious cover.
And you also realize that if you have single-family dwelling and then you put up 8 dwellings, 8 condos, that the piping under the ground has to accommodate the now 8 families. So what happens is your toilets flush slower, and everyone's water has less pressure because the lot wasn't, I guess, designed to have 8 units where there was only 1. You realize they have those kind of problems as well?
Yeah, there are a lot more infrastructure needs, and I am not opposed to density. This amendment is not about opposing density. This amendment is about making sure there's adequate planning going into development, whether it's dense or whether it's putting the word condo on it, but is single-family 2,000 square foot homes.
Except that the people that have bought in these areas, they bought for a certain quality of life, i.e. big yards, kids can run and play, and not to have a lot of traffic. So where there was maybe 2 cars from a single-family dwelling, now you've got 8 cars in those where you got to have extra special skills to be able to back in those small spaces, and they have insufficient parking a lot of times.
Yeah, transportation needs are a huge concern, and that's one of the big concerns for making sure the county can be engaged in planning.
Which is why local municipalities need to be able to do planning for their neighborhoods. They know what's best, and the people that own the property, where these interlopers, these new people are trying to come in and change the character of our neighborhoods, the people that are there first should have some protection against new people coming in and changing the character of their neighborhoods. Would you agree with that?
I think having a local community voice in planning of new development is always important.
And it's just basically a power grab from the state over local municipalities.
Yeah, thank you.
Thank you.
Members, this amendment is important to make sure that our counties have the tools they need to be able to manage growth. I will note that this bill is apparently targeted at counties like Williamson County that have been requiring plats for development. And again, the reason my county started requiring these plats for condominium developments is because people were skirting the rules. And so don't take away their ability to make sure that development is done smartly and wisely in our backyards. Members, I urge you to vote yes on this amendment.
Dr. Alverson in opposition.
Thank you, Mr. Speaker. Members, respectfully, the only thing this bill actually does is it requires counties and cities to follow existing state law regarding the platting and planning of condominiums and to not treat, yes, I
Mr.
yield
Bell,
for
for what
questions.
purpose?
Questions.
Gentleman yields for questions?
I do.
He yields for questions.
Yes. Dr. Oliverson, would it surprise you to know that Chapter 82 has worked very well for condominiums since it was put in, apparently in 83, but we actually formally started using that as a statute January 1, 1994?
That would not surprise me, Representative, because condominiums have been an exceptionally good means of affordable housing in many communities around this state for as long as since I was a kid. So, I mean, that's tracking.
Have we had any problems in this state with counties basically creating, as we heard just a few minutes ago, their own opinion over where they should be able to apply statute or their own ordinances over statute? Because Chapter 82, I believe, is statute, is it not?
Absolutely. And Representative, I would just say that respectfully, and you know this as well, we've been working on this for years. Cities and counties are notorious for implementing duplicative and unnecessary restrictions on site development that end up increasing the cost of housing in our communities, and that is a regressive tax and disproportionately affects people who can least afford to be priced out of a house.
And your bill, as I understand it, this amendment would cause it to move from making certain that counties and cities maintain their statutory obligation. It would strike that and move it, basically it would effectively move these condominiums out from under 82 and over into 242 and the other codes that govern.
That's my understanding. It would continue the abusive practice of having these condominiums basically go through the process twice, once as a condo complex and a second time as a single family home subdivision, which they are never designed to be. And it's expensive, it's time consuming, and as you know, in site development, extra costs and extra time for the developer prices people out of homes.
It would actually codify what is an overreach on the part of those local governments.
It would.
So, well, I appreciate your bill, and I appreciate your opposition to this amendment. I'll be voting with you.
Thank you. Appreciate that, Chairman.
Ms. Gonzalez, for what purpose?
Does the gentleman yield?
Gentleman yield for questions.
Yes.
He yields for questions.
Representative Alverson, I know you do have good intentions with your bill. I know that you feel that it's just genuinely aligning what to make it consistent in the code. However, I think what Representative Zwiener has really talked about is that the code does not require what other areas of code require in counties like setbacks or floodplains and things like that. And could you at least recognize that for those of us who have this growth happening, there could be potentially a negative impact to not accepting her amendments?
Representative, what I will recognize is the fact that condominiums are not subdivisions.
I agree
you
with
cannot treat them as subdivisions, and you cannot take sections of local government code that are designed for subdivisions and lay those over top of requirements that condominiums are already required to follow under state law. And that is what is happening, and this amendment essentially codifies that. It goes in the opposite direction of what we're trying to do with this bill.
I agree with you that subdivisions are not condominiums, but the problem is that your layman definition does not align with what exists in code, and I think that's what we're anxious about. That the things that exist in code are very critical for those of us who have fast growth areas, and they are therefore absent and even now being erased by what you're trying to do with your bill. And I have a prediction that next session will come back and be like, oh my gosh, we do have a problem now because developers are using this loophole that will cause problems for those of us who have a lot of county areas.
So I do not believe that will be the case, but in the event that that is the case, you are describing a completely different bill than this bill. And so, that's a bridge that we can cross together if we come to that. But what I'm focused on now is I'm trying to get cities and counties to follow existing law, which some are not doing.
And I think the problem is that we've seen developers use the existing law as a loophole, and now you're creating making that loophole even bigger, and that's the concern and the need for the amendment.
So I don't see it as a loophole. I see it as that we have a section of code specific to these types of developments, and as long as they follow the code that is applicable, then they are following state law. And what I believe we are talking about here, and you can correct me if I'm wrong, is that instead of treating a horse as a horse, now we want to treat a horse as a zebra and make them double register and go through the process twice. And that's exactly what's happening. And it's pricing people in your district and mine out of home ownership.
I respectfully disagree. That is literally not what's happening, and we've heard stories of how these developers have used this loophole, and we're very anxious about how this could negatively impact our district. So I genuinely ask you to reconsider your position on this amendment, because I do think it'll have very harmful implications for those of us who have areas of fast growth in counties. Thank you.
Thank you.
Winner to close.
Thank you, Mr. Speaker. Members, I wish the world worked the way Representative Oliverson was saying it did. I wish that every single place that used the Uniform Condominium Act was something we all recognized as a condo and agreed should be under those rules. Unfortunately, that is not what we are seeing happen on the ground. And if we want to protect minimum setbacks, if we want to protect minimum lot frontages, things this chamber has already gone to bat for this session, please vote yes on this amendment.
Record vote on the Zwiener amendment. Clerk, ring the bell. Show Alverson voting no. Mr. Romero voting aye. Have all members voted? Have all members voted? 75 ayes, 63 nays. The amendment is adopted. Dr. Alverson to close.
Move passage.
Question occurs on passage third reading. Record vote. Clerk, ring the bell. Mr. Romero voting no. Have all members voted? Have all members voted? Have all members voted? Have all members voted? 47 ayes, 91 nays, 2703 fails to pass. Chair lays out on second reading, Senate Bill 2221. Clerk, read the bill.
SB 2221 by Parker, relating to filing of the fraudulent financing statement in relation to certain secured transactions, authorizing the imposition
Mr. Lambert.
of a fee.
Thank you, Mr. Speaker. Members, over the last few years, there's been an increase in fraudulent UCC filings. Unfortunately, Texas does not have a simple process to remove these fraudulent filings. The only option currently available is to file a civil suit, which can be time-consuming and costly. Senate Bill 2221 creates an administrative process through the Secretary of State's office to determine and terminate these fraudulent filings. I do have an amendment.
Following amendment, clerk, read the amendment.
Amendment by Lambert.
Mr. Lambert.
This amendment was requested by the Secretary of State's office and simply changes financing statement to termination statement. Move adoption.
Mr. Lambert sends an amendment. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 129 ayes, 0 nays. The amendment's adopted. Mr. Lambert to Mr. Lambert to close.
Thank you, Mr. Speaker. Move passage.
Question occurs on passage third reading. All those in favor say aye. All those opposed say nay. Ayes have it. Senate Bill 2221 passes to third reading. Chair lays out on second reading Senate Bill 1719. Clerk, read the bill.
SB 1719 by Hughes, relating to the rulemaking power of the Texas Supreme Court.
Mr. Smithy.
Mr. Speaker, this bill just amends the government code to say that the Supreme Court can't overrule a statute that we pass. I would move passage.
Question occurs on passage third reading. All those in favor say aye. All those opposed say nay. Ayes have it. Record vote's been requested. Clerk, ring the bell. Mr. Little voting aye. Have all members voted? Have all members voted? 89 ayes, 48 nays, 1719 passes third reading. Chair lays out on second reading Senate Bill 2177. Clerk, read the bill.
SB 2177 by Hagan B, relating to the creation of a grant program to assist local law enforcement agencies in solving violent and sexual offenses.
Mr. Little.
Thank you, Mr. Speaker. Members, this bill creates a grant program through the Criminal Justice Division of the Office of the Governor. It's designed to increase clearance rates on violent sexual offenses, improve technology, personnel, and investigative resources for law enforcement, and I move passage.
Question occurs on passage third reading. All those in favor say aye. All those opposed say nay. Ayes have it. Senate Bill 2177 passed third reading. Members, the Speaker's desk is clear. There will be a record vote with strict enforcement on the adjournment. Mr. Wilson moves the House adjourn until 10 a.m. Tuesday in memory of Captain Ernesto Blanco and Major General Harold Green, both killed in action in Afghanistan. A record vote has been requested with strict enforcement. The clerk will ring the bell. Have all members voted? Have all members voted? 98 ayes, 31 nays. The House stands adjourned.